But Monday it will become infructuous. Keep the matter on Monday. I appeal to your
It's
lordship.
appearing in the list.
It is, I have filed pursuant to lordship direction, I have filed it.
Give the number.
All the identical one order will cover
Top it either.
top.
No, I'm seeking your lordship's kind leave, my lord, to obtain my lord number and give it to your lordship, my lord. The cause of action is materializing on the 19th. In terms of your lordship's previous order, my lord, the appeal was heard under the Highways Act. Thereafter, my lordship felt that, my lord, the other coordinate bench has, my lord, restrict.
File it, Mr. Bhattacharya, give the number.
My lord, I'll give the number, my lord, and it will appear, my lord, any day convenient to your lordship.
Number upgrade.
Monday or Tuesday, any day convenient to you.
My lord, in a compelling situation, I am mentioning, my lord, yesterday this matter was released by courtroom number 14, my lord, inadvertently filed there. This is related to, my lord, the permission for Durga Puja.
Oh, it top it. It will appear on the top whenever the file comes, either Monday or Tuesday.
Monday, my lord, Friday or...
If the file comes, yes.
I will try, my lord.
Call on the list.
My lord, under compelling circumstances, my lord, I am mentioning, my lord, the petitioner before your lordship is a 14 years old
Extension
minor
of
child.
interim
Who
order.
is a
Item 1.
14-year-old action. 14-year-old.
14 years old minor child who is a victim of rape and is 16 weeks
Hand over
pregnant.
top it.
My lord, can I come back at 2 p.m., my lord?
No.
Monday. I shall serve notes.
My lord, TRT 2 is not functioning.
Matter, lordship, that situation is, lordship, the petitioner is a tenant. And he was evicted from the property, lordship. Then after Honorable High Court decide that he have to restore, he will be restored, lordship. Subsequently, he restored. Now, what is his facing, lordship? Electric connection has been disconnected and I'm praying for face electric connection, but I'm not getting it, lordship. I am running a bank.
File it, give the number, it upgrade.
My lord, DRT 2 is functioning and e-auction is scheduled to be held on and from 11:30.
Hand over.
Well, your lordship, under very compelling circumstances, I have to mention this, your lordship, the vehicle of the petitioner has been seized illegally by the recovery agents. And now they are threatening him that the vehicle shall be sold off. And
No, ma'am, sorry.
Your lordship, may I point out petition, the monthly list item number 120. There is the urgency, your lordship. There is the petitioner as the hawkers of the situated in the surroundings of the Chandannagar railway station. Now, Chandannagar railway station authorities have issued the notice to evict the premises without following the due process law.
It's appearing in the list.
In monthly list item number 120.
Give the number, it will appear at the top on Monday.
This matter, lordship, listed today is item number 60, lordship. And this matter is relating to CSC and Justice Talukdar Committee. Anytime CSC can disconnect. We are the shop owners.
Sorry, no.
Lordship, may I be permitted to mention, your lordship, this is a writ petition. This is a writ petition, your lordship. The petitioner's hard-earned money is stuck in the bank accounts on no fault of the petitioners. Due to the actions of the respondent number 2, your lordship, I was praying if it could be taken up on Monday or any date after that, lordship.
Call on the list.
Just one. This is an original set matter. Do I mention it?
When the original set matters are taken up, Mr. Vasu, please then mention. Please.
Extension of interim order, item 1.
I am for the petitioner, my lord.
When is it expiring?
My lord, 16th, my lord.
The interim order granted earlier is extended till December 22, 2023 or until further order, whichever is earlier. The matter shall be listed on November 20, 2023.
May I just indicate, my lord, on the last occasion, my lord, though the respondents were not present, but my lord, the time to file affidavit in opposition was extended.
If they don't file, they choose not to file. We will consider that on 20th. Yes.
Item 2, extension of interim order.
When is it expiring, Mr. Mahathir?
Till 19th.
9th it has expired. The interim order granted earlier is extended till December 22, 2023 or until further order, whichever is earlier. The matter shall be placed on the list on November 22, 2023.
Top item, item 3.
Passover Korako, Ele Tokunda, Porter.
My lord, I am appearing on behalf of the petitioner in item number 3. I am led by Mr. Kishore Datta.
Oh, no, Mr. Tiwari, take it. Yes.
Apologize, my lord.
No, it's all right. Yes. Mr. Trivedi, you are appealing for the ED in this matter.
Only enforcement director.
Lordship, I am for respondent number 17 actually.
Yes.
My lord, as far as yesterday, my lord, I made my submission. I said I am adopting whatever has been said by Mr. Bhattacharya, my learned counterpart, my lord.
Right.
I will not bother, my lord, with regard to all those issues, my lord, whatever were raised.
Which respondent number are you, Mr.
My lord, I am respondent number 4.
4? Very well. যদি সাইট করে তখন ফাইল হবে যদি সাইট করে yes please. Are you going to cite any judgments?
My lord, I am just going to cite one judgment that has relevance because
yes
just, my lord, because of the reason, my lord. My lord,
Yes, no, don't have to give reasons for
written
citing. Yes.
instructions, my lord.
Hmm.
My written instructions are, my lord, we had basically asked certain questions to my client regarding the statements which have been made categorically in, my lord, that tabular form, that 12 page number 13, which starts at, my lord. Page 13, my lord.
Yes.
My lord, here are all the news details which have been quoted by the petitioner, my lord, where it has been said that it has been blown out of proportion and it is baseless and it has no relevance whatever to the truth, my lord. Now, my lord, why I am perturbed is that, my lord, if my lord kindly comes to page 30.
Mr. Trivedi, before proceeding, just tell me whether the petitioner is an accused in any of your cases.
My lord, he is a suspect.
As of date.
He is a suspect.
She
Is also a
we
suspect.
were not concerned with you.
She is also a suspect, my lord. As far as 3 cases are concerned, now, my lord, we are investigating. And when a suspect is there, my lord, he may be a witness. If on investigation we find, because there are a lot of things, my lord, we are asking for papers, we are asking for documents, and then under the PMLA Act, my lord, under section 50, whatever statement the person gives is akin to giving evidence before a civil court. So that has that particular implication. So, my lord, whatever they state, my lord,
That review is pending before the Supreme Court, Mr. Trivedi.
my lord,
That review is pending, that you have to give reasons for arrest.
my lord,
A review was filed.
my lord, review. We have, my lord, we are going.
No, I'm not insinuating anything. I mean, that is pending still.
My lord, my lord, never insinuate.
No,
my lord,
it's pending.
my lord, I have to take instruction.
My lord, there is a judgment which has been delivered by the Honorable Supreme Court about 4-5 months back.
That says reasons have to be given.
Sentil's
But a
judgment.
review application has been filed. I saw it on the
Yes,
somewhere live law. or something.
Judgment is there, my lord.
But Sentil is still
Still
holding the
prevailing, my lord.
field.
It's holding the fort.
Anyway, yes, Mr. Trivedi.
My lord, I am not on, my lord,
No, I'm wanting to know what are the repercussions. I mean, what relationship is there at present between you and
we
the
have reasons to
petition.
be, if we have reasons
She's a
to,
suspect at best.
my lord, suspect, my lord, we are investigating, and if we have reasons to believe,
Right.
we are empowered under the Act itself, but
Yes,
we have to
yes.
give reasons to believe, my lord.
Right.
So PMLA Act, my lord, I'm not amplifying on that.
Did not. Yes.
Now, my lord, what I'm trying to impress upon my lord very humbly, my lord. Now, my lord, if my lord kindly comes to page 30, paragraph 13. Basic one,
Yes.
10 minutes maximum. My lord, will kindly see paragraph 13, my lord. All the aforesaid stories, articles, news reports claim that the source of their information is respondent number 4 being investigating agency. Now, my lord, in my respectful summary, this is ridiculous, my lord, because what has happened, my lord, we had actually given all these things and we had asked certain questions. What we have got specific answers, my lord, as far as A is concerned, these things, my lord, what we have said then, my lord, because what happens as far as news media is concerned, my lord, it has been said, my lord, that we focus on positive work done by the organization when we give any news briefing. And all those news briefings are there on our website. Right from the very
These
beginning.
briefings, Mr. Trivedi, do you refer to any particular investigation?
No, my lord. Press releases we give about, my lord, I'm just, whatever, verbatim I'm reading, my lord, what I have got.
Very.
With regard to the press releases.
Positive?
My lord, the focus of positive, my lord, I'll hand over this, my lord, because it has come. The focus on the positive work done by the organization and to build confidence with the public, with due care, information are put on the website of ED only after actions are completed. Further, only those facts are shared with due caution, which may not impede and jeopardize the interest of the ongoing investigation / action. no opinionated or judgmental statements are made by the Enforcement Directorate generally against any person. This is, my lord, which we are vouching for, which we do, my lord. Now, my lord, will kindly see, they have said in paragraph 13 that all the informations which have been mentioned in that particular columns we have been the source of that, as far as this is concerned, my lord. Now, my lord, will kindly see how can we be source of this particular information. And my lord, before going into the details, my lord, it can be verified from our website. Whatever press release we are giving, it is on line, my lord, anybody can verify. So, my lord, we need not vouch for what we have said because that is all crystal clear and transparent. Now, my lord, we'll see. My lord, will kindly come to page 23, my lord.
Page or paragraph?
My lord, page 22, my lord. My lord, will start from page 21. My lord, I will not read it online, but I will pray, my lord reads it. My lord, column number 8.
Yes.
My lord, will kindly see nature of allegation. Last few lines. My lord, we are not gossip magazines.
No.
That we can be attributed to making these statements on ED website. My lord, how callous they are. Are we a gossip magazine? That we even if, my lord, and what allegations are being made in a casual manner against an ACE agency, that all these information were given by us. Now, my lord, I don't want to go online again because it will be not right on my part to make such statements with regard to whoever has affirmed this affidavit or drafted this petition. My lord, serious allegations should not be made in a casual manner, and specifically before an honorable court of law, because it has larger ramification. Once we are fighting for the championing for the cause of media being callous about making statements, we are doing the same thing. Of course, it is within the four corners of this honorable court, but not now. I am cautious. I am not making statement on the mic. Tomorrow, if I say this, my lord may see it in tomorrow's newspaper. So, my lord, this is what I'm trying to impress very humbly before my lord, that while making allegations against the ACE agency, my lord, we cannot be at the receiving end. My lord, until, my lord, lions know how to write, hunter's story will be glorified.
Who are the hunters? Who are the...
My lord, the media and the people, maybe the accused to a certain extent. They can come and they can make any allegation against the agency.
One other thing. Do you submit? I mean, I ask you this specifically. That apart from these news briefings and press releases formally made or on your website, you have no knowledge of your officers releasing any other information?
No, my lord.
Can I record that?
Yes,
I mean, at least to your knowledge,
my lord, my lord, this was received by me because we had put in a series of
can I put in only before this formal news release and briefings?
My lord may have a look at it. My lord, my lord may have a look at it. My lord, it is instructions, my lord, on record on my WhatsApp. This is, my lord, with regard to we had faced certain questions, me and my learned junior, my lord, we have said, and this is what we have to say. And last is the judgment, my lord, which has been passed by the Honorable Supreme Court, my lord, which I am going to cite before my lord. My lord, what has happened, my lord? This is a question which is not only scintillating, but very important as to what about this larger ramification, which due to the self-proclaimed media persons, my lord. I am not, some media houses are there which they are respectable, they have their standards, and they vouch for whatever they say. But, my lord, what can be done with regard to people who are on YouTubes and they make their vartas being self-proclaimed? My lord, there's a very thin line. So, my lord, will kindly see this judgment, my lord. The previous judgment, my lord, has been referred to by my learned senior friend, my lord. That was People's Union Civil Liberties. That was reported in 1997, Volume 1, SCC 301. Now, my lord, this is the other matter under the same name. Now, my lord, will kindly see the two questions. My lord, will see this was decided in the last month of September and has been, my lord, made returnable in the second week of January 2024, asking rather the Union Ministry of Home Affairs to furnish guidelines to the amicus curiae with regard to this particular issue, which is also germane and before my lord for adjudication. Now, my lord will kindly see the first page, my lord, if my lord kindly takes up. My lord, the two questions.
Yes.
I'm just saying, sorry, I apologize. One line. My lord has got
One, two is
my lord, two is relevant for our case, my lord. The propriety and procedure of media briefing by police personnel. Now, my lord, what has happened? Now, my lord will kindly come to the second page, my lord. The first issue governing police encounters has since been dealt with in the judgment of the court dated 23rd of September 2014 in People's Union of Civil Liberties versus State of Maharashtra. So one goes, my lord. Now, the second issue, which is before my lord. The second issue pertains to the modalities to be followed by the police in conducting media briefing where a criminal investigation for an alleged offense is in progress. The issue assumes significance, particularly in the context of the manner in which media reportage takes place, particularly in crimes involving a degree of public element. Now, my lord, I will skip the other paragraphs. My lord.
This is the important point.
My lord, I apologize. My lord, will be at page 2. My lord, I will kindly come to paragraph 6.
Paragraph 6 is last.
My lord, we kindly last few lines. My lord, I'm coming on without wasting my lord's time. Paragraph 6, my lord. Then when it continues at page 3, my lord. May I read, my lord? The media, in pursuance to its fundamental right to the freedom of speech and expression, as well as the consumers of news, information, and ideas, have a right to disseminate and to receive fair and unbiased information. Criminal offenses and investigations into them by the law enforcement machineries involve significant element of public interest bearing upon the right to be informed and the right to know. Now, my lord. Now, my lord, will kindly come to page 7, paragraph 16. So, on this paragraph, page 7, my lord.
Yes.
My lord has got it. Paragraph 6. Now, my lord, an amicus curiae was appointed because of this particular issue, which was before their lordship, the honorable 3 judges bench of the honorable Supreme Court, my lord. Now, my lord, paragraph 16, my lord, the amicus curiae was appointed, my lord, for on all two, my lord, appropriate guidelines with regard to all these points, which are basically, my lord, from 1 to 8 are with regard to these things, which are before my lord. Now, my lord, paragraph 17 at page 8, my lord. The guidelines of the Union Ministry of Home Affairs were prepared over a decade ago on 1st April 2010. My lord has got it?
yes, yes.
Since then, with the upsurge in the reporting of crime, not only in the print media, but in the electronic and social media, it becomes extremely important that there should be a standard operating procedure which balances out the considerations which we have noted above. There can be no denying of the fact that the disclosure of an official version of the investigation would ensure against speculative crime reporting, which may be of disservice both to the public interest involved and the interest of the accused, prospective witness, as well as the victims and survivors of the crime. There is in that sense a need to have a uniform policy which can be adopted for nominating nodal officers who would be available to share the official version at the stage of investigation, consistent with the need to ensure that the disclosure itself does not derail the course of investigation. The nature of the disclosure cannot be uniform since it must depend upon the nature of the crime and the profile of the stakeholders, including victims, witnesses, and accused themselves. The age of the gender of the accused, as well as the victims, would have a significant bearing on the nature of the disclosure to be made. It is equally important to emphasize that the nature of disclosure which is made by the police in the course of media briefing should be objective in the nature and should not consist of subjective opinion prejudging the guilt of the accused. The guidelines must duly factor in the need to ensure that the disclosure does not result in a media trial so as to allow the prejudging of guilt of the accused. Media trials are liable to result in derailment of justice and impacting upon evidence which would be adduced and assessed by the adjudicating authorities. Bearing in mind, now, my lord, I may go through it, my lord, but I will not take much of, but my lord, what I am on, very pertinent, what I'm trying to impress upon, my lord, is the next page, my lord, at page 10, paragraph 21. Now, my lord, what the Honorable three judges bench of the Supreme Court has said that this exercise shall be completed by the union. Now, my lord, the first paragraph 20, my lord. The National Human Rights Commission, which has been represented by Ms. Shobha Gupta Council, has also prepared its response to the questionnaire, which are circulated by the amicus curiae. The view of the National Human Rights Commission shall also be duly taken into consideration. The exercise shall be completed by the Union Ministry of Home Affairs by 31st of December 2023. The Union Ministry of the Home Affairs shall furnish a copy of the guidelines to the amicus curiae, Mr. Gopal Sankaranarayanan, and to Ms. Shobha Gupta, Counsel of the National Human Rights Commission, list the proceedings on second week of January 2024.
So the Union Ministry of Home Affairs have been given time till 31st of December.
31st and the matter. So, my lord, as far as
So this is already in process as
Yes.
far as the investigative agency.
yes, investigate. So therefore, I'm trying to impress upon my lord, the Honorable Supreme Court is already in season of the matter with regard to please. Is already in season of the matter, my lord, and all these issues. My lord, because my lord, I will not champion for the cause that I know all the issues which have been raised before, my lord, because I missed the arguments which were forwarded.
This is correct as far as the investigative agencies are concerned.
Yes, my lord, I'm only on investigating.
Comprehensively being dealt with.
My lord, because I'm the investigating agency,
Yes,
I'm
yes,
only
absolutely.
concerned about myself, my lord.
Right.
And the allegation, bold allegation, without any substantiated cause, have been made in a blanket form, where, my lord, I have shown that those gossips also have been, my lord, we have been saddled with the responsibility that as if ED has percolated and circulated the gossips. And our whatever press releases we have made, my lord, are on record on our website, and we are very responsible for it, my lord, which I have stated once again, my lord. I would, my lord, I will pray before my lord to see, my lord, we have made a specific statement, my lord, with regard to answer C, my lord, which I have given, my lord. It's a,
The rest referred to C also.
yes, my
I've
lord.
seen.
C, my lord. So, my lord, that is what is on record stated by us, which I have reiterated before my lord by reading.
Please give a copy of this also to them. I mean, this you're written.
My lord,
because
my lord, this is my lord. I can speak, my lord.
No, this is your version, which Mr.
My lord,
Tripati-
then my lord will record it, my lord. I am stating it, my lord, on the mic, my lord will record it verbatim. That which we have said, my lord.
read out C.
My lord, I'm reading out because, my lord, this is a my client to and my lord, we are very cautious about it. My lord, may I read it, my lord?
Yes, memorize, Mr. Chaudhary. Just note the time, Mr. Chaudhary. Just note the time. Nowadays, I gathered that is being done. The time is noted and the YouTube is then
My
the
lord,
channel.
YouTube, yes, my lord. That time and YouTube
has to be
will-
noted.
yes, that will be. My lord, we have said, my lord, to focus on the positive work done by the organization and to build confidence with the public, with due care, information are put on the website of the Enforcement Directorate only after action is completed. Further, only those facts are shared with due caution, which may not impede and jeopardize the interest of the ongoing investigation / action. No opinionated or judgmental statements are made by the Enforcement Directorate generally against any person.
Very well. That is it. So this is the plinth of their media reportages.
My lord, and then paragraph 13, my lord, where, my lord, the allegation can be specifically stated, my lord, that they have been so callous that these things, my lord, this should be, my lord, reprimanded and deprecated, my lord, in my respectful submission. Because everywhere we are seeing, my lord, we are an investigating agency, my lord. My lord will see, my lord, our officers are also human beings, my lord. With limited resources, my lord, we are trying to make investigation to the best of our abilities. But, my lord, every day by media, by way of frivolous litigations, we have been dragged and aspersions are made against us, which I told, my lord, till lions know how to write, Hunter's story will be glorified. We being the investigating agencies, we are not allowed to write. We cannot say that, my lord, and we are very strong people, but they should understand that we also feel the pain. So, my lord, in my respectful submission, there should be a human aspect, and, my lord, no such unnecessary allegations should be made against the ACE agency, because this agency belongs to the entire India, and we should all be responsible for whatever our officers are doing. My lord, therefore, my lord, I pray, my lord, no interim order, whatever has been prayed against the enforcement directorate, my lord, because that may deter and, my lord, affect our investigation, my lord, which is to be completed by the 31st of December.
Mr. Trivedi, explain this to me. How can it deter your investigation? I appreciate the other arguments of yours. I mean, suppose some order is passed. I mean, how can it affect your investigation?
My lord,
If you are not allowed to make press releases.
With my understanding,
Transparency.
with my understanding, my lord, of the
Yes.
situation, my lord, I may be wrong, my lord, but my lord, why I am saying, my lord, this? In my lord, if my lord kindly takes up the prayers where they have prayed for interim order against us, and add interim form also.
Yes.
M na N.
M.
N do to yes.
M for Nagpur.
My lord, M is there and N is there.
M is not against. Oh, yes. M also.
Yes, my lord. M is there.
Yes, yes. M is also.
Add interim order directing the respondent to faithfully disclose on oath. My lord, this interim order, my lord, it is not, it is too much, my lord.
Yes.
So therefore, my lord, I am trying to impress upon my lord. Therefore, this interim order, my lord, this will deter, my lord. If I am to vouch and on bold allegations where gossips are also attributed to us, on bold gossips are being attributed. ED said about these gossips. I'm not going online.
The statement in para 13 is very curious. I mean, they say that all the aforesaid stories, articles claim
yes
that the source of information is you.
Now, my lord, even
don't say that you have
a prudent man, my lord, being a civil lawyer, my lord, from that, a prudent man should believe.
You're qualifying the lawyer with civil. So I'll take that on record.
I take back my words. I take back my word. My lord,
you're representing the ED now.
It is exuberance before my lord. My lord will not take me amiss. Sometimes, my lord, I get exuberant before my lord. So my lord will kindly not take me amiss.
So this will deter the investigation,
yes,
definitely.
My lord, that this will, and my lord, what I am trying to impress upon my lord even further, my lord, if my lord kindly comes to N. An ad interim order directing the respondent not to make any statement, genuine or otherwise, or voice, my lord, it is deterring our policy, my lord. Now, what is this, my lord? If for installing confidence in public, which I had against, my lord, I had made that submission. I mean, why do we make press releases? We have specifically said that, and we have, I being the person who is advocating for the cause of enforcement directorate, my lord, on record, I have gone that this is why we make press releases with these cautions. So, my lord, after that, my lord, M and N are not required, my lord. And that also because of the reason that they are making bold allegation again at the cost of repetition in paragraph 13 with regard to issues, my lord, which are there. Kon paragraph hai? Kon column mein chilo? Aur ek bar repeat karo.
21.
From page 21, my lord, those columns, my lord, just, I will not go on air again when, my lord, column 8, my lord. So a prudent man, my lord, of IQ, my lord, will never believe that an investigating agency will be interested in making these statements. I am not even going to that extent that everything is on my website. I'm not going on to that. But even what these we will disclose. And what
8, 9, 10, 11.
8, 9, 10, 11, everywhere, my lord. So now they have gone to that extent saying that all the aforesaid, now my lord will kindly see. So therefore, what had fallen from my lord, that they are saying it is they have learned from media houses, but my lord, they don't. All these people are very, very brainy people, my lord.
No, you
even the petitioner.
You deny that you have been disseminating, your officers have been disseminating information apart from the formal releases made by CPI. I'll have to record that also.
My lord, yes, my lord, that goes without saying, my lord. We are, my lord, the media publications are on their own accord, my lord. Apart from that,
that is, you are not responsible for the media.
The department does not share any information to any print or electronic media with regard to ongoing investigations, except what has been stated by me. With regard to that particular, my lord, the focus of positive work done by us. This is my qualifying.
Right.
That is how I qualify, my lord, my statement that why when we make press releases. The qualification is this, my lord, that we do not share any information to any print or electronic media with regard to the ongoing investigation, except whatever press releases we made. And that also, my lord, my lord has recorded it.
Mr. Trivedi, you and Mr. Bhattacharya are Deputy Solicitor Generals.
My lord.
What's your designation?
My lord, deputy.
Very well. I forget every time. Either I miss out the deputy or the additional. Thank you.
My lord,
This
because,
has
my lord,
nothing to do with the ED.
My lord, my lord, my lord, why this comes, my lord, because initially we were designated as Assistant Solicitor General, and then it
Yes,
was,
that's why I confused.
and then, my lord, because
It's
of
all
that
right. It's
abbreviation being
only Deputy Solicitor General, no additional, no
no.
assistant. Very
we
good.
are deputies.
Thank you so much.
So, my lord, this is what, my lord, what I am humbly saying, those cannot be. And, my lord, in view of this Honorable Supreme Court's order, which is still pending,
Yes,
my lord.
that is there.
So, my lord, that needs to be taken into consideration because we are in the phase of framing those guidelines, my lord. And I rest my arguments, my lord.
Lordship, I want to say before Mr. Dr.
Pray for dismissal of this particular. I apologize, my lord. We pray for dismissal, not only in light of whatever submission has been made by my learned counterpart, but also in view of this fact, the matter, same sort of matter is pending before the Honorable Supreme Court. And, my lord,
This matter,
no, my lord, as far as our that
this
aspect
People's
is,
Union for Liberty.
that aspect is concerned. And, my lord, also on the maintainability, which I have adopted the submission of my, at the very outset, my lord, I said that as far as maintainability is concerned, my lord, I have adopted the arguments made by my learned counterpart. So that may also be recorded.
reply
Mr. Chatterjee, what were you saying?
Lordship, yesterday, Lordship, I found chapters in a book called Free Speech. And journalism, particularly with one subchapter. I want to hand over that copy.
Have to hear. Whatever is, whatever comes, we'll have to take that.
Your lordship,
I will hand over it to you.
Already placing, in the process of placing.
did you
So let me hear whatever he's placing. Yes, Mr. Chatterjee, anything else?
He has left, concluded and left. No connection, your lordship. He is disconnected, your lordship. One judgment, your lordship, is very relevant for this
No
case.
further judgment now.
Your
You have
lordship,
already
Murta's
concluded your
argument,
arguments. No.
Some
You have concluded your
paragraph,
arguments. You
lordship,
cannot add up whenever you wish.
Lord, I'll be very brief.
Yes.
Lord, essentially on the judgments, my lord, which have been cited and the main, my lord, points argued. First is, my lord, I'll come to, my lord, the judgments placed today last. The first point argued, my lord,
Yes.
is that an action for defamation is an action to enforce a right in personam, and therefore only a suit for defamation is maintainable and the writ petition is not maintainable. This is, my lord, the first argument, my lord. Our answer to that is, we are, my lord, attempting to, my lord, have our fundamental rights enforced to the effect that, my lord, we should not be defamed by media trial, and, my lord, the rest of the matter, that enforcement agencies should not, my lord, leak information which should not be embellished further by the press, etc. This is not, my lord, a matter which comes within the domain of, my lord, a civil suit. It's not, my lord, enforcement of a right in personam, my lord, which, or, my lord, the remedy in personam, which, my lord, I am enforcing. It's, my lord, enforcement of fundamental rights for which, my lord, the writ petition is maintainable. The second point argued, my lord, is that the petitioner, being a foreign national, does not, my lord, enjoy fundamental rights, which is perhaps, my lord, contrary to the judgments of the Supreme Court, my lord.
Article 14 and 21 are
14 and
available to
21.
that's settled.
I will refer to, my lord, Chandrima Das. There is a further judgment. Let me not, my lord, multiply, or if your lordship permits me, because it's in reply to a specific argument.
Yes.
I will just, my lord, hand up Chandrima Das's judgment. Mr. Datta has already cited. My lord,
I think it was cited, yes.
yes, my lord, I must have gone out. I'm sorry, my lord.
Yes, 14,
So, my lord,
21
that's my reply to the point.
The third argument is, my lord, placed on the basis of 2023 4 SCC page 1. For the purpose of, my lord, contending that the petitioner and OCI card holder is not entitled to interfere in the internal or political affairs of the country. And for this, her OCI card is liable to be cancelled. It's, my lord, perhaps not correct in the facts of the case. I am not, my lord, interfering in any investigation or in the affairs of the country. I am filing the writ petition for enforcement of a fundamental right to prevent my reputation and my family's reputation from being infringed. So that's the essential difference, my lord. I am not here, my lord, to do something. I am to prevent you from speaking about me in the press and the press from speaking about me in the impugn manner. So, my lord, that's the distinction. Then, my lord, is 1994 Supplementary 1 SCC 615, where, my lord, I would, my lord, pray that your lordship looks at the judgment once. I'll just show one paragraph. 94 Supplementary 1 SCC 615. 94. Sir, kindly give me one moment.
No, it was cited. If it was cited, it must be the.
It was cited by my learned friends, my lord.
এটা কিন্তু পিটিশনার সাইড করেন
এটা ওনারা সাইড করেছেন।
পিটিশনার সাইড করেন পেয়েছো তো দাও
1994 Supplementary 1 SCC 615 State of Arunachal Pradesh.
এটা রেসপন্ডেন্টদের এতে পাবে রেসপন্ডেন্ট কম আছে
Para 35 and 75.
Mr. Chaudhary, give me the paragraphs and read out
35 and 75, I'll tell your lordship, my lord, what my essential distinction is. In respect of the state of Arunachal Pradesh and what was happening there, this question had come up before the Supreme Court. The concerned person, my lord, was trying to submit that my right, my lord, to move around all over the country cannot be curtailed. So there, my lord, Supreme Court said that you can't use Article 14 for the purpose of
19.
overriding Article 19.
Yes.
And, my lord, get this sort of an order. This, my lord, does not deal with 21. And this was a direct case where Article 19, my lord, was sought to be overridden by use of Article 14. In my case, I am saying that I am trying to enforce the restrictions contained, the reasonable restrictions contained in Article 19. So, my lord, this judgment has no manner of application. Paragraphs 35 and 75 of this judgment are, my lord, relevant for this distinction. From where your lordship would get this part of it, that 14 was being used, my lord, to override 19, which was held to be impermissible. Then, my lord, is the judgment, my lord, reported at 1962 volume 3 SCR 842 Sakal papers. What is important, my lord, is in paragraphs 35 to 37 of this judgment, it is recognized that freedom of speech and expression is not absolute and is subject to the law of contempt and defamation, which again takes us back to Mr. Dotto's opening submissions as to why this should not be permitted. So, my lord, it's not an absolute right or an absolute indemnity which, my lord, they enjoy. It comes back to, my lord, contempt and defamation, which is, my lord, what we are trying to suggest, my lord, is the barrier to them doing what they are doing. This is, my lord, essentially what was cited. Now, interesting is, my lord, the judgment of the order of the Supreme Court, my lord, placed today. Now, this is in People's Union for Civil Liberties and another versus State of Maharashtra. The order is, my lord.
This issue he's saying is in the process of being resolved.
Yes, my lord, The Supreme Court, my lord,
Is in
is
sitting.
deciding many matters, my lord. It's in the process of deciding many
So
issues.
this is on general terms. I mean, all over the country, it will be binding. ED operates all over the country.
Yes, yes. Is the, but when it comes,
That
my
will
lord, it will
definitely-
come.
If individual high courts put in their inputs, may be difficult.
That, my lord, when we, my lord, are able to obtain a judgment on a point of law, my lord, we are entitled to place it before the Supreme Court because it has, my lord, persuasive value. So it doesn't mean that nobody else can decide the matter. And, my lord, interim reliefs which we are asking for have to be, my lord, decided. And for that, your lordships have to, my lord, come to prima facie conclusions, which, my lord, even if they impinge upon this subject matter, my lord, there is, my lord, no bar. And on the other hand, I would say it's absolute necessity. A distinction may be drawn. Your lordship would recall, my lord, there was a land acquisition matter where, my lord, the Supreme Court had itself said that no high court will decide this point. So, my lord, all matters had stopped. That's not here.
So you are asking me to furnish the reason for the Supreme Court to do that in this matter also.
That I am only submitting, my lord. Your lordship
This
will.
is the reason Supreme Court has to do it. Because otherwise these things of generally anyway, it's not yet a decision. It has
It's
not
not a
ripened into
decision. And, my lord, what is important is that when I ask, I'm entitled to ask for interim relief.
Yes,
When
yes.
I'm asking for interim relief, your lordship will take a prima facie view this way or the other.
Right.
Now, important is, my lord, paragraph 17. These observations are, my lord, of very great importance. My lord, from paragraph 17, if I read out, there can be no denying the fact that the disclosure of an official version of the investigation would ensure against speculative crime reporting, which may be of a disservice both to the public interest involved and the interest of the accused, prospective witnesses, as well as victims and survivors of crime.
That's a part of the suggestion of the Supreme Court.
Yes. Then, my lord, on the next same paragraph on the next page, which is page 9, it is equally important to emphasize that the nature of the disclosure which is made by the police in the course of media briefings should be objective in nature and should not consist of a subjective opinion prejudging the guilt of the accused.
Underlined.
Underlined.
Already underlined.
That's, my lord, what I could hear.
That is the most important thing. Yes. Objective is one of the keywords. You are right.
My lord, my তুমি বলো kindly
Tell him up to which you submitted. I mean, otherwise he'll be repeating. Siddhartha will be repeating then.
And the only one sentence, if I may add, which Mr. Dotto didn't have the benefit of hearing today. Look, in the statement which my learned friend Mr. Trivedi read out, again, the instructions also say there should be no opinionated statement.
Yes, yes.
And, my lord, judgmental statement.
But who decides? That is in the previous sentence.
That I couldn't, my lord,
In the previous sentence, it's there. Who decides?
I couldn't copy that.
As per their
I couldn't copy that, my lord.
So they at their discretion will do that. But definitely that much has to be given to them.
Yes, because and the statement, my lord, which also, my lord, Mr. Dotto was not there. I will, my lord, request him to, my lord, consider, is that the stand which is now taken, that there has been nothing, my lord, fed to the press, is belied, my lord, by the statements in the press, that everything seems to be on the basis of what was indicated.
There is nothing specific, Mr. Chaudhary. I was going through the reports. Nothing specific. They generally refer to that this is all of those are unverified sources. Or some press releases are there.
No, there are some page numbers.
ED admittedly makes such certain press releases.
Yes.
So it can always be verified with that.
Yes, but my lord, if your lordship looks at the statements, in each article it says as per ED, and from the source of the ED, and then comes a statement. I may, my lord, if your lordship and my learned senior permits me, just show one or two.
Yes.
আমারটাই হারিয়ে গেল এর মধ্যে।
Most only respondent number 17 and 18 mostly.
Yes, they are, my lord, the most vicious. আমার রিটটা কোথায়? আমার সব লেখা আছে। Lord, I think page 77, if I'm not, my lord, mistaken.
of the writ petition.
One is, my lord, 94. No, I'm sorry, my
You are
lord, not-
mistaken.
Yes, I am mistaken. My lord, one is 94. The ED has also issued summons, the summoning to such and such. My lord, no, that's not the one. এটা কোনটা? 104. Yes, it is learned from the source of Enforcement Directorate that black money used to be investigated in the spurious company.
Where is this?
104.
10.
আগের দিনই ঘুরে গেছে।
Yes, yes.
Then, my lord, in the first few pages, yes, 79, my lord, once. My lord, third paragraph. Top sources in the customs department revealed the identity of the lady to my nation. She was Mamata Banerjee's nephew, Abhishek Banerjee's wife.
Customs is also a party here.
No, my lord,
Who else?
customs is not a party. Then, my lord, page 80. Second paragraph. According to CBI sources, Rujira,
Just CBI is a party here.
CBI is a party.
But CBI has not argued. ED argued.
CBI is a party. Only it is a party. I'm sorry.
ED is a party.
Then, Lord, Lord, what is happening? Page 80 is illegible. It says below second paragraph. According to CBI sources, Rujira is likely to be
CBI, which is not a
questioned.
party here.
Not a party. Then, my lord, page 93.
Show me something interesting about the ED.
Interesting about the ED.
Yes.
My lord, they are all interesting, my lord. Page 93.
News
my lord.
reports are saying that ED has said.
Yes, my lord, page 93.
Yes.
The ED has learned.
And the ED officer said that is the penultimate paragraph.
Yes, yes.
I marked that on the last.
ED has learned, has gathered from irrefutable evidence of huge sums of money suspected to be proceeds of the scam. All this can't be part of a press statement. Press statement is dispassionate.
This is Swarajya.
Yes, I am. Press statement, not as an example, should be I am investigating XYZ. These are summons issues, the procedural matters, not on the merits. My lord. Kindly grant leave to my learned senior, my lord. I'll be transgressing authority.
But so far as may I, my lord, address, my lord, on the ED's what should I say, action in regard to the, my lord, subject matter. My lord, one thing, my lord, has been told to the court by the ED that the ED issues these press releases. Another thing is that these press releases are in connection with ongoing investigation. Now, in respect of ongoing investigation, my lord, as my lord has been held by the Honorable Supreme Court, number one is that the investigating agency cannot disclose particulars of the investigation on which, my lord, I have, my lord, made submissions. And my lord, cited case laws also. The second is, once it goes to the press, then, my lord, it gets displayed everywhere. The effect is that the presumption of innocence is also, my lord, getting affected by this. My lord, kindly permit me, my lord, since, my lord, we are, my lord, with a case before your lordship, my lord, where, my lord, competing fundamental rights are in question. But kindly permit me, my lord, as an example or specimen, to hand up to the court, my lord, 2 press releases to demonstrate that, in fact, my lord, through these press releases, they are, in fact, my lord, trying to tell the people that X, Y, or Z.
Mr. Dotto, at this stage, I won't take any further document. I mean, I'll keep the matter pending. I am only considering interim orders. You may later on add this.
But may I only then read it, my lord, for your lordship's consideration?
I cannot take note of that, Mr. Whatever is there is annexed. I'll go by that.
Very well, my lord, the nature of the press release, kindly, my lord, note this submission of mine.
Yes.
The nature of the press releases are such that it, number one, my lord, it discloses the progress of the investigation, which cannot be done. And number two, my lord, hints at the persons who are allegedly found to have been committing some wrong, for which, my lord, investigation is being carried out. But these are, my lord, the nature of the press releases, which, my lord, in my very humble submission, will come, my lord, under the zone of prohibition, which the courts have, my lord, held, my lord, in various judgments, my lord, which I have shown to the court.
Although my junior is absent, and the court forms an adverse opinion of my research work, it is prejudicing. That is not permissible. Permissible to which level?
The press release says that we are investigating Kishore Datto in the recruitment scam case. This is disclosing a progress of investigation. Press releases say that XYZ company has been used for dubious transactions for which investigation is going on, and we have called X, Y, and Z.
It's a per se defamatory statement.
X, Y, and Z for questioning. But
That will also be opinionated
yes,
at the investigation stage.
yes.
But
But
it
these
is
are the-
saying they're not supposed to give opinions
Yes.
in their releases.
Yes. These are not the nature of the press releases. Where
Yes,
we,
yes, definitely.
where we ought to have not filed a supplementary affidavit with that. Be that as it may.
Anyway,
these are-
whatever is there.
Yes, yes. Be that as it may, your lordship would lay down the guidelines. Now, my lord, so far as, my lord, the entire submissions, my lord, which have been made, my lord, by the learned counsels for the respondent, my lord, the entire trend of, my lord, arguments in my very humble submissions are pinned towards civil rights. Someone has said, my lord, why they have not filed defamation. Mr. Bhattacharya has said that Specific Relief Act Section 41 creates a bar. Or there are other alternative forums, my lord, for the purpose of voicing my grievances. But my very respectful answer to, my lord, all these submissions are, number one, my lord, we have not come here to, my lord, enforce any civil right. We have come here to enforce a fundamental right. But here it's no claim for a fundamental right. Here it is a case for enforcement of fundamental right. But number three is, when, my lord, there are issues of competing fundamental rights. For example, my lord, someone is claiming 21, someone is claiming Article 19(1)(a). But my very respectful submission is, my lord, in that circumstances, balancing the fundamental rights is a constitutional necessity. But this, my lord, the Supreme Court has said, my lord, in Antule's case.
Yes.
Therefore, my lord, it is not a case where, my lord, people are, my lord, dilating before your lordship for, my lord, enforcement of any civil rights. Rather, my lord, in the words of the expressions of the Supreme Court, my lord, it is a constitutional necessity much, much, much above, my lord, somebody's other civil right. For example, say a right to property.
Yes.
For example, a right arising out of a contract. So, my lord, we cannot, my lord, relegate the issues, my lord, which has been canvassed before this honorable court to that of civil rights. But this is will be, my lord, one arm of, my lord, my respectful response to what has been submitted by my learned friends. But the second limb is that to ensure a fair trial, my lord, it has to start from the investigation stage itself. But the judgments have been placed before my lord, where, my lord, these various courts, my lord, have dealt with this issue, that in the or during the progress, you cannot come out with documents and informations and disseminate it amongst the public. Now, this is a concern, or to ensure a right to fair trial, apart from being, my lord, a limb of, my lord, Article 21, but by very respectful submissions, my lord, this is a concern of the court. This is a concern of the judiciary. But in this, my lord, type of a proceeding, my lord, to that extent, I mean, to ensure a fair trial, is almost in the status of an informant. Only on this issue. That right to fair trial will get infringed if there is unfettered right, or an unfettered right is given to the media to disseminate investigation process, collection of evidence, etc. This, my lord, the second limb of my argument is, my lord, here, my lord, it is a concern of the court, and I am more in the nature or in the status of an informant. When I enforce my right to privacy, my lord, I am enforcing it as a fundamental right. When I come before this court with the second limb of my complaint, that why everything is being disclosed before the public, here, my lord, I think, my lord, I am more in the nature of an informant before the court.
Why don't you find a pill then?
Yes. Now, so far as, my lord, filing a pill is concerned, my lord, there, my lord, a class of person who cannot come before the court by reason of poverty, a social backwardness, or other, my lord, impediments, restrictions, etc., then, my lord, I can vouch for them. But the issue, in my very respectful submission, the issue is definitely has a public interest in it. My lord, I cannot,
Has to be, yes.
I cannot say no. But in order to, my lord, espouse through a public interest litigation, I cannot have any interest. My lord, in fact, here I have some interest.
Yes. Right.
But this is the second aspect of the matter. But the third aspect of the matter is, my lord, so far as, my lord, the High Court's jurisdiction power under Article 215 is concerned. But the judgments may have been placed before, my lord, that High Court would exercise its inherent power under Article 215, impose restrictions to the extent possible under the Article 215. And what are these restrictions? These restrictions are in the nature of restrictions under Article 19(2). Very many things have been said that the press or the right of the press under Article 19(1)(a) can only be fettered, curtailed through a law under Article 19(2). The courts have held, I've already placed those judgments only for the purpose of giving response. I just only reiterate those. That under 215, the restrictions which the High Court would impose, or even the Supreme Court would impose, would be akin to, or would have the status of a law as contemplated under Article 19(2) of the Constitution. But these are, my lord, my three fundamental limbs of, my lord, response to the submissions made by my learned friends. But one submission has been made, or to a large extent, my lord, showing the various news reports or the media reports that there is no conclusion, and therefore I am not prejudiced. I mean the petitioner. But again, my lord, 7 judges Supreme Court bench has held that to enforce a fundamental right, you need not prove or even plead prejudice. For enforcing a fundamental right, my lord, prejudice is not the test. Therefore, my lord, saying before the court or reading in between lines and trying to interpret that this the so-called reports do not prejudice my rights, my lord, in my very humble submission, my lord, with utmost humility, my lord, is not the correct position of law. My lord, the next submission which has been made is that the Bombay case, 1920 Bombay, my lord, Mohandas Karamchand Gandhi's case. But here your lordship will find that the newspaper which had, my lord, quoted a letter of the registrar of a court, my lord, was held to be a contempt by all the three honorable judges, my lord, who comprise the bench. Therefore, if it is, my lord, again, it is of 1920, my lord, we did not have our constitution then or Article 215 then. But if it was held to be content, my lord, it has to be in today's, my lord, legal position or, my lord, the constitutional document, it has to have its connection and source from Article 215. And therefore, my lord, whatever are the powers of the court has laid down, my lord, by these judgments, my lord, are all squarely applicable, my lord, even, my lord, in the backdrop of, my lord, the 1920 Bombay High Court judgment. My lord, it has been submitted that, my lord, I have come for gag orders, my lord. I have, at the outset, my lord, I have said, my lord, it is not praying for a gag order. It is more to guide the press as to what they would do, my lord, during an ongoing investigation. So, my lord, I don't say that there has to be a complete ban of whatever is going on, my lord, in the investigation. My lord, Kaushal Kishore's case, my lord, has been cited before my lord. But Kaushal Kishore, my lord, in fact, my lord, helps my client. To the extent, my lord, if your lordship may kindly take, my lord, just note down the paragraph numbers. 12.2 and 83.
Right.
12.2, my lord, the question, my lord, has been framed as to whether fundamental rights can be enforced against bodies other than the state. My lord, the answer is, my lord, in the last two lines of, my lord, paragraph 83, that yes, fundamental rights under Article 19 and 21, both said in that two-line sentence. Fundamental rights under Article 19 and 21. 2023 4 SCC1. Fundamental rights under Article 19 and 21, my lord, can be enforced against against bodies other than state authorities. Now, my lord, page para 83 তে চলে আসছে। My lord, Shepherd versus Maxwell, my lord, again has been cited on the principle that a prejudice needs to be proved. That was not a case of fundamental right. I do not know, my lord, in America whether they have fundamental rights or not. But the last sentence at paragraph 83, I'll just read for your lordship. A fundamental right under Article 19/21 can be enforced even against persons other than the state or its instrumentality. But which the sentence squarely applies in our case. The other judgment which has been cited, that is 2013, volume 16 Supreme Court cases, page 82. But again, my lord, this is a judgment under the Right to Information Act. My lord, your lordship, kindly note down paragraph number 64. Where, my lord, in the context of Right to Information Act also, my lord, referring to section 881J of the Right to Information Act, my lord, right to privacy, my lord, has been recognized. So in other words, section the Right to Information Act, which according to me is the mechanism for Article 19(1)(a), again, my lord, protects right to privacy. This has been held by the Honorable Supreme Court. But the other submission has been made by Mr. Bhattacharya is that, my lord, we are seeking a negative enforcement of Article 19. But much submissions have been made by me, my lord. It is not a question of enforcing negatively. It is a question of, my lord, what is the expense? Or what are the extra privileges that a journalist enjoy? It has been said that a Privy Council said that journalists, my lord, do not enjoy any extra privilege than, my lord, ordinary people like us. Then, my lord, foreigners cannot curtail newspapers' rights. That is, my lord, an extension of that negative enforcement. Then, my lord, the submission was intra Article 19. that Article 19(1)(a) is higher than Article 19(1)(b). Not applicable. Then, my lord, the judgment of 1994 Supplementary 1 SCC 615 para 35 has been cited in regard to right to settle.
Yes. Sorry, yes.
Yes, in regard to, my lord, right of a foreigner to settle anywhere in India. So that is 94 Supplementary 1 SCC, but I don't think we are subject to correction by my lord, would require, my lord, consideration by this court in the facts and situation of this case. Then, my lord, AIR 1962 Supreme Court 305 paras 35 to 37 has been relied on the principle that Article 19(1)(a) can be curtailed only under Article 19(2), to which I have already, my lord, made my submission. And this is also, my lord, your lordship will find, my lord, from Sahara India's judgment, paragraphs 33 and 34, same thing. But the other submission which has been made by Mr. Bhattacharya is, my lord, that since, my lord, CBI and ED are central agencies, this is not the appropriate bench. My lord, in my very this submission has been made, my lord, I don't think, my lord, we are only against CBI and ED. But the entire gamut is much beyond, my lord, the activities of CBI and ED. Then Mr. Ganguly has made his submission that these are only reporting of facts. Whatever has been reported are reporting of facts, but I leave it to your lordship's wisdom, my lord, as to whether, my lord, these can only be limited to, my lord, reporting of facts, but very many other things have been said. But on facts, my lord, I will not dilate. No urgency pleaded. My lord, again, my lord, for fundamental right, what urgency will I plead? Well, please only recall, my lord, the principle, my lord, enforcing a fundamental right again is a fundamental right.
Yes.
That is why we have Article 32, my lord, in the Chapter 3. Then Kalighat PS case, etc., my lord, I don't think, my lord, is of much importance. Then another submission by Mr. Ganguly was that these are all stale publication, something which has been published in 2019 or 21. But, my lord, your lordship has seen, my lord, we have given the dates, but it is an ongoing process. So I have not stopped at 2019 or 2021, but in that chart, in para 25, on the left-hand side, we have given the dates. Your lordship will get the dates. I don't think, my lord, that it can be said to be a petition with stale claims. But alternative remedy, my lord, Cable Television Network Regulation Act has been cited. But that again is not applicable. That applies only between cable operators and television only. And Mr. Sabyasachi Chatterjee's submission that it would amount to, my lord, regulating or interfering with the internal political activity of the country by a foreigner. This submission, my lord, if I have a right under 14 and 21, well, I can enforce it. And I don't think, my lord, it relates to, my lord, any internal political activity that I am before this court. But I am before the court with the primarily all rights pertain to or emanate from the criminal law jurisprudence in our country. And, my lord, Sahara, my lord, he has said that fair comment is permitted. Of course, fair comment is permitted. Only to reiterate only one thing, my lord, this judgment I have cited, 2020 SCC Online SC page 765, at paragraph 25, I've already cited this only to, my lord, as the last statement of mine. is that in that judgment where it has been said that percolating news amounts to dereliction of duty by the police.
By the police.
Police. Nothing. Well, yeah, yes, I missed this. Maybe I was not there. But one of the submissions of Mr. Ganguly was that whether the reportage affects the course of justice or not, and people's confidence in the administration of justice. Well, I don't think, my lord, after so many judgments, my lord, it can be said that it would ultimately affect the administration of justice. Rather, it will further the administration of justice. A part of administering justice is a fair trial. Keeping the presumption of innocence alive. Having a fair treatment, whoever it is, in course of trial. So, my lord, this again, my lord, in my very respectful submission, cannot, my lord, in any way affect the administration of justice. But these are my submissions.
Heard learned counsel for the parties, full stop. The matter be placed.
My lord, just once, my lord, one mistake, my lord, which has come to our.
Let me complete my sentence. The matter be placed on October 17, 2023 for the purpose of passing orders.
My lord, just 1 minute. What we, the statement which was made by me on record, my lord, recording ED, my lord, we have made, use the word generally. Please. That will be deleted because that generally word qualifies.
Follow.
My lord, will kindly see. My lord, my lord, that statement which I have made, my lord, with regard to focus on the positive work done by the organization and to build confidence with the public, with due care, information are put on the website of the ED only after actions are completed. Further, only those facts are shared with due caution, which may not impede and jeopardize the interest of the ongoing investigation / action. No opinionized or judgmental statement are made by the ED. My lord, generally will not be there.
I was wondering.
My lord, generally will not be there, my lord. That is a mistake, my lord. No opinionated or judgmental statements are made by the ED against any person. Generally needs to be, my lord, deleted. I stand corrected and I record, my lord, that ED against any person, my lord. No opinionated or judgmental statements are made by the Enforcement Directorate against any person. My lord, we have to be very cautious.
Because generally, it would be very risky.
My lord, there is a saying in Urdu, my lord, will kindly allow me, कि नुक्ते के हेर फेर से खुदा जुदा हुआ. Nukta in Khuda is at the bottom and Juda is at the middle because Jim, according to the Arabic word, that Nukta, that dot is in between in Jim. So therefore, this is what happens, my lord. Therefore, we have to be very cautious. One word, my lord, makes things
absolutely.
Therefore, my lord, 70. I apologize, my lord, for that mistake which I made.
Yes.
My lord's leave.
Grateful to you, Lord, for the patient hearing given to all of us.
That's my job. The arguments were very interesting.
It's a very
This is an interesting
case.
topic, yes.
Very interesting case.
Absolutely. Yes.
Item 4.
Your Lordship, I'm for the writ petitioner, Your Lordship. Your Lordship, in this matter, Mr. Devnath Ghosh is appearing, Your Lordship. He is engaged before another courtroom, Your Lordship.
Your Lordship, may I
Not a good
start?
ground. Not a good ground.
Your Lordship kindly passes it over, Your Lordship.
Sorry.
Your Lordship, I can start.
Start, yes.
Lordship, the matter was also mentioned. We were not served the notice of mentioning, Your Lordship.
Even then. Yes.
Your Lordship, it was mentioned yesterday only before the court took original side.
Without any notice to the other side?
Yes,
Your
Your
Lordship,
Lordship.
no,
Your
no.
Lordship, it was in the list yesterday.
Your Lordship, we
Item
were
number
not there.
22. And then 21, Your Lordship started taking original side. So it was mentioned.
Your
Considering the
Lordship, but we were
urgency.
not
Not have
served
been
any
there.
mention.
No, they were there, Your Lordship.
Your
It was
Lordship, we were
item
not
number
there.
22,
Your
Your
Lordship, we were
Lordship.
not there,
Let's
and
not
the
dispute
notice
on
was
that.
not.
Come back
served.
come back on Monday. What is the urgency?
Your
It's
Lordship,
very urgent matter.
Your
Your
Lordship,
Lordship, it was mentioned
kindly make
yesterday,
it
Your
not
Lordship.
today, Your
What is the
Lordship.
urgency in the matter?
The urgency, Your Lordship, I'm going to address Your Lordship on 2 points, Your Lordship. First point is that the termination notice, it was beyond jurisdiction, Your Lordship.
Have
Secondly,
you been debarred also?
yes, Your Lordship, for 3 years. And additionally, Your Lordship, they have
Why can't you wait till Monday?
no, Your Lordship, this is in the list, Your Lordship. It was there
It
yesterday
will
also.
be in the list, in the same
Your Lordship,
position.
kindly takes Your Lordship. It's very
No, no,
urgent
they're not
matter.
there.
Your Lordship, kindly. Your Lordship, I can start. Mr. Devnath Ghosh will join, Your Lordship.
Your Lordship, he is engaged before another
Your
court
Lordship-
in an ECL matter, Your Lordship.
EC matter?
Yes, ECL matter, Your Lordship.
Your Lordship, I will start. Mr. Devnath Ghosh will join after
He will not
completes
be
his
able to, Your
submission.
Lordship.
Pass over. Whenever both of you are there, I'll take up. Yes. Just mention the matter. Next.
Lordship.
Item 5,
Lordship, I am appearing on behalf of the petitioner, Lordship.
Move the matter. Unless you move the matter, it goes down.
Lordship, no, I
Cannot
will.
afford to upgrade matters and then adjourn them. No.
No, she's not asking for adjournment, Your
Start the
Lordship.
matter. You are not doing the matter. You are saying you are not asking for adjournment. Then let me
praying
dismiss
for
for default.
No, Your Lordship, I'm praying for.
Either you move it, seek adjournment, which I'll refuse, or I dismiss the matter for default. What is the meaning of I'm not asking for adjournment? You are not doing the matter. You're wasting time. These are all upgraded matters, ma'am, at the expense of some other matter. All of these.
Yes, Your Lordship, this was mentioned.
So start the matter, please.
Your Lordship, I appear on behalf of the petitioner. Your Lordship, this is a registered association, Your Lordship. Your Lordship, association, Your Lordship, we were organizing, Your Lordship, different festivities and welfare activities. So, and Your Lordship, by notice, by an illegal notice dated later dated.
What is the interim order you asking for?
Your Lordship, no interim. Your Lordship, I'm
There is no
asking.
scope of interim order. You're asking for restoration of possession. What can be the urgency?
Your Lordship, the
You
main
expect me to
urgency
hear out
is-
the writ petition?
Your Lordship, the main urgency I'm stating, Your Lordship, the urgency is that Your Lordship, we are unable to hold, we used to hold Durga Puja in the said premises, Your Lordship. Now for the past 10 years, it's being held. Now, Your Lordship, the difficulty is that all of a sudden we have been ousted from the possession. Your Lordship, the 3 associations, blocks, which are being holding
You
the
are
Durga
seeking a
Puja.
restoration of possession in a writ petition. Don't hold the Durga Puja for this year.
Your
Heaven
Lordship,
will not fall.
Your Lordship, this is. Your
There are
Lordship,
too many Durga Pujas for Goddess Durga to attend already. So if you don't hold puja, nothing will happen. Heaven will not fall definitely.
Your Lordship, it is not Your Lordship. We
No,
are ousted.
You are seeking restoration in the garb of Durga Puja. Everything is not connected with Durga Puja. Only if you are in possession, you can hold Durga Puja. You are not in possession, have restoration of possession before a proper forum, and then hold Durga Puja, Kali Puja, everything.
But Your Lordship, even ousted illegally, Your Lordship, without proper notice, Your Lordship, because there are other associations also. So Your Lordship, similarly, we were also promised by the respondent authority that we will also be allocated a separate block, Your Lordship, separate space for holding.
What do you mean by ousted? What is the basis on which you claim your possession? What is the right to remain there?
Your Lordship, we were allotted this spot by the NKDA itself, Your Lordship. No. I have to show how can we not stop that. Your Lordship, I'm.
So the issue is that, my lord, my allotment has been given to a third party, not an association with which I was.
You are seeking restoration of possession?
No, my lord.
You have prayed for that B.
But I can't get it, my lord.
What is the memo you are seeking quashing of?
My lord, it's the memo which is at page 33. My lord, I'm also covered by a judgment passed by your.
What is your right over that land? What
My lord, it was allotted to me
Yes.
for carrying out cultural activities,
Right.
which is at page 20. I've been carrying out Durga Puja at the same premises for last 10 years. It's been cancelled without, we had made a representation, so it's not been considered as well.
This was of 2013.
Yes, my lord. And I have continued, there's an electricity line in my name there.
You conduct Durga Puja, that
Yes.
does not mean you are in physical occupation of the property. Durga
Yes.
Puja, conducting Durga Puja does not entitle you to be in occupation.
But you will kindly see, my lord, page 29.
Yes.
This is the electricity bill, which is in.
Suppose this is only a permission to hold organize Durga Puja in 2013. Where is the letter of allotment to you?
No, this is 2021, the bill. At page 29.
What is your right? Where is the allotment?
No, this is the allotment at page 20.
20 is not an allotment. I'm sorry. You were permitted to hold Durga Puja in 2013.
And my lord, it's been identified at page 21 as the as a particular plot. And we have continued from time to time there. My lord, at page 31 is my representation for allotment of cultural activity space. My lord, 3 residential units, residential blocks were conducting. Now, my lord, in terms of NKDA, they had split it into 3 parts because the dissidents have gone and formed separate associations. The plot where I was conducting cultural activities, it was under my lock and key. It's been broken open, and my lord, it's been allotted to A1, which is a separate association. I have written to them, I have requested them to permit me to conduct Durga Puja at any place or any other place which they may identify the same. They have not responded.
After 2013, is there anything to show you had been performing this puja on other years, in other years? 2013 is your last document.
No, my lord. My last document would be at page 31, where, my lord, we have written to them.
That's your writing.
Yes, my lord.
That does not vest any writer.
And Lord, you will kindly see, my lord, their document 19th of July 2022, which is at page 33. And my lord, the third last line of that document, also a piece of land has been identified in AL block by HITCO. Same has been communicated by AL block to NKDA.
This is very vague. To whom? Communicate to
To
whom?
AL block. But my
And
lord,
you are which block?
I am, my lord, composite, which is at serial number 1 of the addressee.
You are no longer there. It has been split up.
No, I am still there. So it was initially one society comprising of 3 blocks.
This comprises of civil rights. Evidence is required to be taken, Mr. Ghosh.
No,
How can
by-
the could determine this even?
No, AL, the society, it's a registered society comprising of 3 blocks.
No doubt.
Some dissidents have gone out. Now, my lord, I have a right to conduct cultural activities, including Durga Puja, which is no longer, my lord, your lordships.
Not wherever you like.
No.
If it's a designated plot only there.
Yes, my lord. I'm only seeking till this issue
You are
is
not in
decided.
possession admittedly.
No, I'm not in possession today.
Then how can we be given
They
a
can
right?
at least identify some place where I can conduct.
No, you don't have such a right. That's not a blanket right, Mr. Ghosh.
I
You can give it
understand, my
to
lord.
the civil code.
Let them at least then consider my representation, which I've given to them. That I want a separate plot, then at least identify that for me.
Where is your application for that?
My lord, it's at page 31.
See your para 8. You are opposed to the idea of sharing.
Yes, my lord.
So then how
Because-
can it be done? I mean, it has been allocated to somebody else.
Yes, my lord, that is why,
They cannot invent land when it is not there.
my lord, even if it is allotted to some other place, some other part of the township, I would be willing to go there and conduct. Because, my lord,
Yes.
because the
Mr.
society
Gupta,
is there.
Mr. Gupta, what do you say that?
Yes, my lord,
What do you say to that?
2-3 things.
Hmm.
Firstly, my lord, this writ petition seeks to cancel uh, plots allotted for community centers in 2-3 other blocks without making them parties. The association of the other blocks parties. Kindly sees the costatal ones. The name of the petitioner is Alakai block, that is comprises of the residents of AL, AK and AI. So when, my lord, in Newtown area, the residents were not that many in number. Three block, my lord, residents formed this association together. So then one plot was earmarked for Durga Puja or any other cultural event of the residents of 3 blocks together. So now that was being done not only for them, but 2-3 other blocks combined, and that was the procedure followed.
Now it has been split up.
Split up, and
Separate
in every
associations?
block,
Yes.
in every block there are separate associations. In every block there are community centers, which we have already given them. We have given permission for Durga Puja in all blocks. So this association, in my humble submission, does not have any other right. And that apart, my lord, they in the writ petition they are seeking to cancel those allotments made in the made for the different blocks. So they have not been made parties also. If my lord sees the
Tell me, yes, Mr. Ghosh, what do you nothing. Nothing.
Only let them at least consider, my lord. I know
these matters.
No, only let them consider whether I can get
Why
a
should
separate
they
allot, because
Really
the society
grateful to
is there.
Mr. Ghosh
Even
for
I am not willing to consider, they'll consider.
Yes, my lord.
I'm really grateful
Well,
to
lordship
Mr.
is-
Ghosh. I'm appearing for HIDCO as well as NKD. This one
Two
matter
fees.
I could not have missed.
2 fees.
One matter I could not have missed.
Mr. Gupta is getting 2 fees for me. One he'll share, he has agreed.
The petitioner number 1.
May I take your lordship's leave?
Yes. The petitioner number 1 is a registered association, and the petitioner number 2 is its general secretary. First up, next para. The petitioner number 1 is an association which was in charge of representing the residents of 3 blocks in Newtown, being the AL, AK and AI blocks. Full stop, next para. Subsequently, the blocks were split up into separate ones, and associations were formed in respect of each of those. Full stop. Although previously the petitioner number 1 used to conduct puja for all the 3 blocks together, the respective associations of each of the blocks have now been allocated plots for the purpose of holding Durga Puja. Full stop, next para. Learned counsel for the petitioner submits that the petitioners have all along been in possession of the property and seeks to lay stress upon photocopies of electricity bills which are of recent origin, annexed to the writ petition in that regard. Full stop, next para. It is further submitted that the petitioners have been illegally ousted from the plot. Full stop. Learned counsel for the petitioners further argues that the petitioners merely seek to organize a puja, and the respondent authorities may be directed to consider such plea of the petitioners. Full stop, next para. Learned counsel appearing for the NKDA submits that the respective blocks are now under the charge of separate associations, each of whom have been permitted to organize Durga Puja in each of the said blocks on allocated plots. Full stop, next para. As such, the petitioner number 1 has no justification for continuance, at least for the purpose of organizing Durga Puja. Full stop. It is further argued that the petitioners have sought for cancellation of allocations made to others, who are not parties to the present writ petition. Full stop, next para. A perusal of the documents and a hearing of the learned counsel for the parties reveals that at present, there are 3 separate associations in charge of the supervision and cultural festivities in 3 of the blocks, which were previously under the joint charge of the petitioner number 1 association. Full stop. Since the said associations have been allocated respective locations for organizing Durga Puja for each of the blocks, the petitioner number 1 does not have a statutory or a constitutional right to insist upon organizing a Durga Puja, comma, in any of the said blocks or otherwise. Full stop, next para. As in any event, comma, the rights claimed by the petitioners over the plot in question are within the domain of a competent civil court and cannot be adjudicated in the present writ petition. Accordingly, WPA 20447 of 2023 is dismissed. Full stop. However, comma, nothing in this order shall impede the petitioners from approaching the competent civil court for canvassing their independent civil rights with regard to the properties in question, if the petitioners are otherwise entitled to do so in law. No orders to cause such.
Only one more indulgence, my lord. If I approach them for the purpose of conducting pujo for this period, they'll consider it. Only that much. If I approach NKD.
Mr. Gupta has escaped.
My lord,
Oh, you are
Mr.
there.
Siddiqui is there.
Oh, you are there. Achha. I won't create a right.
Lord, she will kindly, my lord. It's not a right, my lord. To conduct pujo, it's a right for any person. Under 21, Article 21, I have a right, my lord. It's part of my right to life.
Come after the Durga Puja.
Well, then it will be redundant.
Consider for the next year.
No, my lord, she'll kindly permit me.
That is beyond.
I have also.
You have not even applied for.
Yes, my lord, I have. No, it's not part of the writ petition. I have applied.
Online.
My lord, it's a physical copy. It's been served on them.
Not permitted. Unless there is an order of the court. I know, but now.
Lord, she'll kindly, my lord.
No, Mr. Ghosh.
My lord, if I can't conduct pujo, my lord, it's a society. It's a registered society. It has members over
It will
200.
create more problems than it resolves. Because after holding all these things, I cannot direct your.
No direction. It's just in case a representation is made, they'll consider. That is all.
No, that's too general.
I'll lose the chance of holding pujo
No.
because they'll cite this even if I apply now.
Hold it in one of your petitioner number 2's home.
Lord, I'm here, my lord. I apologize. I was sitting in the morning. It was.
Yes, I saw that. That I attend the matter.
Lord called for my presence.
Your learned friend is yes.
Lord,
She's
can
there.
I come back at 2 p.m. Lord? It's going on matter. I will not run back because Lord Lordship's desire.
Convince your learned friend. I can take it up on Monday.
Lord, I have convinced her.
I'll take it up on Monday.
No, your lordship, please take it up today, your lordship.
What sort of a?
It's urgent matter, your lordship.
What is the English of Abdar?
Please, kindly, your lordship.
No, come back on Monday.
Kindly, your lordship, it's a very.
Why? What is the urgency?
Urgency, I'll tell you, your lordship. Here,
Well, the service may.
I've been.
She will be embarrassed.
Mr. Ghosh is very.
No. Let her. She will be embarrassed.
Come back at 2.
Well, may I file,
Thank you.
I file the affidavit of service.
Yes, definitely. Sorry, Mr. Ghosh.
No, it's all. I'm so
Coming in 10 minutes for the next matter. That matter will be taken up at 2.
Yes, grateful, your
I'm
lordship.
great.
Item 6.
Yes.
My lord, I'm for the petitioner.
I am for the.
May it please your lordship.
Yes.
My lord, the senior citizen petitioner before your lordship runs a shop at IIT Kharagpur campus, providing culinary services since a decade now. Providing culinary services, my lord.
Right.
Since a decade now, more than a decade, from 2012 to be precise. Now, my lord, on 9th of September 2023, at about 10:45 p.m. in the night, while there were patrons over there in the said restaurant having their dinner, the Kharagpur IIT personnel, the security personnel, barged into the shop. They asked the petitioner and his 14 staff members, including one lady staff member as well, and the other patrons, to go ahead and vacate the shop immediately. I was met with threats with dire violence and despicable acts. And seeing their threats of violence, I had no other option other than to shut down my shop. I did so, my lord. The next day, on the 10th of September, in the morning when I went to open my shop, I found that the security personnel have blockaded the shop, sealed it, and upon inquiring and forbade me to open the shop. Upon inquiring, my lord, I was directed to meet the secretary of the CELC, which is the Commercial Establishment and Licensing Committee of IIT Kharagpur. It's a part of IIT Kharagpur. Now, my lord, being a Sunday, I wasn't able to meet the said secretary as the office was closed. So on the very next day, on the 11th of September, I went ahead and gave my representation as to why my shop was suddenly closed down. There was no reason whatsoever, no notice was served, no hearing was done. I am still at a loss as to why it happened, my lord. Then following
You were given a license at any point of time by any authority?
Yes, my lord. I have been giving a license and I have also annexed those documents, my lord.
Was that till surviving that license at that point?
I will come to that, my lord. But they have accepted those said license fee, my lord. Your lordship shall find it on page, my lord, from 21, 22, and 23, my lord. Even till 24th of August 2023, my lord, I have paid my license fee, my lord. And the CELC of IIT Kharagpur has gone ahead and given me the due receipt, issued the receipt as well for August 23 as well. I have paid the license fee, I have paid the additional license fee as well, even the electricity charges, everything. Now, my lord, in 2013, pursuant to their own permission, I had actually expanded my shop. With their permission, my lord, letter was duly issued. 728 square feet, I have increased it, and I have invested 28 lakhs of my own money to improve the shop. And my lord, till now, I was running it without any problems whatsoever. Now, on 12th of September, after my representation, no, needless to say, my lord, nothing was received from the IIT Kharagpur's end as to the reason why they have shut down the shop. On the 12th of September, from a daily called the Doinik Statesman, I came to know there was an article published and the media executive of IIT Kharagpur had given a bite stating that my shop was closed due to allegation of electricity theft. I fail to fathom, my lord, how I can indulge in such practices. And till now, my lord.
That is in your name.
My lord,
your name.
No, actually in IIT Kharagpur in the market committee.
Block meter.
Right, my lord. It is actually given by them. And those electricity amount, my lord, I pay to IIT Kharagpur, the CLC committee directly. My lord, it is evinced from the page 21, 22, and 23. Your lordship shall find that electric charges have also been collected.
From the block meter, individual meters are also, the numbers are allocated probably. Was anything allocated to you?
My lord, they give us a bill and I pay it.
Well,
that's how it works.
So what relief are you wanting at this stage?
My lord, subsequent to filing of this writ, after the writ was filed, my lord, on 5th of October, a letter dated 5th of October, they have unilaterally and arbitrarily cancelled my license with just one paragraph that your license has been cancelled and you are hereby ordered to go ahead and surrender the shop and hand over the premises to the IIT Kharagpur authorities. No reason whatsoever, my lord. All of a sudden, this is high-handedness. I went ahead and even submitted my representation to that Kharagpur town police station, my lord. They did not accept it. I sent it through registered post, and recently, after the filing of the writ, my lord, I have received the letter back stating it's refused, my lord.
The police, for the time being, yes.
Police authorities have refused my letter. They did not even bother to open it, my lord.
I'll ask you, maybe I'll ask you to file a supplementary affidavit.
Such is the unholy nexus, my lord, between the IIT Kharagpur authorities and the police
authorities. What interim order are you expecting?
My lord, till the disposal of the writ, I may be permitted to open my shop and continue to run my business, my lord, without any hindrance. And if necessary, I'm willing to comply with any directions whatsoever as imposed by the Honorable Court, my lord.
Yes. You are for the IIT.
I am for the IIT. IIT means
You are for
IIT,
the-
they have not made a party.
Then who?
No,
Officials are party.
officials are party, not IIT.
Party, no?
IITs have not been made a party.
The chairman.
Anyway,
has been made the
chairman,
party.
director,
The
all are
director
party.
has been made
Any
the
event,
party.
that should have been. Article
Yes,
12
true.
conception speaks about it.
What is your stand in that?
My standing was there was some misconduct by him, and my lord,
In this manner, IIT, premier institution,
no, my lord, kindly look at it. I have written the letter to the.
whatever he has done,
Huh?
you cannot do this to him. Whatever he has done.
I am talking about it that we wrote about it to the officer in charge of.
What has he done, by the way?
Theft of electricity. That is the charges.
IIT deals with its licenses this way.
Yes, already dismissed.
I'll reverse the entire action in the interim period.
Huh?
He'll be restored person, his person will be restored, he'll be able to run his business. I'll direct affidavits, whatever you do after.
My lord, as we speak right now,
This is not the way.
My lord?
You cannot evict a person like this. No.
Not a question of eviction. My
You have
lord.
stopped his business. Article 19 is squarely violated.
My lord, why he should steal
That's it, allegation. No show cause, nothing. And who are you to say
My lord,
electricity
kindly
theft?
look at the.
Yes.
my lord, this was also not supplied to me, my lord.
Give a copy to him, please.
I'm grateful, my lord.
Criminal activities, my lord.
September. My lord, the date is 30th September. The incident occurred on 9th of September, my lord. And my lord, as we speak, I've just received information that the IIT Kharagpur authorities are dismantling my electricity, my fixtures, electrical equipments. They're dismantling it right now as we speak.
No, definitely not. I'll direct restoration of possession immediately.
Well, how it will be, my lord? If it has been dispossessed.
By midnight today. How it will be, I will consider in contempt.
My lord, kindly look at who is the commercial establishment license committee.
I can't believe the IIT Kharagpur is doing this actually.
No,
I
my
can't
lord,
believe it.
kindly look at this
Anyway.
This document.
My lord, may I be supplied with a copy of that as well?
Yes, you have to give
On-
copies.
on-
Whatever you hand over, please give a copy to him.
On inspection.
Give a copy to him. Otherwise, I won't look into this. Please give a copy to your lawyer. Yes, on inspection, what happened?
On inspection, this was fun. This is the direction of the license cancel. Why it was?
My lord, that is 5th of October.
I'll give you
2020.
liberty to add a challenge to this in your supplementary affidavit.
I'm
Do that.
grateful, my lord.
I'll stay this also.
Well, at this time, there is no question of giving that possession of this at this time.
Within midnight today.
Well, then it will
What?
be a-
No possession.
it is
Within midnight today.
Is it
With
not
police
going-
help, I'll direct him to approach the
it is
police.
not going
Police will act on the server copy and his communication.
Mandatory order. my lord.
Mandatory.
Well,
Status quo ante.
But
All the criteria are satisfied here.
without reasoning that why you have.
Reasoning will be there. Otherwise, how can I save myself from the appellate?
I am just talking about it, that we have said that this is the reasons we have done it. We have gone, give the information to the police authority also. That
The-
this is the.
The present-
Union of India, but our petition doesn't have any grievance against us.
No, police also won't be provided by you. So you don't.
Huh?
The president.
My lord,
Sorry.
on-
Yes. উনি কি বলে নিচ্ছে বলে নিন। Yes.
My lord, I mean, total I am reading it, my lord. Kindly look at it. 30th September order.
30th September, yes.
On 10th September 2023, at approximately 800 hours, the security personnel of IIT Kharagpur, along with such and such technical marketing authority and representative of the electric and maintenance section, discovered unauthorized electrical connection at shop number W13, Pip Kitchen, Tech Market license name Sri Purnendu Shekhar Panigrahi. These unauthorized connections were being used to steal the electricity, causing significant financial losses to the right full electricity provided and posing a more potential safety hazards to the surrounding area. Furthermore, it has come to our notice that the state's shopkeeper has been providing illegal power supply to other unauthorized stalls set up by him within the vicinity of the allotted shop space. Joint inspection team consisting of the officials from the security CELSLC electricity maintenance have found approximately 22 LED tube lights, 06 halogen lights, and 1 Guinness that were being run through the illegal power connection. These are the come to the
You
surface.
should have hanged him actually for this.
Huh?
You should have hanged him till death. Electricity theft, such a serious offense. He should be evicted like this. This should be the premier institution's message to the world.
No, that is he has done. Then what will be the
This
status
was
of-
sarcasm, if you could not, I mean.
Alright?
This was sarcasm.
My lord, I am telling you that this is the
So how can you support this?
Which one, my lord?
This action of yours?
No, but we have done it for the purpose that the license was given by us. License was given by us.
Team was inspected.
And a team inspected that thing. I don't think that this is not been done.
Who inspected? What is your authority to inspect? Electrical.
My lord, question is then what is the purpose of the terms and condition of the
What you are not the distribution licensee.
My lord?
You are the licensee. You are the consumer. IIT is the consumer. You are not the distribution licensee. What is your authority to hold inspection?
Once again, I am reading this.
No, please don't. Please
My-
don't
my-
waste time. No. Learned, the president.
my lord, then-
No, I've heard you. Yes. The present challenge has been preferred against extremely high-handed action.
One thing, my lord. License has been given by us for the rest.
Extremely high-handed action on the part of a premier institution of the country, being the Indian Institute of Technology, Kharagpur. Full stop, next para. Learned counsel for the petitioner contends that the petitioner had been running a culinary business from the campus of the IIT Kharagpur since the year 2012 and expanded the area of such business in the year 2013 upon huge expenditures being incurred. Full stop, next para. However, comma, at the night of September 9, 2023, comma, the henchmen and agents of the respondent authorities, that is the IIT Kharagpur, comma, barged into the showroom and ousted the petitioner forcibly, along with 14 employees, comma, including one lady employee, comma, while the petitioner's customers were in the showroom. Full stop, next para. Subsequently, on September 10, 2023, when the petitioner sought to enter the showroom, comma, the petitioner found that the same was blockaded by security personnel of the IIT Kharagpur. Full stop. It was indicated to the petitioner that the petitioner had to approach the Commercial Establishment and Licensing Committee within bracket CELC bracket closed, which is an internal committee of the IIT Kharagpur. Full stop. However, comma, since September 10, 2023 was a Sunday and a holiday, comma, the petitioner could not have any access to the said committee. Full stop. Next para. Subsequently on September 12, 2023, comma, the petitioner came to know that the media person of the IIT Kharagpur had given a bite, BYT, to the concerned media, indicating that the petitioner had allegedly committed theft of electricity. Full stop, next para. The petitioner, comma, of course, comma, denies such allegations. Full stop. Subsequent to filing of the writ petition, comma, on October 5, 2023, comma, a communication was made by the IIT Kharagpur to the petitioner, purportedly terminating the license granted to the petitioners. Full stop, next para. On the prayer of learned counsel for the petitioner, comma, the petitioner is granted liberty to file a supplementary affidavit on the next date of hearing with an advance copy to the learned advocate on record for the respondents. comma, challenging such subsequent issuance of termination notice as well. Full stop, next para. Learned counsel appearing for the respondent authorities places reliance on a complaint made in writing to the officer in charge of the Hijli town outpost, comma, IIT Kharagpur campus, dated September 30, 2023, where several allegations have been made by the senior security officer of the IIT to the said police, alleging power theft by the petitioner, Fushab. In the said complaint, comma, several allegations have been made, comma, including that the petitioner had unauthorized connections, comma, which was being used to steal electricity and supply electricity to other unauthorized stalls set up by the petitioner. Full stop, next para. Learned counsel also places reliance on a copy of a memo dated October 5, 2023, comma, whereby the chairman of the CLC, IIT Kharagpur, purportedly cancelled the allotment to the petitioner to run the shop within the IIT campus. Full stop, next para. It is contended that in view of the serious offense committed by the petitioner by pilferage of electricity and supplying the same to other establishments, comma, the action impugned was taken by the IIT. Full stop, next para. It is unimaginable that such a disproportionate action could be taken by the IIT Kharagpur, comma, which is one of the leading institutions of the country imparting education to students. Full stop, next para. On the face of the documents placed before this court, comma, it is evident that the IIT Kharagpur obviously admitted that the petitioner was duly running his shop within the premises, comma, since by virtue of termination of the allotment to the petitioner on October 5, 2023, comma, as an afterthought after filing of the writ petition, comma, it has been implicitly admitted by the IIT Kharagpur that such allotment had been granted in favor of the petitioner and had been subsisting before the purported termination. Full stop, next para. That apart, comma, the the complaint lodged with the police authorities is dated September 30, 2023, comma, which is also a patent afterthought, comma, since the high-handed action of evicting the petitioner illegally was done on September 9, 2023, comma, that is 21 days prior, that is 3 weeks prior to the lodging of the complaint with the police authorities. Full stop. In any event, comma, the IIT Kharagpur is not the distribution licensee, comma, nor does it have any authority whatsoever to hold an inspection or to conclude beyond reasonable doubt that the petitioner was guilty of theft of electricity, comma, within the contemplation either of the Electricity Act 2003 or the regulations framed by the WBERC thereunder. Full stop, next para. In view of the above circumstances, comma, the impugned action, comma, which is extremely high-handed and patently unlawful, comma, has to be set at naught NAUGST immediately without waiting for the final disposal of the writ petition. Full stop. Hence, comma, furthermore, comma, in view of the strong prima facie case made out by the petitioner, the writ petition itself is required to be heard on merit as well. Full stop, next para. Accordingly, the respondents are directed to file their affidavits in opposition by November 24, 2023. Full stop, reply, if any, shall be filed by December 1, 2023. The matter shall be listed for hearing in the combined monthly list of cases for December 2023. Full stop. Next para. The respondent authorities shall, comma, by midnight today, comma, acting upon the communication of learned counsel for the parties, comma, restored the possession of the shop room which was being run by the petitioner pursuant to the allotment given to him by the IIT Limited. Uh, Full stop. Next para. It is made clear that in the event such possession is not handed over to the petitioner, comma, the petitioner will be at liberty to approach the local police outpost, that is the Hijli town outpost, which shall, comma, acting upon the written communication of the learned advocate for the petitioner, coupled with a server copy of this order, comma, without insisting upon prior production of a certified copy of this order, comma, restore such possession to the petitioner. Full stop. However, comma, such restoration of possession shall be subject to the outcome of the writ petition. Full stop. It is made clear that upon such restoration and till disposal of the writ petition, comma, the petitioner will be entitled to run his business which he was doing prior to such disposition. Full stop. Next para. Yes,
In the meantime, my lord, restoration of electricity and water supply as well. please.
Only thing I'm asking,
Arakta line add kore for the effective running of such business, comma, the electricity and water supply as well as other essential services shall be restored to the petitioner by the respondent authorities, comma, by within 24 hours from now.
well, only thing I am submitting.
I'm
my lord.
extremely obliged, my
Yes,
My lord,
please.
instead of midnight today, my lord, your lord should give 1-2 days so that we will not go for any.
Not for this action.
Oh, my lord.
Well, it is not possible right at this moment. What I am talking about it, even one day your lordship is permit instead of 12 AM, that will be. Communication.
Why communicate by phone?
Communication.
Communicate by phone.
Only.
And send an email. Ask your learned junior to send an email.
Well, it is an autonomous body, my lord.
So what?
Only one day I am coming. Your lordship.
That's why he is asking for that.
At least some days, my lord. My lord.
Not for this matter.
My lord, if it
is not
it will
special.
be violation of the court's order if they are unable to do it on that day. So I am telling what is practical.
That I'll consider in contempt. That I'll consider in contempt.
Well, it is practicable, or at least they are.
Midnight, take steps, take steps.
At least
Take steps immediately. No. Call on the next matter.
I'm grateful, my lord.
Item 7. 7.
Directed for restoration of electricity, but that is to be done by the IIT authority, because we have not disconnected.
Yes, who is appearing in next item?
But I'm praying for one of the Durga Puja, Milordi.
Don't hold it. No permission, don't hold it.
Milordi. Milordi, page 25, Milord. Physically
Why is there
application.
sudden splat of religiousness before the Durga Puja festivals? What do you do all the year round?
Milordi, it is 19 years Milord running, Milordi, Durga Puja, Milord.
Yes.
Milordi,
Have you applied?
Milordi, physically
When
have
did you
applied.
When
Milordi,
did you
on
apply?
page 25, Milord.
You have been doing Durga
Page
Puja the
29,
previous years
Milord.
also.
On
You have
the
been doing
19th
the same thing the previous years also.
Yes, Milord.
Right. Page 25.
Page 29, Milord. Annexer P5, Milord, page 29. The previous year, Milord, I have been asked for the by the Milord, the IC police, Milord, the Tamil police, Milord. The page
Previous
20.
year you did you conducted Durga Puja.
Milord. Previous
Why
year,
didn't you apply online? What was the last date?
Milord, after filing, Milord, I have applied, Milord, on 19th October, Milord. That time was the portal was not open.
And I them to consider.
Yes.
Give a copy to them.
That was a prior, yes. That means
Yes.
he applied offline. That's why this is the result.
I think so.
So if he has
Give a copy to
applied
them also.
offline
Why
provision
are you
is not
nodding your
there.
head? Give a copy to them. How can I look into it?
So if it is online, Milord, now they should process. Lord.
Milord, I shall give Milord.
SDU is the permission granting authority. Milord, this is what I have received from the Milord BDO concerned.
Right. The petitioner's grievance is that the petitioner applied for holding a Durga Puja in the oncoming Durga Puja festival. So, however, comma, the respondent authorities have not responded to the same. For next para, learned counsel appearing for the state hands up an internal communication with a memo number 2347/BDO dated September 30, 2023, where it is indicated that the petitioner has not submitted any online application through the concerned web portal, comma, which is the essential prerequisite for granting such permission. Full stop, next para. It transpires from the annexures to the writ petition that the said apprehension of the state is correct, comma, as only a handwritten representation was given by the petitioner. Full stop. At this juncture, learned counsel for the petitioner hands over a printout of a purported online application made by the petitioner subsequently, comma, bearing application reference number AFP stroke 2023 stroke 00475. Full stop, next para. Since such an application has now been made, comma, WPA 23482 of 2023 is disposed of by directing the respondent authorities to consider the online application of the petitioner and take due decision on the same, comma, preferably due decision on the same within 3 days from this date. Full stop. The learned advocate for the petitioner shall hand over a copy of the printout filed in court today to his counterpart appearing for the state during the course of the day. No orders to cause urgency.
But the liberty to communicate the lordship's order, my lord.
State is here.
Lordship.
Please give a copy during the course of the day, otherwise this order gets ineffective.
Item 8.
No, I am for the petition.
Yes, Mr. Bhattacharya, what is the matter?
No, this is the regard to the same matter for permission for holding the Durga Puja.
You will hold a Durga Puja. What will happen to Lord Goddess Durga?
Previous year permission is not there.
I have previous year's
Oh,
permission.
previous year
my lord,
permission.
Page 16 is my lord, my representation. Page 19 is also my lord. Page 16 my lord, and previous year my lord, the municipality was granted.
The single window system also he has not gone for that.
This server is
Difficulty is this previous year, this policy as a general policy cannot be, I mean, I won't interfere with the policy at this stage. I'll direct them to, I'll direct you to consider this handwritten representation. What is that representation?
Page 16 my lord.
What is page 19?
Page 19 before the IC man. And page 16 before the subdivision.
Only the requirement is this CSDO's permission for the previous year. That he has not got.
But there is no justification for that. You cannot support that on any logic. Blanket way, you cannot say that. I mean, just because they have not previously done Durga Puja. Learned counsel for the petitioner contends that the petitioner's application for permission to hold Durga Puja this year has not been responded to by the respondent authorities. Full stop. Next para, learned counsel for the state submits that as a matter of policy, comma, the applications by new organizers for holding Durga Puja for the first time this year are not being entertained on the online web portal. Full stop. Next para. However, comma, there does not appear to be any justification for such general policy decision, comma, which does not have any reasonable basis whatsoever. Full stop. Be that as it may, comma, since it would be difficult to accommodate the petitioner's application on the online portal at this juncture, at this belated juncture, comma, it would be welcome if it would be appropriate and in consonance with law if the respondents consider the representation given by the petitioner manually on such score. Full stop. Accordingly, WPA 23532 of 2023 is disposed of by directing the which respondent SDO? By directing respondent number 3, the subdivisional officer Kollani, to consider the representation stroke application of the petitioner annexed at page 16 of the writ petition and to convey his decision to the petitioner within October 16, 2023. No address to cause urgency.
And DBO.
9.
Durga Puja permission matter, my lord. Private land. Only thing is online. We have no
Is
access.
it necessary for private land? I mean, permission is necessary.
School's land, my lord.
But we have no objection.
School's land, my lord.
We have no objection from the
Private
school.
land does not mean your land. I mean, private land of somebody else.
Yes, but we have no objection from the landowner.
But the problem is, my lord, with regard to that online application.
Yes, my lord,
New for the first
take
time.
up this one. Yes.
First time.
Permission for the
Same
first
order.
time. We have been organized.
May I let it kindly go through?
Oh, yes. I'll set aside this. Thank you for handing up. I was wanting this.
No, no, that is, I am just mentioning something, my lord, which is not at all required to be.
Policy decision. Oh, this is not that memo.
No, no, no. Only things is that,
I
my
was
lord.
looking forward to getting that memo. That's a palpably bad. Very good. Learned counsel for the petitioner contents that the petitioner, comma, with due permission from the true owner, comma, is seeking to organize a Durga Puja this year on the land of the said owner. Full stop, next para. Although under normal circumstances, comma, permission is not necessary as such, comma, the petitioner, comma, for abundant caution, comma, has sought such permission from the authorities to avoid any unnecessary complications at the time of holding the puja. Full stop, it is further contended by learned counsel for the petitioner that although the petitioner has been holding Durga Puja on previous occasions, comma, no permission as such was taken previously. Full stop, next para. Learned counsel for the state hands over a copy of a communication by the inspector in charge of the Egra police station indicating that that the police station has no objection to celebration of the Durga Puja. Full stop. However, comma, it is stated that there has been no online application on the part of the petitioner. Full stop, next para. Be that as it may, comma, since the petitioner seeks permission, comma, the mere technical requirement of an online application need not be pressed too hard, full stop. Accordingly, WPA 23618 of 2023 is disposed of by directing the respondent number 4, the subdivisional officer, Egra subdivision, to consider the petitioner's application for holding a Durga Puja as per the petitioner's request, comma, annexed to the writ petition, comma, within October 16, 2023, and immediately thereafter to communicate the outcome of such decision to the petitioner.
Lordship.
Thank you. No orders to cause.
Grateful.
Next two matters are identical.
Private property.
10.
Everything identical.
Private.
There should be puja. What is
Same order in both.
Lordship.
Thank you very much. But have a talk with your, with your client, regarding this blanket sort of a ban.
that a new puja?
I don't feel any of you are agreeing with that, but since it's your client's decision, have a talk with your client. Can you do it blanket fashion, in a blanket fashion? No new puja. Case to case basis, definitely you have the right to reject. Have a talk with your. এটা কোনটা হলো যেটা দিলাম 10 এর মতো হবে
9, 10, 11.
9, 10, 11 same
Identical matter.
11 এ কি আছে?
11 এ কি আছে?
11 who is for the state. Find out somebody for the state. You are for the state, yes, give your name.
Mr. Galib could always.
Open invitation.
Open invitation. We have served and notice has also been given for urgent mention.
সবকটাতে affidavit of service filed to be kept on record. File your affidavits of service and all.
Deeply.
Thank you. Yes.
Upgraded matter item 12.
Yes, what is your
My lord, I am for the petitioner's affidavit of service, my lord.
good service?
Yes, my lord. My lord,
You are not so sure.
I served on 5/12/2019.
Where is the track report?
Due to
Where is the track report?
the tag report has not been collected from the cyber crime.
Do that. How can there be an affidavit of service without the track report?
My lord,
Cause of action.
only consideration, my lord, a representation, my lord. My lord, my father was a agricultural officer. He retired on 36/1993, my lord.
and died on 24/8/2010, my lord. I made representation regarding the deposition of money of United Bank. Now it is merged on Punjab National Bank, my lord.
What do you want in
And
the
Fiji-
representation?
yeah,
What are you asking for?
I am asking, my lord, the account, my father's account has been closed. I wants to regarding the account number. Why it is
Yes, sought
closed?
for information.
Yes, my lord, I made RTI, FD and TD policy.
There is a forum for that.
My lord, the bank, the bank of branch Khakurda, my lord. My lord, representation 27, my lord. Page number 27, my lord.
You have remedy under the RTI Act.
My lord, I want how much money. has
Representation
been
at page
deposited.
27.
Yes, my lord.
25 is the last page.
24, my lord. 24, my lord. Page number 24, my lord. Only information on how much there are. I am a I am suffering from financial crisis.
Learned counsel for the petitioner submits that the petitioner is suffering from financial crisis. Which of the petitioner sought for the details regarding the bank account of his deceased father. Full stop. However, no response has been given by the respondent bank. Full stop. Next para. The affidavit of service filed today be kept on record. Full stop. Although there is no indication that service has yet been completed, in view of the innocuous nature of the prayer, the writ petition is taken up for hearing. Full stop. WPA 22110 of 2019 is disposed of by directing the respondent authorities to consider the representation of the petitioner annexed at page 24 bracket annexure P7 bracket close of the writ petition within 3 weeks from date, and to intimate the outcome of such representation, consideration to the petitioner immediately thereafter. No address to cause urgency.
One indulgence, my lord, I will be seeking in
Yes.
respect of item number 11. My lord, I appear back to appear with the state respondents. My lord, I have with me the reports.
Name
Followed-
may also be included.
My lord, Durga Puja, regarding Durga Puja, my lord, holding of Durga Puja, they have applied to the wrong, my lord, portal. My lord, I have with me the,
Written application করলেই হবে।
my lord, I have with
I have
me the-
directed you to consider the annexure and consider that, and
my lord, they have to, my lord, they have to apply before, my lord.
you have
the-
annexed your representations to all. Consider the representation from the annexures. Column
Lord,
next.
the-
13. Whoever is appearing with you, please give your names. Yes. Next. 13.
My lord,
Yes, Mr. Manna.
my lord, a petitioner before your lordship, my lord, he purchased the land.
I'll impose personal cost on the advocate if such annexures are. Particularly if the advocate is you, Mr. Manna. What sort of annexure is this?
No, it is not.
It's a blot on your career.
Only this, my lord, it record, it's a record.
Yes, what do you want?
Record, my lord, I want, my lord, the deed was not released by the registering authority, my lord. And
You have to pay money for that. You have paid the money.
my lord, the usual order, my lord, kindly come to me. Earlier order passed, similar order, my lord.
No. They are saying that there is deficit stamp duty or that the stamp.
Deficit stamp duty, I will pay. I'll pay, my
Then
lord.
why did you file the writ petition? Pay the deficit stamp.
Until order of they are not taking step. My lord,
My
this-
lord, if they pay the deficit stamp duty, we will release the.
lordship kindly, the same similar order, lordship kindly pay 30,
You're
20.
citing a judgment for this.
No, judgment, no, it is usual order has been
This
passed.
is a
my lord.
part of the.
Several order was passed, my lord, by our High Court. Page
Mr.
27.
Manna, in those matters, the order which was annexed here, there was a dispute raised by them. They say that the stamp papers were forged.
My lord, exact similar, my lord, exact similar to all.
Your stamp papers were also forged.
No, that is another point. Stamp.
That is the only point.
No,
All
only
the
point-
previous judgments, orders which are passed by us, the usual order, as you say, all the courts are passing. When there is an allegation that
No,
the
only
stamp
this-
papers are forged, Mr. Manna, you have to put in this money equivalent and then they register.
Lordship,
What lordship?
This order was passed, my lord. Similar, my lord has been saying, page my lord 27, passed by on my lord is Devasi.
What is your instruction? Why are you not giving it? I mean,
My lord, they have not paid the stamp duty, my lord.
Stamp duty, my lord, the forged stamp supplied by the vendor.
that is what I'm asking you. In your case also, the stamp papers are forged.
Yes. Stamp paper forged supplied by the stamp vendor.
Lord counsel for the petitioner submits that the petitioner submitted a deed for registration. However, the registration is not being granted on the ground that the stamp papers on which the document was executed are forged. Next para, learned counsel submits that the petitioner is agreeable to put in the cash equivalent of the amount of the forged stamp papers. Next para, learned counsel for the respondent submits that in the event the petitioner deposits such amount, there is no impediment on the part of the respondents to register the document and hand over the same to the petitioner. Accordingly, WPS 6097 of 2023 is disposed of by directing the petitioner to deposit the cash equivalent of the allegedly forged stamp papers on which the deed in question was executed. Upon such cash being deposited with the registering authorities, the respondents shall complete the registration and hand over the registered document to the petitioner, preferably within 3 weeks from the date of deposit of such cash equivalent by the petitioner. No address to cause urgency.
Much obliged with your kind leave, my lord.
My lord, the other
14.
Other 3 matters same.
Other 3 matters, so many matters.
14, 15 and 16.
To pay some commission to the advocates benevolent fund for so many matters, moving so many.
Affidavit of service.
See, up to which matter, up to which item?
Up to 16.
16, Lordship.
Same.
Same.
You are appearing for the state.
And for the state in item number 14, Lordship.
Appearing the others also. No, is anybody engaged? Otherwise, I'll regularize your appointment. You are in 15.
14.
14. 14 same order হবে. Are 15 and 16 also same order?
Same order, same order.
15, 16 same order হবে, শুধু 15, 16 এ প্রথমেই একটা লাইন অ্যাড করে দিতে হবে। ওনার নামটা দিয়ে the appointment of learned counsel for the state, Ms. Omuk, be regularized by the state.
Grateful, Lordship.
Thank you. Thank you.
Affidavit service.
17.
Please, your lord.
Yes, Mr. Bhattacharya.
This matter was taken up yesterday.
Good
Someone
service?
wanted, yes. Someone wanted to take an adjournment.
Oh.
There are 2 affidavits of service.
Appearing on behalf of respondent number 3, FCI.
3?
Yes.
Achha. FCI is the main.
No, state.
No, sir. No.
It will retain its position. I'll record an order. I'll keep it on Monday then.
The only thing is,
Yes.
what has happened here? What is the immediate urgency?
If there is good service, then move the matter.
What is the urgency is, I respond to a tender floated for construction of a godown. I have to give a godown for storage of food grains only, nothing else. I participate in the process. Now, since I was obliged to complete the construction of the godown within a time frame indicated in the scheme and in the tender, they extend the time. I admittedly, there was some goof up, I could not complete. There was inspections done. Ultimately, in the year 2019 January, they said everything is in order. Now, after that, when I offered the godown, it is in terms of a particular scheme. The scheme is known as Private Entrepreneurship Guarantee Scheme, PEG scheme. Now, under that scheme, I have to, the tender was floated and I had given that godown. Rightly, wrongly, they in the year 2020 said that since you did not do it within the time earmarked, the entire thing is cancelled. Whatever was, I am the lowest bidder. That is cancelled. In terms of the scheme, every month they are going to give me as rent an amount not exceeding a few lakhs. Or the go down. This is in Golshi area. Now FCI floats a fresh tender, invites a fresh process. In that, Milan, I offer the go down because of the earlier cancellation. This now becomes interesting. Milan, please come to
Page
128. This is by the FCI, Food Corporation of India. This is written to the Divisional Manager, Food Corporation of India, for verification of PWS Godown at East Bardhaman having same address and capacity as PEG Golshi. It is to inform that the technical bid of the tender for hiring of godowns at East Bardhaman, which was floated on 24th June 22, has been opened on 15th July 22. On one participant, namely my client, has participated and offered a 10,000 metric tons covered capacity at Golshi. From the tender documents, it has been found that the address and capacity of the said godown is the same as those of PEG Golshi, which has been surrendered by the Food and Supplies Department, Government of West Bengal.
Actually, the self-same godown.
Yes. It was decided in the 59th high-level committee dated 1st June 2022 that the fate of PEG Golshi is to be decided by the state-level committee after examining possibility of its utilization. Hence, before proceeding further, it is requested to check, verify and confirm if the godown proposed to be hired through PWS and PEG Golshi are same or not, and furnish the information to this office at the earliest. I do not know the outcome. Now, apropos this, when I write to them that take my godown, you are saying that it is to be utilized and give me my rent. They are now writing, the job page 133.
One 133 এটা কিছু করতে পারছি না ভাই এটা
I do not know if it is
my copy is already only FCI's copy is apparently
my copy is also
deliberate misnotice.
No, but it is relevant because apropos my representation claim for rent towards 10,000 metric tons the Director of Storage, Food and Supplies, Government of West Bengal, in reference to the subject mentioned above, undersigned is to inform you that this office already conveyed you the decision regarding cancellation of the guarantee which had been given to you for hiring 10,000 metric tons go down at Golshi in Purva Bardhaman district under PEG scheme due to delayed construction even beyond the allowable time period, and also requested you to make further communication in this regard to the FNS Food and Supplies Department. You are therefore requested once again to act accordingly in this regard. Now, this is dated 23, and then again the next letter which is also written to the client also saying the same thing enclosing 19 now the food and
there was a delayed construction of the godown.
I'll show your lordship the impugned cancellation. It is apparent
cancellation of the guarantee is there. So what do you want now?
Now today they are
the construction is complete,
everything is complete.
Yes.
It is in order.
Right
now when I am offering it to FCI apropos of fresh tender, FCI says that it is yet to be released by the Government of West Bengal. Please come back to 128 once again. Last but one paragraph, it was decided at the 59th HLC on 1st June 2022 that the fate of PEG Golshi is to be decided by state-level committee after examining possibility of its utilization.
So you say either utilize or give.
Oh, yes, kindly utilize my godown. And the rent, which because apropos this, there is some hope and expectation generated. If I may say so, I do not want to.
Do they have any claim against you?
No.
Otherwise, they don't have any.
No.
Cancellation was the
cancellation is 2020.
Right. Yes, Mr. Bandhavata, what do you say?
Yes,
yes.
If your lordship kindly, first come to page 98. This is the tender notice.
Yes.
Letter of acceptance out of the tender notice. Can I take the second paragraph, Mulad? The time for completion of the entire work of the godown and its ancillary works is 12 months from the date of issue of this letter. Thereafter, Mulad, if your lordship kindly takes page 109. Well, they made a request to us that the construction, last paragraph
I'm sorry.
of 109.
Yes, 100.
The second paragraph. Therefore, construction period is allowed to me 1 year plus 4 months as per the clause 5(4). And also I request your good self to be given one additional 1 year to construct as per clause 31, and which will be highly grateful to so and so. So, Malad, they prayed for an extension before us to construct the godown. Now, Malad, this extension was granted, Malad. Malad, perhaps Malad, the pages.
Page 106.
My pages are not telling actually.
106.
109 did not tell you.
A bit faded, Malad, the top part of my brief.
10
P9, P9.
109 did not tell you.
P9 and P10. Kindly see P9, P10, 105 and 6.
P9.
6, 7,
Page
2008.
105, 105.
105, yes. Yes, 105 says that.
Well, this extension was given.
Extension was granted, yes.
Yes, Malad, kindly see Malad, the terms of the extension. That with reference to the subject and letter mentioned above, I am to inform you that as per clause 31 of the so and so, the period of construction of PEG godown, which is maximum 1 year for non-railway siding godown, will include 120 days time granted for production of documents for acquiring land. Further, as per the same clause, delay is allowed up to a maximum 1 year with corresponding reduction in the guarantee period. You are therefore requested to expedite construction process to avail the benefit granted during this period. Now, Malad, then Malad will kindly take P10, that is 106, very next page.
Yes.
Second paragraph. Further, it is to be noted that if the godown is not completed within 2 years from the date of issue of the letter of acceptance to you, taking over of the godown will be done as per the decision of the HLC FCI in the 47th meeting dated 29th April 2016.
This is taking over by you.
Taking over by me. This period is long gone.
Gone.
This admittedly, this period is gone.
The guarantee was also cancelled for that.
Yes.
Yes.
Page 120, 119.
They are saying now take a decision, either release their godown or use it. That is what they cannot offer it to others also because the FCI tender is there.
Malad, if your lordship kindly takes Malad 119, which is the impugned letter. Malad, that clearly says that
cancellation of guarantee.
Yes, cancelled due to the delayed construction.
You are not challenging that cancellation. You did not challenge that cancellation.
I have.
Yes.
But
I have.
You have challenged it.
I have. 100% I have.
They have challenged that.
I have. But, my lord, since page 128 says that the cancellation, my lord, I am in a, my lord, if I may be permitted to, my lord, use this word, my lord, limbo. My lord, I do not know whether it has been cancelled or whether they are minded to utilize it.
No, they have cancelled. There is no doubt.
They have, but thereafter, my lord, page 128 says something otherwise. 128.
128. This is.
Sir, I'm
two-
giving you
No.
128. What are you challenging then? You are not sure.
But I am saying that please utilize my godown or else release my godown or do something about it, because when I am offering it to FCI, the FCI says something else. It says
So you
it
see,
was,
even if the cancellation of guarantee is there,
but despite
that
it
you
is
can
still-
release it. Yes.
Yes, they are still holding on to it because it says it was
So you
decided.
are no
at-
longer challenging the cancellation. That
if- if
cancellation
the-
challenge remains.
If the
If the
godown-
challenge remains, then I'll keep the writ petition pending on the cancellation and I'll ask them, Mr. Bandyopadhyay, whether they can release it subject to this adjudication. I mean, they need not keep the godown with them.
কি করবো বলো, exact instructions কি?
I think that would be better.
No, let it be kept pending, yes.
Mr. Bandyopadhyay, even irrespective of the challenge to this cancellation, which remains in the writ petition, can you release the godown? I mean, is there any other embargo?
Malad, we have Malad forfeited the security deposit.
Yes, exactly.
And Malad, thereafter, Malad, what they Malad,
So they are wanting for release of the godown so that they can offer it to the FCI.
When I have offered it,
in
this
my
is the-
understanding, this itself releases the godown, Malad. This interpretation of the petitioner, Malad, is not.
No, it is not my interpretation.
I can record that, Mr. Bandyopadhyay.
Malad,
Nothing remains.
Either I record it in your version or my version. I mean,
yes, Malad, what interpretation they give, Malad, that is not in writing before me. But Malad, in my understanding, when the guarantee
apparently, yes.
is cancelled,
You have done whatever you had to
yes,
do.
and that has to be, Malad, even if we read it with the clauses, Malad, 9, 1 and 31 and 32, That will
So
not.
in the interregnum,
31 permits them to cancel.
I'll observe that by virtue of this cancellation, I mean, there is nothing to show that you have any, there is any other embargo for them to offer it to the FCI.
Yes.
That will observe.
Separate.
Separately means now, this challenge remains to the cancellation that will be decided on affidavits. I'll direct you to file. But in the meantime, they can offer the go down to the FCI.
They can, we are not utilized.
My lord, what Mr. Bandopadhyay is perhaps missing, my lord, just to assistance of the court, my lord, page 128 kindly returns once.
Yes.
It was decided at the 59th high level committee dated 1st June 22 that the fate of PEG Golshi, that is, my lord, the go down which has been, my lord, the guarantee has been cancelled, is to be decided by state level committee after examining possibility of its utilization. My lord, this is troubling the entire thing. This is not my letter. The FCI's assistant general manager is writing to the divisional manager in the department.
See, the moment, Mr. Bhattacharya, you say that I want to offer it to somebody else, you are not pressing you're not going along with your offer.
100%.
So that will be
I have
totally-
already, my lord, irrespective of the writ petition, I have already exercised it.
Of course.
By virtue of a fresh tender floated by FCI, my lord, which is page 128, the second sentence.
The cancellation of the guarantee that is set aside ultimately. What happens? What
That
is
is-
the fallout
outcome
of that?
is, my lord, the balance period. I have indicated in the writ petition, my lord, the obligation was 10 years guarantee they would have taken 10 years. My lord, this go down would have been utilized by the state.
Suppose this cancellation of guarantee is set aside by me.
Ultimately,
What happens?
it is set aside after 5 years. Let us assume, my lord, 5 years gone. The balance 5 years I am going to get. That is the.
Now you're offering it to the FCI now.
Now, my lord, if it is.
So then your challenge goes.
Not if it is, if
Either your writ petition goes as a
I have already offered it, and if I have already offered, it is not the question of
you offer it to the FCI,
I have taken the cancellation to remain.
then the entire writ petition becomes infructuous. If you insist on that, I'll say that the writ petition has become infructuous because if you now offer it to the FCI, if you give it to the
I
FCI,
have already offered. If
the outcome, whatever may be the outcome, there won't be, it will be toothless outcome.
Not this probably, as per my understanding, taken over by FCI as a step with regard to the state before that, which sees that it is in compliance of the FCI requirement.
They have no authority.
That is their headache.
Yes, that is, but my lord, if your logic, while they concern, my lord, if your logic kindly takes the clauses as far as the state stance is concerned, my lord, only 3 clauses, my lord, relevant portions only I will face. My lord, kindly takes 9(1) at page 46. And the continuing portion of 9(1) at page 47.
47.
47 kindly takes from 1, 2, 3, 4, 6th line onwards.
Right.
Starting with in case.
In case, yes.
In case the go downs are not completed on the specified land mentioned by the tenderer in the tender and handed over within the scheduled time or any condition of this contract are breached, the security deposit will be forfeited and the guarantee given for such hiring of the go down will be cancelled. Then skips over one line, the right to forfeit of the security deposit as well as to refuse the takeover of the possession of the said go down on guaranteed hiring for 9 years if the same is not leased out to the director of the storage. Then kindly take clause 31 at page 54. 31 at 54. Kindly take again the 6th line at clause 31.
The delay.
6th line starting from the delay.
The delay?
The delay in construction of maximum up to 1 year may be allowed to the tenderers on their request in writing with the corresponding reduction in the guarantee period. So if they take 1 year more, 1 year of guarantee period, then the last line of that, last sentence of that clause, in case
the
go down is completed in the extended time, the director of storage will have the discretion to choose the date of taking over the go down within 3 months of completion. In case of delay beyond 1 year, the agreement is liable to be cancelled, and it is further added that the tenderer would be liable to be cancelled in case so and so. Then next page, clause 32. The director of storage, food and supplies department, government of West Bengal reserves the right to refuse to take over the said go down on guaranteed hiring for 10 years if the construction of the go down is not completed in all respect and leased out to the director of storage, food and supplies department by extending the date, and in that event the security deposit of the tenderer is liable to be forfeited. So my lord, once this impugned
They have
letter
to,
is given,
they have to waive every right, every challenge.
yes,
If
so
they offer it to
once this
someone.
letter that is impugned, that I thought was impugned, page 119, once this is given, well, this relationship is terminated then and there, along with forfeiture of the security post.
But the difficulty is if they win in the writ petition on the challenge against that, then it revives. Then what will happen? I mean, then the interim order cannot be given to them for offering it to the FCI.
Well, either they get it for
kindly-
the remaining period.
Suppose they win, your cancellation of guarantee gets set aside. Then the thing revives. Then you'll have to be offered the takeover of that.
On instructions, I
You
am
won't be able to do that because you'll be giving it to the FCI in the meantime. So it cannot go together. Either
instructions, I am submitting this without prejudice to my rights and contentions, not in the writ petition. I have to, I am starving because, for the construction of the godown, I had to, incur loans and everything.
you
Bank
cannot
is
use the
running
godown as
after
a
me.
kumit for FCI as well as a state. Either you stick to your challenge.
No,
to
I am state. My instruction is I am challenging the action of the state, which according to me was
if you
completely.
win in your challenge, then Mr. Bhattacharya, the cancellation of the guarantee goes. Then the state has an option to take over.
Yes.
They cannot lose.
So,
both ways.
I want to, restrict my challenge to the cancellation.
If you restrict your challenge to the cancellation,
And the
if the
utilization
challenge
part,
succeeds, I cannot permit you then to offer it to the FCI in the meantime.
I will not.
So direct affidavits and leave it at that.
The interim order দেবেন।
So what is the whole what is the question of an interim order?
Termination interim order ordinarily is not.
Cancellation of guarantee. If you win in the, if you succeed there,
Ultimately, I succeed.
then you have to offer it to them, the state. The state gets to have it.
That is my instruction.
Not only I get to have it, it is my bounden duty to take it.
Yes.
Because that is if the cancellation of guarantee is set aside, the guarantee is revived.
The cancellation of a guarantee with regard to the petitioner's go down has been challenged in the writ petition. Full stop. Next para. Since an arguable question has been made out on facts as well as law, comma, the respondents are directed to file their opposition within, what is the time you require, Mr. Bandavate?
My lord,
24th November. 2 weeks after.
maybe 3 weeks after vacation.
No, I am on the street. I am on the street now.
No.
I offered it to them without even throwing a challenge. Kindly visualize my situation. I offered it to FCI.
Come back within 24th. He's on the street. How can you deny him?
2 weeks, 30th. 2 weeks is 30th.
It reopens on 16th.
16th.
Yes, right.
15 plus 14.
By November 30, 2023, reply finish shall be filed by December 7, 2023. The matter shall be listed on December 11, 2023 for hearing.
Grateful.
Grateful.
সব precedence দেবে না জজ সাহেব ছুটির আগে। My miss, he says precedence.
One Bhattacharya is enough. No further Bhattacharya.
And here we have three. Even honorable judge.
Two. No, I am speaking about myself. One is enough.
What?
So you are Bhattacharya, Mr. Arup Bhattacharya is Bhattacharya. I am speaking about the rest of you.
Grateful.
Item 4, passover matter.
Yes, ma'am. What is your matter? Moving on.
Yes, Your Lordship. Your Lordship, I am going to address on two things, Your Lordship, that I am a L1 bidder. I started my work in 2020, in the year 2020. Thereafter, I am terminated. I am blacklisted. Now, I'm address on two things. First, that the termination notice was beyond the jurisdiction because it's beyond the scope of the show cause notices. First. Second, the whole process, the whole procedure of blacklisting and termination is palpably arbitrary in nature because first, blacklisting without notice. Second, they have not preferred any provision for blacklisting. No justification. They have not referred to any provision. They have just blacklisted. Third, they have blacklisted for 3 years without giving any justification. That is all that's I'm going to address. So if I can take you through the documents.
Yes.
Your Lordship, I'm gonna take through the first show cause notice, from the first show cause notice, page 172.
One 22.
172.
72. I'm sorry. Yes, please.
This is the first show cause notice.
Right.
Your Lordship would kindly note this down. These are the months, these are the 6 months because of which I am being terminated. And I'm admitting these 6 months I have not performed up till 75%, which is the required requirement. The termination clause in the next page, Your Lordship, 173, I'm going to read through the termination clause. As per agreement of the contract, which read as falls to achieve a monthly agreed quantity of 75% for a period of 6 consecutive months or for cumulative of 6 months within a continuous period of 18 months. So I'm admitting for the consecutive 6 months, I have not performed up till 75%, because of which I'm being terminated. But Your Lordship would record this April 22 to September 22. But the date of this show cause is 15th March 2023. So I have worked 5 more months, and I will show you, Lordship, that the 5 months I have achieved the minimum quantity of 75%. Why I'm stressing this, Your Lordship, I'll take Your Lordship through the documents, but I'm stressing on the point that I have worked for the next 5 months and have achieved 75%. Thereafter, the next show cause, page 174.
Yes.
It's 24th March 2023, second show cause notice. The same 6 months they have referred.
What was the occasion for the second show cause?
That yes, exactly, Your Lordship. The second show cause, it's written last 6 months from April 2022 to September 2022.
Yes.
We have not matched the target amount. Next line, Your Lordship will see, next to next para, during last 8 days. 16/3/2023 to 23/3/2023. So they are adding additional 8 days. On the and also the next page, Your Lordship, page 175. The last para. You are hereby asked to explain within 7 days from the date of issuance of this letter why penal action vide clause 9A, 9B, which is a termination clause, as per provision of NIT, an agreement for termination of contract should not be initiated other than other penal actions. So I've been given 7 days time to give cause. Thereafter, I gave my reply, that is 27/3/2023, that is page 176. I gave my reply. Thereafter, they next page 177, it's an inquiry regarding show cause, where they are asking whether we have received the stated 2 show cause notices and the reply which we have given. This is an inquiry from their side. Thereafter, I'll take Your Lordship, page number 179.
Yes.
This is a notice for termination of contract with banning of business. So they are directly going to termination with banning of business. However, However, also they are referring to the 6 months, April 2022 to August to September 2022. Also, in the last paragraph, moreover, in the last 8 days, average coal production percentage is only 29.99. So they are considering the last additional 8 days as well. So this is the termination with banning of business. But next page, your lordship, page number 180, they're again asking, last para, you are hereby asked to explain within 7 days from the date of issuance of this letter as to why penal action, vide clause 9A, 9B, as per provision of NIT, and agreement for termination of contract. So they are asking to explain again within 7 days. Thereafter, my reply, next page, your lordship, April 3, 2023, page 81, 81. Next, we have requested for a personal hearing. Then they provided us with a personal hearing, page 182.
Yes.
Yes. So here they are like referring back the case history. First show cause notice, thereafter in response to the second show cause notice. Now here my learned friend is gonna press his objections. Lastly, notice for termination of contract with banning of business. They are referring to a different letter, 4/4/2023. Your lordship could kindly record this. This is a different letter they are referring to.
Which paragraph? Yes.
Para 4.
Right.
Para 4. Thereafter, after personal hearing, page 185, your lordship, we are being given another show cause. We are being given another show cause. Now I'm going to read through the lines. First, second para, in continuation to the first show cause notice, dated 15/3/2023, second show cause notice, 24/3/2023, thereafter notice for termination of contract with banning of business dated that show cause notice which I showed you, 1/4/2023. They are agreeing that was a termination notice. Sorry, that was a termination notice. After two subsequent show cause notices, they are terminating my contract with banning of business dated 1st April 2023, and subsequent to the first hearing, that is 6 April 2023, we would like to apprise you that you have miserably failed to keep your commitment in terms of OB removal, coal production. Now your lordship would see the table. They have waived the 6 months that they have originally taken. They have originally referred to the 6 months. They are taking April 2023 and May 2023. So my point is that they are waiving off those 6 months. They are taking this 2 new months, which are the recent months, April 2023 and May 2023. Next page, your lordship, the second last para. In the light of the above scenario, you are asked to submit a written explanation as to why we should not start the process of termination of contract with banning of business again. So they are telling us why we should not start the process of termination of contract with banning of business again. So lordship would record this, that the previous termination notice, they have withdrawn that notice. By their own conduct, they have withdrawn that notice and they have started a new process of termination by giving a show cause. Thereafter, your lordship, page 197. This is a notice for termination of contract. They have reference, you'll see the references. They have referred to first notice of termination of contract dated 1st April. This is the first notice of termination. They're referring to that notice of termination. Thereafter, the show cause. This can be considered to be again a new show cause, starting the process of termination again, dated 1st April, dated 28/5/2023, 20th May 2023. So after this show cause, they are issuing this termination, where your lordship would note they have again taken the 6 months, which they have waived off. They have again taken the help of these 6 months from April 2022 to September 2022, which they have already waived off. The last show cause, which they have started afresh, they have taken only 2 months, April 2022, April and March 2023. April and May 2023.
This is the final termination and so, and
No, Your Lordship. This is final termination. The next page, Your Lordship would see, page 198. They are referring to clause 9 of general terms of contract, termination suspension. After careful consideration and evaluation of the situation, we have decided to issue this final notice for the termination of contract with banning of business according to clause 9 of section 2 general terms and conditions, as well as other clauses of NIT, whichever may be deemed fit during this course. So they are not referring to any provision for banning of business. They're only referring to clause 9 A and B for termination. They're not giving any justification. No clause is being provided for banning of business, just clause 9 for termination.
no, they say other clauses whichever may be deemed fit,
Yes, Your Lordship.
whatever that means.
Thereafter, we gave our reply,
Yes.
page 199, where we have shown from April to February, we have shown the last 5 months where we have achieved the 75% target. So the first 6 months where we couldn't achieve the target, thereafter 5 months we worked. We achieved the 75% of target and they allowed us to work. Even after we, for a consecutive 6 months, we couldn't achieve, they allowed us. And thereafter, they suddenly gave us show cause notices. And thereafter, they've withdrawn the show cause notices by issuing a new show cause.
This 75% refers to that particular period or the 75% of the entire contract?
So the clause, section 9, the clause, it says keys consecutive 6 months or
So it's a continuing process, continuing work.
basically the provision says continuous 6 months or else
What is the nature of the work?
nature of
What
the
do you
work
do? Yes.
is a removal of coal and overburden.
So it's a continuous thing.
Yes. And
So for every period, there will be a 75%.
no. For consecutive 6 months or else a cumulative 6 months in a continuous 18 months of time.
All
In
right.
18 months, they can separately pick 6 months and they can cumulate it and say you have not attained the 75% of target. Thereafter, page 201, this is basically the imposing penalty on us of 20 crores, Your Lordship. They're imposing penalty of 20 crores and debarring us for a period of 3 years from participating in future tenders. They're debarring for 3 years. They have not given any justification. They have just in the last clause, they
What
have
is the
stated
provision for debarment in the contract? Is there any provision?
there is no separate provision, Your Lordship, under the termination only, under section 9C.
3 years is provided there or the term of
No. Minimum of 12 months.
Achha.
Minimum of 12 months.
So they have the discussion for 3 months, 3 years then. They have the discussion.
They have minimum 12 months, but they have to justify themselves.
But-
That's
Right.
written in the clause, Your Lordship.
Anyway, we'll
Minimum
find
12 months.
Very
Minimum 12 months.
Very
I'm gonna produce judgments which says that you have to justify your actions first. Note blacklisting without notice is not permissible under law.
Several
Second,
notices were given, but you say the previous ones are waived.
withdrawn. Because I showed Your Lordship the 6 months which they were
The ultimate termination is for a period which was waived. There shows for that period.
yes, the ultimate termination which they were referring to the 6 months that is actually waived. Yes, the show cause notice was for only 2 months, that is April and May.
Yes. That is what I'm saying.
Yes, the termination is basically
Yes,
beyond
yes,
the
that
scope
also,
of-
right.
Huh. Basically, Your Lordship, lastly, page 203, that's the final measurement that they took. But final measurement, but before that, they have already debarred us for 3 years. Before taking final measurement, only they have debarred us. That is basically all the documents that I'm gonna show Your Lordship. My 2 points, which I've already taken before, is that first, as my learned senior friend mentioned that the termination is beyond the scope of the show cause notices because the show cause notice only prescribed 2 months, April and May, but the termination is basically for the 6 months, last 6 months, which they have already waived. So it's wholly beyond jurisdiction, Your Lordship. The second is blacklisting, Your Lordship, without notice. They have not given any prior notice.
One of the notices was for blacklisting also.
No, that's with termination.
Yes.
That's with termination. They are just banning business along with termination notice. They are not referred to any provision in
The last show cause, there was no reference to banning.
This one line.
185 is the last one. That for 2 months, that termination notice. With banning
No,
of business was
185 is the show cause, the last show cause.
185 is the last show cause. There they referred it at page 186. They referred
Yes,
to the
we will start the process of termination as well as banning of business. They
banning
will start.
also. Banning is
Yes.
also included. So that is the notice for show cause.
They have just mentioned one line where they are stating they will start.
The ground of banning and termination are same, or banning requires some extra grounds. As per the contract,
As
banning
per
and
the
termination
contract,
same ground.
In the same provision is being mentioned just one line
Right.
that they can be banned, they can ban us for a
So
minimum.
this is
of
the
12
notice, show cause notice for banning. Page 185 refers to banning also.
Your Lordship, can you, page number 81 of the writ petition, Your Lordship?
81.
81.
Banning would only be the contractor without reasonable cause or valid reason commencing the execution of the work in the aforesaid the company should. In addition, the department shall be at liberty.
Yes, page number 81,
6.1.
clause 6.1.
Hmm.
I'll just read out the clause, Your Lordship.
Hmm.
If the contractor, without reasonable cause or valid reason, commits default in commencing the execution of work with the within the aforesaid date, the company shall, without prejudice to any right or remedy, be at liberty by giving 15 days notice in writing to the contractor to commence the work, failing which they can forfeit the earnest money. In addition, the department shall be at liberty to debar the selected bidder from participating in future bids for at least 12 months. Yes, Your Lordship.
Yes.
So this was the clause for banning of business, but they have not referred to any provision. Your Lordship could see in the show cause notice as well as the termination, they have not referred to any provision.
Right.
Without referring to any provision, without giving justification why we are being debarred for 3 years, they have just noted one line. That you will be banned for 3 years. And also in the show cause, they have stated one line that we will start the process. But the process has no justification, Your Lordship. The
Right.
process does not mention any provision, neither does it mention why we are being debarred for 3 years. Also, Your Lordship, the first person hearing was after the first set of termination. Thereafter, we were not given any person hearing. Like after the new show cause notice,
But
where
they gave you replies to the show cause.
yes,
Give you replies to the show cause.
we have just given a reply.
To the last show cause also you gave a reply.
Yes, yes, Your Lordship. I showed Your Lordship the last
Very
reply.
well. Yes.
Page 199.
Right.
So we have just given a reply to the show cause notice. We were not given any personal hearing.
Let us hear Mr. Ghosh now.
Your Lordship, can I place 2 judgments, Your Lordship? The first judgment, Your Lordship, of this Honorable Court, Calcutta
Yes.
High Court. Your Lordship, para 13 and 14, Your Lordship. I'll read once, Your Lordship.
Yes.
A show cause notice must essentially disclose the charges upon the person entity to who the notice is being addressed, and must also afford a reasonable opportunity to the person to reply to the charges made in the show cause notice. Thereafter, reference has been made to Gorkha Security Services. The necessity of a show cause and the consequent opportunity to the person of a hearing assumes importance in the context of the punishment to be suffered by the person for who the show cause notice is intended. Now, para 14, in the present case, the letter of 8 March threatens the petitioner with debarment for a period of to be fixed by DVC. Hence, the requirement to give a detailed show cause notice becomes even more imperative. In our case, since we are being debarred, so a show cause with a more detailed explanation, the detailed show cause has become imperative, at least in our case.
Details were given 2 months.
No, in the show cause, no details were given, Your Lordship.
185. Page 185.
How many months they were planning to bar us to third condition?
186, Your Lordship. They're just referring to one line.
6 is a continuation of 185.
Yes, yes.
185 refers to 2 specific months and
Yes.
the target and all.
Yes,
So
they are
particulars were given.
particulars were given.
You are
But-
saying no details were
but-
given?
See, but Your Lordship, these are the 2 months that they're referring to. They're 2 months. They're not even taking any provision why we are going to get terminated, because under clause line, it's either cumulative period of 6 months in a continuous 18 months or else a continuous 6 months. So continuous 6 months they have waived.
So this is 2 months only.
2 months only, and they have not referred to any provision for termination also. And also, your lordship, they will start the process of termination of contract with banning of business again. So the number of months they are not mentioning here. So it's not a detailed show cause notice as to why we are going to get debarred.
Yes.
So I'll continue with the judgment once, your lordship.
Yes.
From where I left.
Arguing very well. Continue, but be short.
Yes.
Just the relevant portions. Yes.
Okay. Should I then refer to Gorkha Security Services?
Do
once?
it. Read this part.
The Supreme Court stressed on the necessity of compliance with the principles of natural justice with reference to the person against whom an action of blacklisting is sought to be taken on the rationale that blacklisting entails civil death and is stigmatic in nature. In UMC Technologies, the Supreme Court strongly opined that the first principle of civilized jurisprudence is that a person against whom any action is sought to be taken or whose rights and interests are to be affected should be given a reasonable opportunity to defend himself. The Supreme Court proceeded to hold that the notice to be served on the person should clearly mention the grounds necessitating action and should also specifically mention the penalty proposed. Mention the penalty proposed and should prescribe the grounds on which the action has been taken. So this show cause doesn't mention the provision on which termination is being made or why we are being debarred. Your Lordship, should I separately show Gorkha Security Services? Or
You like, you can. Yes. Give the relevant paragraphs. And
no, Your Lordship, I won't show it. But I will show one.
don't go by your seniors' advice.
No.
Do whatever you want. But be short. Be precise rather.
Okay, then I'm showing Gorkha Security
Very
Services.
well. Gorkha has been
Yes,
referred
it's
to
been
here.
cited. Both UMC and Gorkha has been cited.
Yes. Mr. Ghosh knows by heart. Don't give it. Unless it's unreported. Yes.
No, sorry.
Oh, Gorkha, sir. You are citing Gorkha. Which paragraphs?
Paragraph 16, 17, and 20, Your Lordship. Should I read it to Your Lordship?
Same thing.
Same thing, Your
Yes.
Lordship. Same thing. So I won't press
But
much.
here, please come to para 20, something which may go against you because you also hinted that no hearing was given to you. Here it's observed that oral hearing is not necessarily to be given.
Correct.
Something like that. We may also hasten to add that once the show cause notice is given, an opportunity to reply to the show cause notice is afforded, it is not even necessary to give an oral hearing. So that there goes your oral
I'm not
hearing.
pressing that paragraph,
No,
Your Lordship. I'm not
obviously not.
pressing that paragraph.
You cannot. I'm pressing that part.
This, I got surprised she showed.
Apologies, Your Lordship.
No. Don't do it. So let us hear. Yes, Mr. Ghosh. Very good argument.
Very well argued. Extremely well argued.
Match her. Otherwise, she wins.
No, not at all. Milord, contract for excavation.
What is going on in the ECL, Mr. Ghosh? So many show causes.
Milord,
It has become a bad habit. 5 show causes, 4 show causes for this.
Because Milord, they are very Milord now.
One new
skeptical.
officer comes and a new show cause.
They're skeptical before terminating. They give them enough chance to do the work, Milord. Because getting a contractor today's and Milord, with deepest of respect, Milord.
But you waived the previous ones in the second last.
With deepest of respect, I'm sure.
Deepest of respect to your officers.
Yes.
Abuse your officers with deepest of respect.
Yes, kindly Milord takes Milord page 182 once.
Yes.
I'm sure my learned friend must have it a copy the Amar copy. Other side copy. Other side ke dao.
182 is that hearing or something like the
Yes.
questions, queries were.
Yes.
Yes, right. You're right.
Judge সাহেবের copy এটা
That was in the previous show cause.
kindly Millard takes Millard this Millard the important page Millard the page number 2 should have not have been Millard suppressed at all. I'm sure Millard it missed my learned friends Millard. May I just read it Millard?
Acha, yes.
Millard, show cause notice. I have given elaborate Millard show cause. It's elaborate. Millard, I have Millard banned him. Millard, 5 years is permitted by a contract document called CMM, which is referred to in the tender document as clause 63. 5 years.
Because the page 185 notice is the last notice.
Yes.
There you have the notice previous to that you have said again we'll start it all over.
Yes.
So then you waive the previous ones.
Well, I need not because Millard, it's Millard. This is Millard. What is Millard? Not Millard shown to your lordship. Kindly Millard have Millard.
Yes.
All Millard is kindly Millard have Millard. Question number 11. This is Millard very important. I also asked them because this is not part of the writ petition.
This is like an examination sort of.
Yes.
Read the question.
Yes. Please pen down your thoughts regarding the future course of action regarding the project.
Pin down their thoughts. How can you pin them there?
Kindly Millard, it should be say how do you want to proceed? Millard, whatever the deficiency are, I'll do my best to rectify it and improve the managerial skill so that the hired patch runs smoothly and the production will be achieved. I want to add here that currently our maximum machineries are under breakdown due to lack of proper maintenance. So it's an admission, Millard. In the meantime, I will also set up the required manpower according to the mining conditions to be deployed. Machineries will run 24 hours into 7. So Millard, till then it was not running. I will also want to ensure that I will deploy the exact number of machineries as per NIT. Apart from that, I will ensure that no condition regarding the validity of the diesel will arouse in coming in future. Lastly, I want to state that we would like to start production from April 25, 2023 and will give my level best to achieve the target production given by the company. If I have failed in producing the coal and removing of overburden as per the target given, then the management is free to proceed in continuation of your above letter dated 1st April 2023 for terminating the contract with banning of business. The same will be accepted by me. This was not disclosed in the writ petition, Millard. Obviously, there will be no cause of action if it is disclosed. This is Millard, not Millard, part of the writ petition. This is on a Millard personal hearing. It's a stage, Millard. I have faced you with ECL and Coal India, Millard, hearing not given, nothing done. But here, Millard, you dot down the, I say, Millard, because one has to see, Millard, how the thing progresses. Millard, all Millard, I can place the entirety, Millard, the default, everything, guilt, everything is admitted. Today, the contract is terminated. Millard, there's a provision.
Because there is one difficulty on your part.
Yes.
On 6th of April, they say this.
Yes.
That if I fail to do this and that, then you are free to proceed in continuation with the previous letter, 1st of April.
Yes.
Now, even after that, on 28th of May,
Yes.
you give a show cause notice to them,
Yes.
where you do not proceed on the basis of that 1st of April.
Yes, I do not. I proceed
If you don't, then you waive this right. They have given you the right, you fail to.
Millard, kindly, Millard, appreciate.
They giving you the right
Yes.
does not mean that you have asserted that right.
That's Millard, now Millard kindly takes Millard. Millard, what is the nature of waiver? Millard, I have to give them a notice. I have adequate, that can be adequate. I give him for better protection. Millard, today, Millard, a person coming and say, Millard, crucify me on the basis of a notice. He admits the guilt. Today, Millard, he is banned for 3 years. What is the banning under the contract?
But you don't crucify, that is the difficulty.
No, I Millard.
You don't give a notice, you don't rely on that.
Yes.
You only had to just say that I reiterate 1st of April thing.
Absolutely.
And along with that, these 2 months also you have not acted.
Yes.
You don't do so.
Yes, I give
So
a
the
fresh
entire
notice.
process has to be set aside.
Millard,
Start with the new officer, new everything.
Millard kindly appreciates one thing. Millard, banning of business, Millard. This is Millard admission, Millard. It's a gross suppression. This letter, Millard, in all fairness, should
Provided it has a bearing on the.
Of course, Millard. If someone comes forward and say, Lord, comes forward and says, Millard,
They come forward and say, crucify me. You don't. Later on, you cannot ask again that let me crucify you on a different
kindly
thing.
take Millard to page 185 notice, Millard.
I'm there, yes. I've kept it open along with this.
Yes, absolutely. Kindly takes page 185. Kindly
Yes.
have a look at page 185. Millard, today, Millard, what is the banning? Millard, the banning order under the ECL is what, Millard?
that my lord, ECL will not enter into the contract, only ECL, not my lord, other coal companies or Coal India. This is my lord, the purport of the banning order. It's not that the banning order, my lord, which is shown, my lord, a blacklisting, that my lord, it results in a civil death.
ECL is not an ordinary employer, sir.
Yes. Kindly, my lord, takes my lord, the show cause notice as page 185, my lord. Kindly
85,
have a
yes,
look at it.
185.
My lord, in continuation of the first show cause notice, the company by the general manager Sadgram area dated such and such, second show cause notice dated 24/3/2000, the notice of the termination banning with effect from 1/4, banning notice dated 1/4/2023.
You do refer to that.
I do refer to it. And the subsequent first personal hearing recorded vide on such 6/4/2023 at the office of the undersigned. We like to appraise you that you have miserably failed to keep up the commitment in terms of the coal removal and coal production of the Nimcha, OCPAT, etc. percentage. Millard, I have given the fullest particulars. Now, Millard, hard judgment, Millard, in Gorkha Hill Council, Millard says, Millard, no personal hearing. What personal hearing would I need to give? Kindly have, Millard. Lordship is absolutely correct, and this is what was troubling me, so it's marked in my brief.
Which one?
Which Lordship fell? He gives a notice and say you proceed on 1/4/2023, and you give a further notice. This is what thought me, so it's marked in my brief. So, Millard, I wanted to show that portion. So, if that be the case, if he admits, Millard, facts admitted need not be proved. Everything is admitted, he is beyond schedule. Today, the contract is terminated. I only say.
Why did you, who asked you to give this table? I mean, this table says something else.
Millard,
This belies your previous paragraph. That's
Millard,
the
kindly
difficult.
takes, but it's in continuation. Everything has to be read together. He's under, Millard, kindly Millard takes. There is no dispute, Millard.
If the table was not there, there would be no difficulty. Mr.
Yes.
If you
Millard,
said this much,
yes,
that's sufficient.
Kindly, Millard, takes a situation, Millard. Millard, today, Millard, it's an admitted position. He is, Millard, behind the schedule, 75%. Whether this table, that table.
Maybe, but for 3 years banning for that.
Lordship can reduce it to 12 months. That, Millard, the Supreme Court is saying. If Lordship feels that is, Millard, arbitrary.
That would also be arbitrary.
Yes.
If I do that, that would be arbitrary, Mr. Ghosh. What is the basis of doing?
There is no, Millard, according to ECL, Millard, they have banned it for only for ECL for 3 years.
No, it has to be only for ECL.
No, no.
ECL cannot ban for
No,
FCI.
they can circulate in other contracts. Blacklisting, Millard, is circulated all.
This is sufficient, need not be circulated. It gets circulated.
Millard takes, Millard, clause 4, Millard, of the
if ECL debars, then the others also come to know. This is the business circle.
Kindly, Millard, takes, Millard, the banning, Millard.
Yes.
Minimum 1 year, and Millard, maximum is 5 years.
Where is that? I mean, I
Millard,
could not
it's
find.
Millard, C.
6.1 says 12 months.
Yes, kindly, Millard, takes, Millard, page 63, which refers to, Millard, the contract management manual, page 63 of your Lordship's brief.
Yes.
It refers to contract management manual of CIL, clause 30, page 63. The other terms and conditions of NIT
Not covered.
Not covered.
It is covered. Here you say 12 months.
12 months. So highest penalty, 12 months.
So highest penalty is not given. That is why it's not
So
covered.
12 months. Lordship can restrict it to 12 months. That is the highest penalty I could have invoked.
Very.
That, Millard, is, Millard, I have already, Millard, instructed. It could be 12 months or 1 year as per the clause of the contract. That's all, Millard. Because this is, Millard, in continuation of 4th of April 20. And this is suppression. This is gross suppression, if Lordship says. It's absolutely gross.
Yes, what do you say to this?
May I?
Mr. Ghosh, anything to add?
No, nothing to.
Let me hear him. Yes. Yes, absolutely.
So Mr. Ghosh is not entirely wrong when he says that there is a suppression. I will not, as an officer of the court, I will not. But I take the full responsibility. I should have seen this. It's not. The point is, my lord, whether it's a suppression or not is otherwise, even if I admit it, the question that would stand before this court is whether it's a suppression of material fact, whether anything would turn on this or not. Now, he places this particular document in order to show that I have already waived off my right to challenge a future proceeding that may be initiated against me. That is the purpose of showing that extra page, which I have.
No, it does not say that. It says that they are free to proceed on the basis of the previous show cause.
They are.
That is what you say. You agree.
So that would essentially mean.
Why is it not a suppression?
I'll indicate to your lordship why.
Yes.
I would read. No, it is. I'm not saying it's not a suppression. I'm saying
why
it's
it is not a material suppression.
I'll tell you, lordship, why. Because this would have to be read in tandem with the fact that they have withdrawn the earlier proceeding. Lordship keeps this aside for a moment that I have said this. So the earlier proceeding as today stood withdrawn.
So they will either have two options, one to initiate a fresh proceeding, or they will be able to reinstate the first proceeding. It is already, so my first argument apropos that is, it has already fallen from your lordship that they have also waived off their right to be able to fall back on the earlier proceeding. That is my first argument by initiating the new show cause notice. That is the first bit of it. The second is, if your lordship kindly bears with me and lordship tests my argument on this.
Please just show that portion where they have waived. I mean, they have said that again, we'll start it again or something like that.
From the fresh show cause notice, my lord.
Oh no, in this itself.
This
Page
is
185, 186.
185,
Right,
186 is a fresh show cause where they say that they will initiate the proceeding afresh. So they have themselves waived off the earlier proceeding. But in this case, I would, in administrative law, my lord, be the delinquent. So there would have to be a show cause notice. There would have to be an opportunity of hearing, and there would have.
I'm very sorry, my lord. Lordship will kindly also take. I should have placed page 186, my lord, second paragraph. We emphasize that this level of performance is unacceptable, fell below the standard set out to forthwith achieve the target production given to you with a letter dated such and such 6/4/2023. We value our relationship with our company and believe the issues through which our communication collaboration. We understand the challenges can be raised such and such. So letter is referred to. This is in continuation.
No, that would be contrary to their first paragraph, my lord, in the same show cause notice, where they are saying it's being incepted afresh. But even if I keep that aside for a moment, my lord, lordship considers that under administrative law, there would have to be a show cause notice, opportunity of hearing. I would be given a chance to reply, and then there'd be a reasoned order which is passed. Now, apart from the fact that this is also a procedure, this is protected under Article 14. I cannot be proceeded against without being given a show cause notice. I don't, in law, my right, which is a fundamental right, cannot be waived.
Why Article 14?
Because in administrative law, this entire process commencing from the show cause.
Why Article 14? What does Article 14 say?
Reasonableness. This cannot be arbitrary.
There is a question of equality with others.
The opportunity of being heard.
It was given to you previously.
But that has been waived off by issuance of 185.
This argument depends on your on the acceptance of your other argument that it has been waived by this.
This would be, because otherwise that paragraph that he shows on 186, this would have to be read in terms of the paragraph which is in 185.
That is the first paragraph.
That is the first paragraph.
See the first paragraph. They refer to all the previous documents, and that in the context of your this admission.
Yes, he writes that lordship looks at the same paragraph. Lordship looks at the bottom. We would like to apprise you that you have miserably failed to keep your commitment in terms of OB removal and coal production at Nimcha.
They should have only omitted the first table there at page 185. Otherwise, that's superfluous.
No, but also that the last line of this paragraph, which your lordship is looking at, they conclude the paragraph by saying that apprise you that you have miserably failed to keep your commitment in terms of the OB removal and coal production in Nimcha. So that this is nothing but a mere observation as to the prior facts. This is not the initiation of a show cause which is in continuation to the earlier show causes.
All right.
That would be my argument. Then he goes on to the following table is the pictorial status of your subpar performance and inadequate adherence. Then there's a chart given. So in the context of a show cause, it would have to be observed that these are the particulars which are being made over to me for the first time. The earlier particulars have not been repeated. Show cause has to be detailed. He doesn't give the details of the earlier show cause apart from a mere reference to the same, which I can conclude in my humble submission. Lordship tests that would only be an observation as to what has happened, which also they are in law bound to give me. So with respect to that, the fact that they have already waived off their rights under the earlier show cause notice is not in question in my understanding. And my right under law, under Article 14 cannot be waived. While my learned friend was taking up this point, I was looking up, there's a judgment, 1959 AIR 149, there's a Basheshwarnath judgment.
Don't fight.
I'm not sure. I don't even have a copy of that. I'm not showing the judgment. But with respect to the fact that fundamental right cannot be waived off. If I have to be given a right of show cause and an opportunity of hearing, that is a fundamental right. I would have to be given the principles of natural justice. There would have to be a necessary compliance of audio alternate partem. If it's not, and merely because I say that I don't want it, does not mean that even I as a citizen have the right to waive that off. That would be the law. I mean,
you gave a reply to this.
185, I've given a reply. I've given a reply. I have not been granted a personal hearing, but in the context of the earlier Supreme Court judgment, which my learned friend had shown to your lordship, that particular paragraph, I mean, my learned junior had shown, my lord, that specific paragraph, I do not particularly think that is going against me. And I'll indicate to your lordship why. The fact that there would have to be a right of personal hearing is a settled proposition of law with only one exception. The exception is that if the records of the case are so manifest that a personal opportunity of hearing would be an idle formality, it can be waived off. Your Lordship was hearing the matters under 148 of the Companies Act, the disqualification of din. In that case, it is on record, they have not filed their returns, therefore they cannot be granted an opportunity of hearing. This is a case which is substantially based on fact. Why I could not be given the opportunity of extraction, etc. That is, and the last reply, my lord, with respect to the fact that the 12-month period, 12 months to 5 years waived off because there's a contract, so nothing to the contrary. So today this contract, my lord, restricts the entire period to 12 months, which is a maximum limit. That is the outer limit. So even if they grant, my lord, even if they impose a penalty of a ban of any period below 12 months or a period of 12 months, they will have to substantiate the reasons for that. In the absence of it, the writ court will not set aside the banning, will not reduce the banning. They'll have to set it aside completely, because then it would be an order passed which is Dehor's reasoning. Why 9 months or not 12 months? Why 12 months and not 9 months? That reasoning has to form a part of the impugned order. That is not there. That would essentially, I think my learned friend has already placed the case better than me, but I'll not add to anything.
The present challenge has been preferred against the termination of the contract stroke work granted to the petitioner by the respondent authorities and banning of business of the petitioner with the respondent authorities for a period of 3 years. First of next para. Learned counsel for the petitioner argues that despite having given several previous show cause notices and the petitioner having answered the same, comma, the respondents in their final show cause notice dated May 28, 2023, comma, waived the previous notices by referring only to 2 months of alleged default, comma, pertaining to April and May 2023, comma, whereas the previous notices has referred to previous months. First of next para, it is argued that in view of the waiver, comma, the respondents cannot now rely on the contents or the allegations made in the previous show cause notices. First up, in the notice dated May 28, 2023, comma, which was the genesis of the present impugned action, comma, the respondent authorities did not give the particulars of the alleged defaults of the petitioner, but only referred to 2 months, comma, whereas the contract contemplates default for a continuous period of 6 months within a particular larger period. First of next para, it is further argued that proper notice of blacklisting the petitioner by banning business was not issued to the petitioner at all. First up, by placing reliance on the show cause notice dated May 28, 2023, comma, it is argued that the same relates only to the subsequent cause of action pertaining to the months of April and May 2023, comma, whereas the impugned order of termination and banning of business dated June 10, 2023 refers to previous alleged defaults committed by the petitioner. First up, thus, comma, the termination stroke banning of business order went much beyond the show cause notice itself. First up, next para, learned counsel places reliance on a coordinate bench judgment reported at 2023 SCC Online Cal 139, where the learned coordinate bench, comma, placing reliance on certain judgments of the Supreme Court, comma, observed that a show cause notice must essentially disclose the charges upon the person stroke entity to who the notice is being addressed and must also afford a reasonable opportunity to the person to reply to the charges made in the show cause notice. First up, the necessity of a show cause notice and the consequent opportunity to the person of a hearing, comma, it was observed, comma, assumes importance in the context of the punishment to be suffered by the person for who the show cause notice is intended. First up, the learned single judge, comma, citing the Supreme Court judgment in Gorkha Security Services, comma, also borrowed the principles of natural justice in such context, comma, since The blacklisting entails double inverted civil death and is stigmatic in nature. Full stop. Next para. Learned Counsel also places reliance on the parent judgment of Gorkha Security Services versus government within bracket NCT of Delhi bracket close and others reported at 2014 9 SCC 105 for a similar proposition. Full stop. Next para. Learned Counsel appearing for the respondent authorities contends that a vital portion of the admission of the petitioner has not been annexed to the writ petition. Full stop. Whereas the minutes of a personal hearing given to the petitioner on April 6, 2023 have been annexed, comma, the second page thereof, comma, which contained question number 11 and the answer thereto has not been annexed. Full stop. A copy of the same is handed over to court by learned counsel for the respondents. Full stop. It is argued that in the said reply, comma, the petitioner had stated that it would like to start production from April 25, 2023 and would give its level best to achieve the targeted production, comma, failing which the management would be free to proceed in continuation with the above mentioned in continuation with the previous letter dated April 1, 2023 for termination of contract with banning of business, and the same would be accepted by the petitioner. Full stop. Next para. In the said paragraph, comma, it is pointed out, comma, the petitioner also admitted that currently at that juncture, comma, the maximum machineries of the petitioner were under breakdown due to admitted lack of proper maintenance. Full stop. Next para. It is argued that in the show cause notice dated May 28, 2023, comma, the respondents clearly mentioned the previous notices in terms of the concession given by the petitioner in reply to question number 11 referred to above. Full stop. Next para. Thus, comma, it is argued that no question of waiver of the previous notices or the grounds taken therein arose at any point of time, full stop, since the petitioner had already been given opportunity of hearing previously and had given a reply to the show cause notice dated May 28, 2023, comma, it cannot be said that the petitioner was not given ample opportunity within the contemplation of the cited judgments. Full stop. Next para. A perusal of the judgments cited by the petitioner shows that the proposition laid down therein is well settled and there cannot be any quarrel regarding the same. Full stop. However, comma, in paragraph number 20 of Gorkha Security Services itself, comma, which was one of the judgments cited by the petitioner, comma, the Supreme Court hastened to add that once the show cause notice is given and opportunity to reply to the show cause notice is afforded, comma, it is not even necessary to give an oral hearing. Full stop. In the present case, comma, the petitioner got an opportunity, comma, which it used, comma, to give a reply to the last show cause notice dated May 28, 2023, full stop. Hence, comma, it cannot be said that the principles of natural justice were violated on the ground of non-compliance of the doctrine of odi alteram partem. Full stop. Next para. Insofar as the petitioner's stand is concerned, comma, the petitioner clearly admitted in reply to question number 11 in its previous personal hearing that if it failed to complete the production, complete the target as indicated therein, comma, the management would be free to proceed, double inverted tarpor, in continuation with the above mentioned letter dated 01.04.2023 for termination of contract with banning of business, and the same will be accepted by me, double inverted close, full stop. Next para. Thus, comma, the said concession of the petitioner itself revives the validity of the grounds taken in the previous show cause notices. Full stop. The question which remains is whether the previous notices were specifically waived by the respondents at any point of time. Full stop. In such context, comma, the penultimate paragraph of the show cause notice dated May 28, 2023 is placed by the petitioner, which states that double inverted in the light of the above scenario, double inverted close, comma, the petitioner was asked to submit a written explanation as to why the respondent should not start the process of termination of contract with banning of business again. Full stop. Next para. The petitioner's reliance on the table given in the show cause notice dated May 28, 2023 is misplaced, comma, since the said table, comma, alleging non-fulfillment of the target during the months of April 23 and May 2023 were superfluous, comma, over and above the grounds cited in the 4 previous show cause notices and other communications in that regard, comma, which were revived by virtue of the undertaking given by the petitioner himself. Full stop. Next para. In the second paragraph of the show cause notice dated May 28, 2023, comma, the respondents clearly referred to the previous notices dated March 15, 2023, comma, March 24, 2023, comma, April 1, 2023, and the hearing dated April 6, 2023. Full stop. Next para. The respondents mentioned that in continuance of the said notices, comma, the respondents apprised the petitioner that the latter had miserably failed to keep its commitment in terms of OB removal and coal production at Nimcha, within bracket Amkola extension, bracket closed, OC patch. Full stop. Next para. In the same notice, comma, the respondents also mentioned that the level of performance of the petitioner, comma, in terms of the above paragraphs, comma, is unacceptable and falls well below the standards set forth to achieve the targeted production given to the petitioner, vide the letter dated April 6, 2023. Full stop. Next para. In such view of the matter, comma, and in the light of the above scenario, comma, in the language of the respondents themselves, comma, the petitioner was asked to submit a written explanation as to why the respondents should not start the process of termination and banning of business within double inverted again. Full stop. The term within double inverted again does not waive the previous notices, but rather resumes the exercise from where it was left in terms of the previous notices, comma, which was enabled by none other than the petitioner's own admission in its reply to the query number 11 in the personal hearing given to the petitioner. Full stop. Next para. Insofar as opportunity of hearing and reply is concerned, comma, sufficient opportunity was given to the petitioner. Full stop. Hence, comma, the proposition laid down in the cited judgments are not attracted in the present case. Full stop. Next para. The respondents gave several opportunities to the petitioner, but the petitioner failed to meet the standards. Full stop. Although the petitioner has argued that subsequent to the issuance of the previous show cause notice, it had fulfilled the targets for a particular period, comma, in view of the previous laches, comma, which were not satisfactorily explained by the petitioner, comma, in the perception of the respondents, comma, it cannot be said that the impugned order of termination and debarment is so vitiated that the same has to be set aside. Full stop. Next para. The writ court can only scrutinize the decision-making process and whether there was any palpable arbitrariness, comma, malafidis, or unreasonableness in the action impugned. Full stop. I do not find any of the above yardsticks to have been satisfied in the present case to call for an interference with the decision of the respondents, comma, particularly insofar as the legality of such decision is concerned, comma, since there is no flaw in the decision-making process of the respondents. full stop, in such circumstances, comma, there is no scope of interference with the impugned order. Accordingly, WPA 19005 of 2023 is dismissed on contest without any orders to cost. Sorry.
May I before one small indulgence, my lord? Not with respect to this, my lord, there are certain machineries, etc., which belong to me. They are still lying within the compound, my lord, which I have not been allowed to take back. Those belong to me, admittedly. Lordship will
There is
clarify
no
that.
claim, no allegation regarding that effect.
No,
Take
because
them back. There is nothing to apprehend that they won't permit.
that this would not preclude me from my rights, asserting rights
That's
post
beyond the
termination.
scope of the writ.
Right. I'm deeply obliged.
Yes.
18. May it pleases my lord, I appear for the petitioner.
Yes.
I'm for the state respondent.
Right.
My lord, my lord, it's a classic case as to how state's apathy can lead to financial collapse of a family. My lord, the matter relates to, my lord, illegal seizure of my truck in connection with an offense under the Indian Forest Act. My lord, in the event of seizure, law contemplates two eventuality. My lord, either the vehicle should be released under section 53. Well, the discretion is there with the authority, or my lord, without any delay, there should be confiscation proceeding.
This is under the Forest Act.
My lord, Forest Act.
Indian Forest Act.
My lord,
May I hand over the book?
Yes.
my lord, in
Yes.
this event, my lord, my vehicle was, my lord, seized on 8th of January. My lord, kindly takes the complaint copy, the FIR, my lord, at page number 25. My lord, before, my lord, taking your lordship through the provisions, my lord, I'll just place the facts very briefly. May I, my lord?
Yes.
My lord, the petitioner is from Maharashtra. My lord, the vehicle left from Maharashtra on 29th of December, my lord. It reached Assam on, my lord, 5th of January. My lord, as my lord knows that the transporters, my lord, come up with the assignments. So, my lord, one transporter, local transporter, had approached my client's driver on 6th of, my lord, January. My lord, for consignment, Calcutta. My lord, this was a carbon consignment. My lord, my client, upon agreeing on the terms of payment, my lord, have over the phone, my lord, have consented for the consignment. My lord, the consignment was loaded on 7th. My lord, while loading the consignment, my lord, what, my lord, the consignor did, surreptitiously, my lord, he have concealed the wooden blocks beneath the polymer bags filled with, my lord, the carbon dust. My lord, it was filled with, my lord, it was tightened with the tarpaulin from outside. My lord, the vehicle commenced its journey on 7th. It was intercepted near Kuch Bihar. My lord, Bakshirhat police station, my lord, has seized the vehicle. My lord, have filed an FIR. My lord, may I now place the FIR? That is at page 25. My lord, has that page 25?
Yes, yes, I'm there.
My lord, this is the FIR number is 12 of 2023. My lord, the charges slapped against my client, my lord, is section 379. 411, my lord, which is nothing to do with the case, because my lord, police says that my client was not having, the driver was not having any papers with regard to the my lord, vehicle. My lord, which is incorrect. I'll show to you, lordship.
This 42 of the Indian Forest Act is there. What is
My lord,
that?
42. My lord, 42 is, my lord, for breach of any rules made under section 41.
All right.
My lord, kindly under 41, my lord, the
Yes.
government has framed the rule. The my lord, the rules are. Well, the West Bengal Forest Produce Transit Rules 1959. Well, this is the rule framed under section 41. Well, may I place the copy of the rule?
Please.
Well, may I indicate, my lord, at the in exercise, my lord, this is in exercise of powers conferred by section 41, 42, and 76. My lord, these rules are framed. My lord, now rules provides that in the event if a vehicle is, my lord, carrying any, my lord, if the forest producer, my lord, transported without transit pass, my lord, it is liable for seizure. My lord will file that rule at page as rule number 7, subclause 3. My lord, may I please? Any timber or other forest produce not covered by a transit pass referred to in subsection rule 2 and 3 of rule 4, together with boats, carts, vehicles, or cattle suspected to be carrying the same, or any timber which is cancelled in contravention of rule 1, sub-rule 1 of rule 4, shall be liable to seizure and dealt with under the provisions of contained in section chapter 9 of the Indian Forest Act 1927. Well, it kindly takes one more rule, Malad. Rule 8 subclause 2. These seized forest produce shall be released or confiscated under the provisions contained in chapter 9 of the Indian Forest Act. My lord now kindly takes chapter 9. My lord, which starts from section 52. My lord. Yes. My lord, may I place, my lord, starts with section 52 that provides for seizure of property liable to confiscation. My lord, this simply provides, my lord, in the event a vehicle or my lord, boat or other my lord, means of transportation is filled with forest produce and my lord, it's found without transit pass, it is liable for my lord, seizure. My lord, rule 53, section 53, my lord. Power to release property seized under section 52. My lord, seizure under 52, power to release under section 53. My lord, may I please? Any forest officer of a rank not inferior to that of a ranger who or whose subordinate has seized any tools, boats, carts, or cattle under section 52 may release the same on the execution of by the owner thereof of a bond for the production of the property so released, if and when so required, before the magistrate having jurisdiction to try the offense on account of which seizure has been made. My lord, power has been given, my lord, to the authorities to release the vehicle. My lord, I have invoked this power. My lord, I have written a letter to the authorities. My lord will find that at page number 26. My lord, page 26. My lord, it's sorry, my lord, page number.
You're willing to give a bond?
My lord, page number 28.
28?
My lord, 28, my lord. I'm sorry. That is my representation, my lord, to the divisional forest office.
So you're willing to give a bond under this provision?
It's subject to. Is it reasonable terms, my lord? I'm willing to. My lord, I'll just place my case, my lord, and then, my lord, may I please?
So what has been done now?
My lord, no release. Vehicle was not released.
Their discretion.
My lord, discretion. Very well, my lord.
There's a chance of you fleeing to Maharashtra. That's it.
My lord, in that event, my lord, section 59, confiscation. My lord, 55 provides for confiscation. My lord, kindly take section 55. Forest produce, tools, etc. when liable to confiscation. All timber or forest produce which is not the property of government and in respect of which a forest offense has been committed, and all tools, boats, carts, and cattle used in committing any forest offense shall be liable to confiscation. Well, the procedure of confiscation is laid down under section 59A. Mallet, may I?
59A.
Mallet, this is the amendment made out by the government of West Bengal.
Yes.
Lordship has that?
Right.
Mallet, may I please? Confiscation by forest officer of forest produce in the case of forest offense believed to have been committed. Notwithstanding anything contained in the foregoing provisions of this chapter or in any other law for the time being in force, where a forest offense is believed to have been committed in respect of the timber or other forest produce, which is the property of the state government, the forest officer or the police officer seizing the timber or other forest produce under subsection 1 of section 52 shall, without any unreasonable delay, do the same together with all the tools, ropes, chains, boats, vehicles, and cattle used in committing the offense before an officer of the rank not inferior to that of an assistant conservator of forest authorized by the state government in this behalf. My lord, the objective is there should be no delay. My lord, January 8, vehicle was seized. My lord, I'll just indicate after filing of the writ petition, a notice was served, purported notice, my lord, but that is again not under section 59A, 59B, my lord. My lord, section 59B provides for the notice. My lord, kindly takes 59B. My lord, may I please? Well, this is the safeguard for the people, innocent owner, who have got no knowledge or connivance in the commission of the offense. My lord, may I please? Issue of notice before confiscation. No order confiscating any property or tools, ropes, chains, boats, vehicles, or cattle shall be made under section 59A, except after giving a notice in writing to the owner of or the person from whom such property or tools, ropes, chains, boats, vehicles, or cattle have been seized, for showing cause as to why the same should not be confiscated, and considering his objection, if any. My lord proviso. Provided that no order confiscating any motor vehicle shall be made except after giving a notice in writing to the registered owner thereof. In the opinion of the authorized officer, it is practicable to do so, and considering his objection, if any. My lord clause 2. Without prejudice to the provisions of subsection 1, no order of confiscating any tool, rope, chain, boat, vehicle, or cattle shall be made under section 59A if the owner thereof proves to the satisfaction of the authorized officer that such tool, rope, chain, boat, vehicle, or cattle was used in carrying the timber or other forest produce without the knowledge or connivance of the person. My lord, this is my case. My lord,
So you had to be given a notice for being heard under 2.
My lord, what had happened now? My lord, I filed the writ petition. Since, my lord, 5 months when the vehicle was seized, no action under section 53, no confiscation proceeding under section 59A. My lord, that apparently is violation of all the rights that the petitioner has. My lord, after that, I have written to them, my lord, in April. They have not replied to that letter. My lord, kindly takes my letter, my lord, at 59. That gives clear picture that, my lord, 53 is an equity, my lord, bestowed upon the authorities to be exercised in the event of an innocent owner. My letter expressly, my lord, shows that a person from Maharashtra who has got no nexus with the northeastern part of the country, who was there a day before, can he conspire, my lord, in the smuggling of this large scale, my lord, wooden product? That is my case. My lord, page 28 is the representation. May I please, my lord? With reference to the above vehicle, I beg to state that I am the registered owner of the vehicle number such and such, which was purchased under the hire purchase agreement with Sind Bank. My lord, the vehicle is under hypothecation. I had a liability to pay in excess of 1 lakh a month, but I'm not being able to pay since January. And this is the only source of my income, which was purchased under the hire purchase agreement. The said truck is the only source of my income to maintain my family. The said truck was being plied by my driver, Riaz Nayak, whose driving license is such and such. At the time of appointment, I specifically instructed him not to carry any contraband goods in my truck. I came to know that my said truck was seized on 8th of January 2023 by police of Boxhirat police station. I came to know that my police station allegedly loaded with 83 wooden blocks, different size, total volume 571.43 cubic feet. Neither I had any knowledge regarding carrying of said timber, nor the driver, nor did I have any connivance regarding the same. After seizure of my truck, I asked my driver why he loaded timber, to which he told that one transporter from Guwahati, such and such, whose mobile number was also given, hired the said vehicle from him, and as per instruction of the said transporter, in good faith, my driver allowed the transporter to load burn carbon, for which the transporter hired my vehicle. After loading the vehicle in Guwahati, Assam, the transporter had handed over tax invoice and e-way bill to my driver, being an illiterate person and not acquainted with the documents to carry goods. After loading the goods and seeing those papers, in good faith, my driver carried the same. The seized timber seems to be burn cover, for which the transporter hired my vehicle. Well, this driver was an illiterate person. He could not read English or write. He found the paper. He has seen the format and he thought that it will be the correct. But after this, the law contemplates that without delay, assume the authority chose not to exercise its discretion under section 53. Law mandates the compliance of 59A. Without delay, confiscation. They have not done it. I filed my writ petition on 9th of June. After passing of the writ petition, I have been served with a notice. A purported hearing notice, which in my respect was submission is not in terms of cannot be in terms of section 59B. There has to be specific mentioning. The notice says, my lord, that the notice is for hearing in respect of seizure of vehicle. Seizure is 52, my lord. Confiscation is 59B. It has to be in respect of confiscation. But be that as it may, my lord, my client appeared in the hearing post filing of the writ petition. It was, my lord, it happened on my lord, 3rd of July. My lord, we are in October. No development.
You were heard.
I was given a purported hearing, my lord. I was there. We have given a submission. After that, my lord, nothing had done. My lord, in the meantime, I have also written to the higher directorate, my lord. I have also written to the directorate at, my lord, at page number 30. Well, the entire sequence of event, how it led, well, the vehicle was loaded with assets. Well, it is explained at paragraph, if your lordship may permit, it's 2-page.
Two must be the same as your letter.
Well, it's even in more detail, how he was, misled and how he was, implicated in the proceedings. I've given the detail, but despite that, nothing had happened. Now, kindly takes the, complaint copy, based on which, the FIR was lodged.
Given you a hearing under law, they can now confiscate.
It's not under the notices, I'll show the notice, it is not in terms of 59A. Cannot be,
You participated in the hearing.
But hearing was.
There is no scope of any notice being given before Caesar. Is there?
Yes.
Cannot be.
At the time of Caesar, they have to. I'll just show. This is rule 8.1. 8 subclause 1. Kindly takes the rule.
Yes.
Any forest officer who has seized any forest produce under rule 7 shall immediately issue a written notice to the owner of such forest produce, or if the owner is unknown, to the person in charge of the possession of such forest produce at the time of seizure, calling upon him to produce the proof of origin of the forest produce. So, this notice is uncertain. It can very well be under rule 8 subclause 1. I have a right.
Now show me that notice.
The notice was posted, and in view of the bereavement in the family of my client, his mother passed away. He could not supplement. May be permitted. It's their document. Hopefully, they'll not deny.
Give a copy to them also.
I will, my lord. Once. Even otherwise, notice after this inordinate delay, is vitiated. Any hearing, given after inordinate delay, the proceeding will be vitiated itself.
So what
may I place,
Yes, I've seen it. What relief do seek?
Release of the vehicle,
Release of the vehicle outright. I mean, without.
Subject to the condition imposed by your lordship. Reasonable condition, because my client is under financial stress. That is a fact.
Yes, what do you say?
The delay was caused since there was no papers of the vehicle. We have also intimated the RTO of the Kuch Bihar. Even he could not produce anything, my lord. And thereafter, we have received an email from the petitioner that the vehicle belongs to him. We have immediately approached him, but to come up with the papers. But we have received initially was only an Aadhaar card. And my lord, thereafter, we have approached again by issuing a notice, my lord, and he appeared, my lord. My lord, though I am not aware of the fate of this, my lord, this, what to say, this meeting, my lord, but my lord, your lordship kindly comes to 59D. 59D. The provisions are there, my lord, open for the petitioner to approach the concerned district judge for necessary relief, my lord, in terms of 59D.
There has been no confiscation. What is the scope of availing of this provision?
I am not aware of the fate of this, this.
You are the authority who is confiscating. If you are not aware, who will be?
We are not served with any order under section 59. So therefore, 59D is not applicable.
Whether after this procedure,
we have not received.
Thing have been confiscated or not, my lord?
They cannot, my lord.
Sir, 53 is still open, since there is no proper confiscation as yet. Your notice does not speak about 59.
Notice speaks about the seizure.
Seizure, which is not confiscation. So there is no notice as yet of confiscation for hearing after confiscation. Before.
Let me come back on Monday.
No. Yeah, I've heard you.
May I just indicate, may I just place one judgment in the same context? On the point, my lord, if the seizure is without following the due process, my lord, the entire proceeding, my lord, will be vitiated, and the petitioner, my lord, is entitled to return of the vehicle.
83.
My lord, even the FIR or the my lord, seizure list, the implication, my lord, seizure list is in English, which was signed by my driver, who does not know how to write or read English. The notice is after 6 months.
But admittedly, my lord, the ticks had no legal documents.
No action was taken against the people who are after this.
Mr. Ghosh, how do you justify not complying with Rule 8? I mean, which says that immediately upon seizure you have to issue a written notice. There is
Milord,
no proof of that.
initially, we could not trace out any individual, Milord.
The driver was there.
He could not say,
You could have ascertained by the number of the vehicle from the RTO.
well, we have tried it, but he has also failed to produce any sort of
So the
document.
seizure is bad in law. He's right.
Milord, the
You have to release
RTO,
the vehicle.
Milord, the RTO was unable to trace the
No, it's online.
owner of the vehicle.
It's online. I've enclosed the documents which I have downloaded from the website.
RTO Kuch Bihar.
An extra P1. It's all online document. Everything is available
It's
online.
online actually.
Milord,
I don't
we
know
could
whether
not find
Vahan or not. It's a different website.
we
can
could
very
not
much trace
find
out.
any particulars of
Page
the
21,
vehicle.
my lord. It's
In
an
spite of
online.
our best efforts, Milord.
Page 21 is an online document, my lord. It's available on the website of the government of Maharashtra. Even otherwise, my lord, I have provided with all the documents in July.
Milord,
Everything.
I am not aware of the fate of the hearing, Milord.
My lord, it's before hearing, my lord. It's after. It's part of the petition, my lord. Page 30.
No, what happened?
Hearing no reply, no order, no communication.
Milord, let an order be passed, Milord, in connection with this hearing, which was held, Milord.
No, my lord. Caesar is bad.
I'll pass that order. If release the vehicle himself. The petitioner contends that the petitioner's vehicle was confiscated on the allegation that it was in contravention of the provisions of the Indian Forest Act, since contraband timber was being carried on the said vehicle. Next para. Learned counsel for the petitioner argues that the petitioner, being a resident of Maharashtra, was in no way aware of any such contravention. The driver of the truck in question, which was in Assam and picked up a cargo therefrom and was traveling to through West Bengal, was also illiterate. Next para. In any event, it is submitted that even well after the stipulated period, no action was taken by the respondent authorities in terms of the Indian Forest Act 1927. Next para. It is pointed out that under section 53 of the Act, the authorities have a power to release the property seized under section 52 upon furnishing of proper bond for the production of the property so released. Despite the petitioner having written to the authorities for availing of such provision, no response thereto was given by the authorities. Next para. It is submitted that the options before the authorities, if the vehicle is not released on bond, is either to release it or to confiscate the same within the contemplation of section 55 of the 1927 Act. Section 55 provides that all timber or forest produce which is not the property of government and in respect of which a forest offence has been committed, and all tools, etc., used in committing any forest offence shall be liable to confiscation. Such confiscation, in terms of subsection 2 of section 55, may be in addition to or addition to any other punishment prescribed for the offence. Next para. Section 59 capital A within bracket as amended in West Bengal speaks about confiscation by forest officer of forest produce in the case of forest offence believed to have been committed. Next para. Section 59 capital B provides that no order confiscating any property, tools, vehicles, etc. under section 59 capital A shall be made except after giving a notice in writing to the owner of or the person from whom the property, vehicle, etc. has been seized, for showing cause as to why the same should not be confiscated and considering his objections. Next para. Subsequent to the filing of the writ petition, it is contended, a notice was given pertaining to the seizure and not a notice under section 59 capital B of the 1927 Act. The petitioner attended the hearing, but till date, no outcome of the same has been communicated to the petitioner. Next para. It is thus argued, that the entire process of seizure is vitiated and the vehicle should be released in favor of the petitioner. Next para. Learned counsel for the state argues that since a notice has already been given to the petitioner and the petitioner has been heard, comma, the matter ought to await the outcome of such hearing. Full stop. It is submitted that despite its best efforts, comma, the authorities in West Bengal could not ascertain the whereabouts of the owner of the vehicle, that is the petitioner, comma, from the concerned RTO. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it transpires that the rules framed under the 1927 Act in West Bengal, comma, that is the West Bengal Forest-Produce Transit Rules, comma, 1959, clearly stipulates in Rule 7 within bracket 3 that any timber or other forest produce not covered by a transit pass referred to in sub-rules 2 and 3 of Rule 4, together with the vehicles suspected to be carrying the same, shall be liable to seizure and dealt with further under the provisions contained in chapter Roman 9 of the 1927 Act. Full stop. Next para. Chapter Roman 9 of the Act starts with section 52, which speaks about seizure of property liable to confiscation. Full stop. Next para. Under Rule 8 of the Rules of 1959, comma, any forest officer who has seized any forest produce under Rule 7 shall, comma, immediately issue a written notice to the owner. Full stop. Next para. The said notice has to call upon the owner to produce proof of the origin of the forest produce and his title thereto within 30 days from the date of issue of the written notice, a copy of which shall be posted on a notice board at the nearest forest office. Full stop. Next para. Some some reasonable meaning has to be attributed to the expression double inverted immediately, double inverted close, preceding the issuance of written notice in Rule 8 within bracket 1 within bracket small a. Full stop. Even after several months from the seizure, comma, such notice was not given in appropriate format to the petitioner. Full stop. Only after filing of the writ petition did the respondents wake up from their slumber and issued a notice within double inverted pertaining to double inverted close the seizure, comma, without referring to the exact provision under which the same was issued. Full stop. Next para. Thus, comma, the basic preconditions of a seizure process have been flouted by the respondent authorities. Full stop. Till date, comma, no notice under section 59 capital B before passing a confiscation order has been issued to the petitioner. Full stop. Next para. It may be taken note of that the vehicle was seized as long back as on January 8, 2023, that is about 8 months prior to this date. Full stop. Next para. Hence, comma, in view of the utter inaction of on the part of the authorities, comma, the entire process of seizure is vitiated. Full stop. Thus, comma, the vehicle cannot be retained any further by the respondent authorities and should be returned immediately to the petitioner unconditionally. Full stop. Accordingly, WPA 13826 of 2023 is allowed, comma, thereby directing the respondent authorities to release the vehicle to the petitioner within a week from date. Full stop. Upon the petitioner approaching for such release before the appropriate authorities, comma, the authority shall release the said vehicle in terms of this order by acting upon the server copy of this order without insisting upon prior production of a certified copy thereof. Full stop. Next para. It is made clear that nothing in this order shall prejudice the rights of the respondent authorities to draw up appropriate proceedings under the relevant law against the petitioner on the allegations as made under the 1927 Act. Full stop. This writ petition and the order passed therein pertains only to the unlawful process of seizure of the petitioner's vehicle. No order is to cause urgent certificate.
So grateful, my lord.
Thank you. Mr. Ghosh, thank you for the book, although it went against your authorities. But
My lord, we just don't want that the petitioner cooperates with us in the investigation.
he also wants the same from you.
So grateful, my lord.
Only one matter I am, urgent matter I am mentioning, my lord.
All the matters are urgent.
My lord, item number 39 at 2 loss. Otherwise, I don't have to.
What is the?
I don't 39, my lord. Tuesday, the date fixed, the borrower will be ousted from the creditor assets. Well, this is very important. Only my only house is that. Only my house.
Regarding item number
31. That's it. Well,
There is a person who has been kept unlawfully in India for 2 people for almost 18 months. They are
In India?
In India, they are Bangladeshi citizens.
What is the item number?
669 of the monthly list.
It will note korte gulo. 669 monthly list. Your item is?
39.
Your?
My lord, item number 39 regarding Puja.
39?
35 regarding Puja permission, my lord.
35, 39 and it is 660. Top it either.
I mentioned yesterday, the scheduled caste certificate has been cancelled. It will be given effect to. I'll be in the roll down.
That is not.
Yes, my lord, because otherwise, my lord, my entire MBBS degree, everything will go. And during the pendency of the matter, this has been done. My lord. We filed that.
That can wait till Monday. Wait till Monday for mentioning.
My lord, otherwise we'll be in difficulty.
All the other matters, please mention on Monday. Call on the.
I have mentioned in the morning, my lord.
Original set call.
Original side matters.
Mentioning ki ache dekho. Yes, please use the microphone.
This matter is, my lord, is appearing as item number 29 in my lordship's list, my lord. I am for the respondent in the matter, my lord. My lord, the petitioner is indebted to the bank for an amount of more than 13 crores, my lord. And my lord, although there is no stay in this writ, but my lord, this writ petition is taking.
So,
advantage of
please
this
give a
writ.
notice to the other side.
My lord, I have given a notice, my lord, and they are, I think he is present also.
He's trying to hide behind you.
My lord, I don't know, but I have given a notice, my lord.
Where is the notice?
My lord, any day, my lord, next week too, my lord, it will take my lord 15 minutes to hear.
Topic আছে already. একটা কি অন্য কোন একটা দুটো থাকার কথা। Tuesday ফাঁকা আছে topic. Tuesday at the top.
My lord.
Tuesday at the top.
My lord, I inform them.
Inform, yes. এটা রেখে। No, mention it on Monday. Yes.
Item number 29.
I'm not precluding you, Mr. Sawant. Please mention on Monday.
Yesterday, directed that it is listed today. It is listed.
I'm directed other matters also along with your matter.
Wait out.
So may I be permitted to mention one matter, Lordship? In this matter, Lordship, my learned friend's client filed a writ petition challenging the e-bidding notice. That is dated 6/7/2023. Now we filed, Lordship was pleased to pass an interim stay order and we move before the Honorable. This may be the wrong recording in the order, Lordship. On the last occasion, we submitted that we will take instruction from the higher authority whether we will withdraw the appeal or not. So it has been recorded.
That was not the submission made of the bar. The submission was that they have already.
No, then file an application.
They have already issued a notice recalling that notice on virtue of which this interim order was passed.
Our submission is that, Lordship, we will take instruction.
I don't remember your submission now. Whatever submission you made, that was recorded. I mean,
yes, Lordship, but the Lordship
cannot verbally. I mean, just recall that order.
No. I'm not asking for any.
File a proper application if you want a modification. Yes. Yes, call on the list.
Item number 1 for judgment. Gulshan Kumar Gulati and another versus West Bengal Small Industries Developer.
Thus, WPO 1610 of 2023 is dismissed on contest. However, without any order as to cause, urgent certificate copies.
I'm grateful to your lordship.
Yes.
Item number 2 to be mentioned.
My lord, only for the purpose of, my lord, fixing it on Monday, my lord, Mr. Chaudhary had mentioned it yesterday, my lord. Because the lordship had passed an order fixing it Tuesday at the top instead of Tuesday, my lord, Monday, because he is not there.
Monday কি আরো টপিক কিছু আছে? এটা একটা আরেকটা আছে।
My lord, he said he will take only 10 minutes after Mr. Sen concludes.
This is another top fixed matter, but this will also appear on Monday because you mentioned.
Grateful, my lord.
Monday, top. Oh, it is appearing in the list. I must pass an order.
Yes, because there is an order. It says, my lord, Tuesday it will.
The matter in view of joint submission of learned counsel for the parties, comma, let the matter be listed on October 16, 2023 fairly at the top of the list because there is another.
Very Lordship. Grateful, Your Lordship.
Fairly, man, really fairly. Probably this may be the first matter also. Yes.
Item number 3, Banwarlal Jajodia versus State Bank of
Yes,
India.
please.
and
Oh, that,
others.
yes.
ওটার নাম্বার কত আছে?
Yes, sir. What is it?
Lordship, I have prepared written notes, Lordship, and I also
Thank you.
enclosed some documents, Lordship.
Documents in written
Documents
notes,
like
sir.
deed of guarantee and all. Lordship said that if something has to be given, I am giving a copy to my
You have
learned
given a
friend as
copy to
well.
them.
These documents are known to him, Lordship.
No, you have,
I am giving a copy, Lordship.
I
course,
don't
sir.
know whether they know. So you have to give a copy to them so that
I'm
they know
giving-
that they know.
Lordship, I am giving them a copy, Lordship.
Now, why, Mr. Rai? Should have given earlier.
Oh, I'm so sorry, Lordship.
Not so sorry. Don't know. Yes, I'm taking on record these written notes of arguments. If you have to say anything, can you check up right now or should I keep it on some
Yes,
other? Check up, take your time, check up.
Lordship, or we'll come back on Monday, Lordship.
No,
I'll
I think
not take much time.
there's no further submissions.
No, no.
to be made.
Further submissions, whatever he has stated in his notes, Lordship, I have tried to dealt with all those points, Lordship, especially regarding the when assignment happens, then automatically the guarantee goes, Lordship.
File your written notes, I'll keep it on Monday as to you mentioned.
Yes.
You have filed your written notes of arguments.
Lordship, I have just
Just now hand it over.
now I'm sorry, Lordship. It is with me still. Yes, I'm so sorry.
My notes have been filed.
Yes. Written notes of arguments filed by respondent number 1 be kept on record, full stop. In order to enable learned counsel for the petitioner, in order to enable learned counsel for the petitioner to ascertain whether any further response is required thereto, comma, since a copy of the respondent's note is handed over here and now, comma, the matter be placed under the heading to be mentioned on October 16, 2023.
Can it be 17, my lord?
17, 16,
Indeed,
17. 17th under the heading to be mentioned.
Lordship, should I orally point out, Lordship?
Need not.
My lord, I had relied on certain cases, my lord. May I hand up the copies of the, because
Yes,
they're
sir.
part of my notes, my lord.
ওই পিটিশনের নোটের সঙ্গে এটা থাকবে।
Deeply.
Item number 4, Indian Oil Corporation Limited.
May it please, Lordship, my lord, I'm appearing for the respondent. That before my learned senior friend starts, may I take 30 seconds? Only one, my lord,
Your
page
30
I will,
seconds, Indian 30 second or my 30 second?
my lord,
30 seconds is it's relative.
I'll just
No, let us
indicate,
test your 30 seconds.
Lordship,
Yes.
my lord, I'll just indicate page 144 of the compilation. Only that, my lord. Page 144 of the compilation. Paragraphs 59 to 62. My lord, this was a bunch of appeals which was, my lord, being decided by the Honorable Court. One of the appeals, my lord, the facts are very similar. In fact, it's a step further. Here, my lord, the arbitrators were appointed under the Arbitration and Conciliation Act 1996. And the Honorable High Court, my lord, in a writ petition, my lord, held that you cannot invoke the MSME jurisdiction because arbitrators were appointed. The Honorable Apex Court set aside the order and held that no, MSME has an overriding effect. Even if, my lord, the arbitrators were appointed, my lord, MSME will take precedence, my lord, and the proceeding has to be, my lord, before the MSME. Only this, my lord. It's paragraphs 59 to 62 at page 144 and 145. That's only.
Yes. Yes, Suminda.
Now, 2 points have been principally argued.
Right.
Now, one is whether it's a works contract or not, that's a plea of defense. Being a jurisdictional fact maybe, which can be taken up before the council. The other point is special versus general.
Special?
versus generals.
Yes, yes.
Overriding effect.
Yes.
I first showed your lordship that there is a special provision in the West Bengal rules framed under the Act. It's the West Bengal Micro and Small Enterprises Facilitation Council Rules 2016. Please turn over to the 4th page of that, or Rule 4.
Yes.
Which deals with procedures to be followed in discharge of functions of council. Kindly turns over to sub-rule 8.
Yes. 8.
The council shall, if it is satisfied that on the facts stated therein, it has jurisdiction to proceed with the reference or application, and that the claimant is entitled under the Act to make a reference. A copy of the statement of claim to be sent by registered or speed post to the respondent, along with the copies of attached documents, and issue notice to the respondent asking him to furnish within 15 days a statement of defense with such documents and facts in support of his defense. If your lordship kindly remembers, the Act provides for 2 stages of conciliation and arbitration, and both stages there has to be a statement of application filed and a defense.
Yes.
At both the stages.
Yes.
And your lordship has perused that section 9 application. I just need to show to your lordship 2 paragraphs from that section 9 application.
Act regulator. Section 9 application take. Huh? Oh, আলাদা করে দিচ্ছি।
দিয়েছিলে বললে? Oh, আচ্ছা। Oh, I'm sorry. I'm told the court wanted a copy of the same. It was actually not handed over.
Right.
Now, please see paragraph 16 at page 8.
Yes.
Your petitioner submits that the terms of general purchase conditions forming part of tender documents are binding on the parties, wherein parties have chosen an alternative dispute resolution forum for adjudication of the disputes as and when arises, and the same will be evident from arbitration clause number so and so. Now, turn over to please paragraph 17 at page 9. Under these circumstances, there exists every probability and possibility that respondent will invoke the performance bank guarantee if the petitioner issues a notice under section 21 of Arbitration and Conciliation Act 1996 for invocation of the arbitration clause, and hence it is absolutely imperative to restrain the respondent from dealing with or unilaterally invoking performance bank guarantee till the issue of defect vis-a-vis damage is decided by the appropriate forum. Paragraph 22. That the relief your petitioner is seeking before this learned court is in aid and as an ancillary to the main relief which your petitioner is entitled for on final determination of the rights of your petitioner. Now please turn over to sections 8 and 9 of the Act. I just showed you lordship page 99 of the application, writ application, and then take your lordship through the provisions.
Yes.
The last paragraph on that page, in spite of our express intention conveyed to you on 10th October 2022 to resolve the dispute through conciliation or settlement as per clauses so and so, you have neglected to hold conciliation. Hence, this invocation of clause 34.1 is bad in law. So, apart from invocation of section 9, there was a clear intention expressed as on 10th of October 2022, much before he has approached the council. Now, kindly takes note 2 sections of the Arbitration and Conciliation Act, being sections 8 and 9. Both the provisions were introduced in the statute on the same day through the same amendment.
Sections
8 and 9.
Yes. 8 and 9 of the
Act of 1996.
Oh, arbitration. Yes.
But I'm not on which act is general, which act is special. Not that
No,
is
I've got a
well settled. Power to refer parties to arbitration where there is an arbitration agreement. That's section 8.
Yes.
Please see the date of incorporation, 23rd October 2015 by Act 3 of 2016. A judicial authority before which an action is brought in a matter. An action is brought in a matter which is the subject of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him so applies, not later than the date of submitting his first statement on the substance of the dispute, then, notwithstanding any judgment, decree, or order of the Supreme Court or any court, refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. The application shall not be entertained unless it is accompanied by the original arbitration agreement or a duly certified copy thereof, provided that same date, this provision was inserted on the same date or substituted rather. Where the original arbitration agreement or a certified copy is not available with the party applying for reference to the arbitration under subsection 1, and the said agreement or certified copy is retained by the other party to that agreement, then the party so applying shall file such application along with copy of the arbitration agreement and a petition praying the court to call upon the other party to produce the original arbitration agreement or its duly certified copy before that court. Notwithstanding that an application has been made under subsection 1 and that the issue is pending before the judicial authority, an arbitration may be commenced or continued and an arbitral award may be made. So this situation consists of two things. One, an action may be brought before the judicial authority, and once it is brought, the judicial authority has no other alternative but to refer. The word used is shall. I shall show to your lordship the same judgment of the Honorable Gujarat High Court, which considers a Supreme Court judgment and says judicial authority has no other alternative but to refer it for arbitration if a person has approached it for an action.
How is it relevant? You did not approach under section 8 before the MSME authority.
No.
One. Secondly, Supreme Court says
any
that
party
will override.
Any party. Not this. Now please consider 9.
Yes.
This was also introduced on the same day. And Supreme Court says it's a matter of choice. Under the Act of 2006, unlike many other statutes, there is no bar of jurisdiction. While holding that 2006 Act is a special statute,
yes,
the court has also, the Honorable Supreme Court has also held it only gives a choice to the party. Please see, section 9 now.
Yes.
Interim measures, etc. by court. Introduced on the same date. Please see section 9 renumbered as subsection 1 thereof by Act 3 of 2016 with effect from 23rd of October 2015. A party may before or during arbitral proceedings or at any time after the making of the arbitral award, but before it is enforced in accordance with section 36, apply to a court for, please see II, an interim measure of protection in respect of any of the following matters, namely A, I am not on A, B, securing the amount in dispute in the arbitration, D, interim, no, D is not relevant, E, such other interim measure of protection as may appear to the court to be just and convenient. Now, he approaches a court for the purpose of protection of a right. And please consider this section 9, please consider the interplay of 8 and 9. It's an action brought before a judicial authority.
I don't understand. 8 and 9, what is the interplay here?
8 says if an action is brought before a judicial authority.
Yes, it has to return.
It has to.
If an application is filed.
Yes. A judicial authority before which an action is brought in a matter which is the subject matter of an arbitration agreement.
Yes.
So it's a matter which is covered by an arbitration agreement.
Right.
An action has been brought in terms of section 9. The judicial authority had no other option but to refer it for arbitration in terms of the provisions of the Act of 1996.
What do you mean by the MSME authority?
No. MSME authority has
Section 9, there is no scope of applicability of Section 8.
Section 9 is a precursor to commencement of arbitration
Yes.
proceeding.
Precursor and also in between, yes.
In between or even after award is
Even
passed.
after.
Number two, if I apply for an interim protection, I choose to make this a subject matter of or a subject matter in terms of the provisions of Section 8 before a judicial authority.
Yes, it's implicit that he has to go for arbitration if he seeks Section 9 relief. He has to. It's
He has
implicit.
to.
Yes, that is there.
Now, I'm not. So far as the Act of 2006 is concerned, one can't directly approach for arbitration.
No.
He has to route it through the process of conciliation.
So you say the moment he says that I invoke Section 9, it's implicit that he invokes the arbitration also.
It's triggered.
It's triggered. Huh? Despite that not being Section 21, as he argued, as Mr. Bagh argued. So even if it's not Section 21 commencement, but he elects for arbitration.
Chooses for this. Not he had a right not to apply for interim protection and then get his rights adjudicated before the 2006 authority. But having taken the chance to apply for an interim order or an interim measure in terms of the 1996 Act, and Section 9 and Section 8 having been incorporated in the statute on the same day, the interplay of Sections 8 and 9 have to be read together.
Same day as what?
The amendment in the statute of
Amendment
1996.
same day.
Because not it speaks of an action. An action must have to be read as an action taken by a party to the dispute.
This is a legal action.
Action by act. Please see the language. A judicial authority before which an action is brought in a matter.
Yes, which is a subject matter of arbitration agreement.
Not he has brought,
like if he files a suit.
not he has not like he had filed an application under Section 9. It was not the Act of 2006 does not provide.
Section 9 and Section 8 cannot be mixed up like Section 9 in Section 9, Section 8, how can it apply?
Not it says a judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement.
Yes.
But the subject of an arbitration agreement is the bank
So do you
guarantee.
mean to say in Section 9 court will also return it?
No. Section 9 is only for interim measure.
Yes.
I'm not when the court says not the if Section 9 and 8 are read together.
Then what happens? I mean,
But the judicial authority has no other option but to refer it for arbitration if a party has brought an action before it in reference to a matter which is subject matter of an arbitration agreement.
Section 8 does not apply here at all.
Not if
there are two legal fictions you are mixing up together. And
not,
Section 8 confers one legal fiction, Section 9 another. I mean, you interfere in the anticipation, there is an arbitration.
yes, not Section 8 says a judicial authority before which an action is brought in a matter.
It's confined to its own applicability.
Which is the subject of an arbitration agreement. Section 9 says
yes,
a party may before arbitral proceedings.
Section 9 independently operates. Section 8 has no connection with Section
apply to a court.
Yes.
For an interim measure of securing the amount in dispute in the arbitration. Not the moment a party applies for securing the matter in arbitration, for securing of the amount in dispute in the arbitration, or say for an interim such other interim measure of protection.
Implicit. Arbitration you're saying is implicit in Section 9.
Yes. And also in Section 8 because he has brought an action which is the subject matter of an arbitration agreement.
All right. Very.
Now, in this background, kindly takes note that first judgment, I straightway take your lordship note to page 140 of the compilation. The Supreme Court judgment. Please see the issues first at page 135. Page 135, paragraph 32.
32, yes.
Now, the first and foremost issue involved in these appeals is whether the provisions contained in Chapter 5 of the Act of 2006 with regard to delayed payments to the enterprises which have precedence over the provisions contained in the Arbitration Act, more particularly when the parties by execution of an independent agreement as contemplated in Section 7 of the Arbitration Act had agreed to submit to arbitration the disputes arising between them. Now, 7 is an agreement executed, 8 is an action brought. Now, please turn over to page 138.
Yes.
Paragraph 40.6. The provisions of the Act of 1996 have been made applicable to the dispute only after the conciliation initiated under subsection 2 does not succeed and stands terminated without any settlement between the parties. Then not in paragraph 42, the court holds that Arbitration Act is a general provision or a general statute. Now kindly takes note page 140. Paragraph 46.
Yes.
The submission, therefore, that an independent arbitration agreement entered into between the parties under the Arbitration Act would prevail over the statutory provisions of the Act of 2006 cannot be countenanced. No, it's not a question of overriding. As such, subsection 1 of section 18 is an enabling provision which gives the party to a dispute covered under section 17 thereof a choice to approach the facilitation council despite an arbitration agreement existing between the parties. Absence of the word agreement in the said provision could neither be construed as casus omissus in the statute nor be construed as preclusion against the party to a dispute covered under section 17 to approach the facilitation council on the ground that there is an agreement existing between the parties. In fact, it is a substantial right created in favor of the party under the said provision. It is therefore held that no party to a dispute covered under section 17 would be precluded from making a reference merely because there is an arbitration agreement existing between the parties. Mere existence does not prevent. But if I take recourse to an action in respect of a matter which is covered by an agreement, then probably the doctrine of election may apply because it's a question of choice. Now, please see note the Punjab Haryana High Court judgment, which begins at page 59. I am sorry, it probably begins at page. Please take page 59.
Yes.
And it's like that note, I know that a particular statutory authority or a court is not clothed with the power to pass an interim order. There are so many statutes. There may be other statutes which permits grant of injunction or interim protection. Now, I approach this statute for an interim protection, don't get it, and at a later stage I invoke the jurisdiction of another statute saying that no, this will govern my dispute.
Mujumdar, according to you, what would have been his recourse if he wanted to avail of the MSME Act, conciliation and arbitration?
Conciliation and arbitration.
But he wanted an interim relief. What could he have done?
Not he could have not. There is provision for civil court as well. Not there are cases.
But once he goes to a civil court, I mean.
Not there are cases. Not that's under the common law. That's not government.
Can he come back to MSME?
No, that's not the law does not create a bar of jurisdiction. Not there are so many statutes which creates bar of jurisdiction by
file a suit.
Not it's under common law. Same way I try to get my rights settled or some protection under the common law.
I approach the civil court. After that, can I come back and say that I want to approach?
Not if I had not the two in that case, not I approach this court. Not suppose it is governed by the agreement. He says that I want to get this right protected by reason of invocation of section 9.
Let us suppose there is no arbitration clause. Then also, if he wanted to approach the MSME council, he would have to go through conciliation and then arbitration
and
under that act.
That's a choice. Not I may not go under this act also.
In that event, what could he have done for interim relief in the interim?
He probably had a right not to. If it is a question of choice, he could have
if
gone
there was
or
no
not
arbitration clause, there would be no choice.
Then no choice.
Only MSME. But there is no scope of.
So if suppose there is an arbitration clause, in the Act, and I am an MSME enlisted or registered entity. Now, I take the risk of, or say, I take the course of ventilating my grievance to the Act of 2006.
How could you get interim order under this Act?
Now, I take the risk of not getting an interim order then. I can't say that for the part of this transaction, a different statute will apply, and for the rest, no, I shall take recourse to a different statute.
Then it would be just IB remedium.
That's it.
He won't have any remedy.
No, he can have his remedy elsewhere because it's a choice.
Where? Elsewhere.
Suppose there are cases where even in spite of agreement or he can approach a civil court
and come back to MSME after.
But I can submit before your lordship, not say in the service jurisprudence. There are so many statutes or service regulations which do not provide for interim relief.
That is why, to test the margins, I was wondering, Mr. Mujino, what would happen if there was no arbitration clause. It's a MSME unit. He wants to come under this Act, have a conciliation and all, but he wants an interim relief immediately.
Now, at a particular stage, certain provisions of the Arbitrations Act are referentially referred in the statute.
But if there is no arbitration clause at the conciliation stage, he cannot.
65 to 71 applies.
He cannot invoke Section 9. Yes,
Section 65 to 71 apply.
That is conciliation.
So, it's a conscious decision taken by the legislators to regulate the procedure under a special statute, if it is to be recognized as a special statute, as my learned friend says, and as the Honorable Supreme Court has said, then it's a special mode of ventilation of grievance or adjudication of grievance. It's a special mode of grievance redressal.
This is a marginal peculiar situation, Mr. Mujumdar, because here they have a right. Suppose they want to invoke, they want to invoke this Act. They want to come through this Act, but they need an interim order. If they go to the civil court, I don't think after approaching the civil court, after electing that forum, they can come back to this.
One is declaration that you cannot do this. The other is, I want money in respect of the services rendered. That's the scope of the MSME Act.
Then the civil suit would be bad.
He's not filing a money suit then.
What else can he do?
He's probably filing a declaration that this invocation of bank guarantee is bad. Something like that.
Restricted to that interim relief.
Okay,
I mean, the main relief on this
for that purpose.
Very good.
Maybe
that's one of the options. So his main relief would be around that interim relief also.
Please see not the Act of 2006. It's only for the purpose of recovery of claims.
That would be a peculiar situation. Actually, I don't. I'll have to go through both the acts for that. I mean,
yes, yes.
What could be his option if he wants interim relief, but he wants to go to the MSME Council?
No, not whether he can at all choose that. That's the question.
Section 9 would be the most convenient if he has an arbitration.
It says for arbitration.
If he had an arbitration, yes.
Not if it is an arbitration, not under the Act of 2006, he cannot apply for arbitration without the conciliation.
But Mr. Mujumdar, theoretically, he can argue that this arbitration could also be under the MSME Act.
Yes.
Then but he has to be in anticipation there. Because he cannot jump the conciliation.
That's mandatory.
They're right on that. Actually, they're right on that.
That's mandatory. So therefore, he's taking a conscious decision to choose the path.
Yes, the rest follows.
Great. Now, please take that page 59.
59, yes.
Punjab Haryana High Court judgment. Paragraph 49.
49, yes.
The questions which primarily arise for adjudication in the present batch of petitions are whether the conduct of conciliation under Section 18(2) of the Act of 2006 is mandatory prerequisite for commencement of adjudication by way of arbitration under Section 18(3), whether council could appoint a facilitator, expert so and so under Section 18(3) of the Act, and as to whether the award passed by the sole arbitrator is a valid award in terms of Act. None of the questions is relevant except the seventh question at page 60.
Yes.
Whether the proceedings before the facilitation council in relation to a works contract would be not maintainable. Now, this is apropos, not a jurisdictional fact which at the most be addressed. This could not be an authority for the proposition because in West Bengal we have special rules. In the facts and circumstances of each case, the council must have to satisfy itself that he possesses jurisdiction and therefore he can issue notice. Now, please take the other judgment of the Gujarat High Court. Page 152.
Yes.
Paragraph 11. It is further submitted by Sri Patel, learned advocate for the appellant, that the learned counsel ought to have appreciated that the respondent herein had entered into an agreement under the Act of 2006, came into force, and by having agreed for resolution of dispute by way of arbitration, has voluntarily and impliedly waived its right under the Act of 2006, and therefore now it cannot be permitted to invoke the provisions of the Act of 2006 in view of mandatory in nature of agreement, as well as provision of Section 8 of the Arbitration Act. So the argument advanced was entirely different. The question was, in view of the existence of an arbitration agreement, whether the Act of 2006 could be invoked or not, at all or not. In that context, not at page 156, paragraph 24, somewhere in the middle portion of that act, of that page, the sentence begins with the words, therefore, once the council itself. Firstly, the court has held that 2000 Act is a special act. I am not troubling you with that.
Yes.
Therefore, once the council itself is acting as an arbitrator in that case, thereafter the council who acts as an arbitrator has no authority and or jurisdiction to entertain the application under Section 8 of the Arbitration Act. That's what the court was holding, of course. So,
yes,
there was no necessity of going into other questions. Section 8 of the Arbitration Act would be applicable in case where any proceedings are pending before the judicial authority. Judicial authority is not defined in the Arbitration Act. However, in the case of SBP versus so-and-so, reported in 2005, 8 SCC 618, it is observed by the Honorable Supreme Court that judicial authority as such is not defined in the Act. It would certainly include the court as defined in Section 2E of the Act, and would also, in our opinion, include other courts, and may even include a special tribunal like the Consumer Forum.
This is a foregone conclusion. I mean, if the council itself acts as an arbitrator,
then
where is the question of Section 8?
But not what is important is judicial authority has been explained to mean also a court.
Definitely.
It's not
mostly a court. What
it was not required to be explained, but not it goes without saying. Not even forum, quasi-judicial authorities, any tribunal whatsoever.
Yes, yes.
So, my lord, in that context, my lord, when your lordship is considering the provisions of Section 8, I request your lordship to read the word bringing an action before a court. Which would also mean an application under Section 9. Otherwise, what could be an action under Section 8 of the Act?
Suit, civil suit.
Any action.
Civil suit.
An action.
Mr. Mujumdar, you are going too far. If this action means the Section 9 also, then the Section 9 court will return the application and say go before an arbitrator.
No,
that's independent.
Not say there are two alike provisions. Not Section 9 is wide.
Section 9, Section 11, Section 36, Section 34. Court acts as a court. So you cannot, that is not akin to, I mean, their Section 8 cannot apply. No. Judicial authority before which an action is brought in a matter, which is, if a party, what will it do? It will refer the parties to arbitration. Section 9 court is approached and it will refer the party. Then if a Section 34 is
no, he is approaching, not he's, of course, not
then Mr. Mujumdar, Section 34 challenge also, court will say no, go before the arbitration again.
Not he goes, no.
That is a ridiculous.
Section 9 and Section 17.
9, 11, 34, 36 are different.
9 and 17, these are the protective measures.
17 is before the arbitrator, yes.
So 9 says if I bring an 9 says if I apply for interim measure, the court may grant or not grant. 8 says if an action is brought in relation to a subject matter, then it has to refer it. Not
then Mr. Mujumdar, Section 9 would not have any applicability.
I don't say Section 8 will not take away the jurisdiction to pass orders under Section 9.
Section 8 is only on that. You have to refer it to the arbitration without going into it. Then if you approach the Section 9 court, Section 9 court will say no. Under Section 8, go to the arbitrator and have the arbitration and go under Section 17.
That's one way of, not for the purpose of interim measure. Section 9 is
trying
Section
to confuse 9. And confusing the way you are confusing. Now, Section 8 cannot apply to Section 9 in any manner of imagination. How can it? I mean, then Section 8 itself is entirely around the concept that if a judicial forum is approached, Judicial forum will say, no, I won't pass any order. Go to the arbitrator.
Correct.
Section 9 court will say that.
Section 9 will grant interim measure or refuse interim measure. That's the only situation.
Different line of
Very well.
perspective, different.
Now, can you take note page 152?
152, yes.
I'm sorry.
No,
Can you take note that 156 I have shown to your lordship?
Yes.
Can you take the Delhi High Court judgment?
Right.
Page 165.
Yes.
Paragraph 9, case of the petition. Petitioner contends that disputes are now liable to be referred to arbitration in terms of clause 25 of the agreement, and this court has territorial jurisdiction to entertain the present petition. It is also contended that as per section 18(3) of the Act, upon the termination of the conciliation proceedings, the dispute could either be taken up by the council itself for arbitration, or they could be referred to any institution or center providing the institutional arbitration services. By virtue of section 80 of the Act of the Arbitration and Conciliation Act, the council would be barred from acting as the arbitral tribunal under section 18(3) of the MSME Act, since it has already acted as the conciliator under section 18(2) of the MSME Act. So that was what argued by the petitioner. Now, in that context, please come to paragraph 13 at page 167.
Yes. I'm there.
A plain reading of section 18 would show that upon receipt of reference under section 18, the council could either itself conduct the conciliation in the matter or seek assistance of any institution or center providing alternate disputes resolution services. It is also expressly provided that section 65 to 81 would apply to such disputes as it applies to the conciliation initiated under part 3 of the A&C Act. It is thus clear that the provisions of section 18 of the Act of MSME incorporate the legislative intent to apply the provisions of 65 to 81 to the conciliation proceeding conducted by the council. Section 18(3) of the MSME Act provides that in the event the conciliation initiated under the Act of MSME Act does not fructify into a settlement, the council can take up the disputes itself for arbitration or refer them to any institution or center providing alternate disputes resolution services for such arbitration.
These
So
are
that's a
foregone
different question
conclusions.
altogether.
Yes, yes. Obviously, why are these questions asked? I don't know. I mean, there is no
Yes,
scope of
there is
asking.
no scope for
Asked
asking.
in Delhi and answered also.
Right.
So you don't repeat the same exercise.
Now,
I mean, council, yes, council acts as the council. If there's a conciliation, it acts as a council. Conciliation fails, arbitrator, council itself can do it or relegate it.
that's only by way of
Acts is so.
that's only by way of reference that the other provisions of the 1996
Yes,
Act have been brought in.
Right, right.
There's no problem with that.
The council is conciliating, the conciliation provisions of Arbitration Act apply,
When
and
it
the
is
other way around.
arbitrating, the provisions.
Yes, right. So that is settled.
That is well settled. Now, my lord, for that purpose, lord, these decisions can't be recognized as authorities for the purpose of addressing the issue at hand.
Only whether they can jump the gap. I mean, conciliation is a prerequisite before arbitration in under this act. Whether they can jump the act before that, they say there is an arbitration on the anvil after this conciliation process, and therefore I invoke section 9. Whether they can do it. If they can do it, then they did not elect. And if they cannot do it, as you argue, then Mr. Mujumdar, there is no scope of.
Now, my lord, please see the language of the Act.
Which?
2006 Act. Please see section 18. In chapter 5, it's a chapter entirely devoted for delayed payments.
Don't go by that.
No, I don't go by that. But it's a chapter devoted, because when their lordships in the Honorable Supreme Court has held that this is a special statute, the taking into view the subject matter of the statute. Please see section 18. Notwithstanding anything contained in any other law for the time being in force, any party to a dispute may, with regard to any amount due under section 17, make a reference to the Micro and Small Enterprises Facilitation Council. On receipt of a reference under subsection 1, the council shall either itself conduct conciliation, shall conduct conciliation.
Yes, yes, definitely.
So, not conciliation is a stage which cannot be
Must.
skipped over.
Absolutely. Mandatory prerequisite under this act. No
So,
doubt on that.
So, not if a party to a dispute approaches a section 9 proceeding, then Lord, he has to foresee that conciliation has failed.
Mr. Mujumdar, let us take a scenario. Let us forget this act for the time being. Now, it's only on there's an arbitration clause. That arbitration clause in some agreements, you have come across many of those in industrial law also. There is a clause that there is a prerequisite that there has to be a prior conciliation effort. If that fails, only then arbitrated. In the clause itself, there can a section 9 application not be filed. If it can be filed there, even if I can go before the court and say, see, there is an arbitration clause, although there is a prerequisite of conciliation proceedings before that, I make an application under section 9 because there is an arbitration clause, give me relief. Those are granted. Section 11 is also filed. Section 11 court generally says, no, exhaust that provision and then come. So these things are there. So section 9 can be invoked in those provisions also. If that be so, prior conciliation, is it a bar? Yes, conciliation by its very nature is consensus between the parties. Settlement between the parties. It's not an insurmountable thing, because the parties know there is a dispute. They want to still go before the council. They may very well say section 9 I am invoking. There is an arbitration clause, therefore I am invoking section 9. Although there is a prerequisite of conciliation, if that fails, I'll go to arbitration.
Now, my lord, if this act has been, please now see the next provision. And the provisions of 65 to 81 of the 96 Act shall apply to such a dispute as if the conciliation was initiated under the part 3. Then the next provision, where the conciliation initiated is not successful and stands terminated without any settlement between the parties, the council shall either itself take up the dispute for arbitration or refer it to any institution or center providing alternate dispute resolution services for such arbitration, and the provisions of the Act of 1996 shall then apply to the dispute as if the arbitration was in pursuance of an arbitration agreement referred to in section 7 of that. It shall then apply. Now, if this act is to be looked as a special statute, then no other interpretation or a wide interpretation can be made into it, can be given to it. If I take recourse to a provision of this act and not a agreement between the parties, not if they are same, not a tender. There are so many tenders which requires this conciliation, settlement, and then different grievance redressal forum. Your lordships quite often entertain repetitions for that purposes, even in those cases. But it's one thing to say that parties have agreed to such a situation which does not debar them from approaching the court of law. It is another thing to say that there is an alternative mechanism provided for in a separate special statute.
Mr. Mujumdar, I'm going one step further. Suppose MSME Act does not come in. This conciliation part 3 is applicable here to the conciliation part, and the rest of the thing, the arbitration. Now, if there is an arbitration clause, suppose I invoke section 9. After that, can I not go? I mean, can I or can I not go into conciliation? Can I not try conciliation? If I can do this under this arbitration act itself, why can't the same thing apply here?
Because
I invoke section 9, get an order, and then go for conciliation. Can I do that?
That's my point. Now, if I have chosen not to approve, I have chosen a different course.
Different as in between conciliation and arbitration.
Yes. And 2 statutes.
Yes.
Then whether I can retract midway and take a different course altogether.
Yes.
Because this act consciously has not provided for an interim measure and consciously has applied only certain provisions of the Act of 1996.
That is absolutely true. Yes.
Now, if Section 18 begins with the non-obstante clause, without giving a protective right to a party approaching the dispute forum to obtain notwithstanding any provision contained elsewhere in the Act, the party can approach Section 9 through the Section 9, or this does not abrogate the provisions under Section 9. Consciously, the legislature in a subsequent statute with a non-obstante clause refers to only certain provisions of the Act of 1996. And this procedural regulation,
yes,
in my most respectful submission, has to be read not only for the purpose of conciliation or arbitration, but also for the purpose of choosing a mode of redressal.
There is something in your favor. If you choose under this to go under this Act, Section 18, Section 3 is very specific.
Very
Where
specific.
the conciliation fails, arbitration begins. Only then the provisions of the arbitration and conciliation in 1996 shall apply, taking that it is a pursuant to an agreement under Section 7. Now, only if there is an agreement under Section 7 can Section 9 be invoked.
Yes.
So that also comes along with this, the other things, only after the conciliation fails. That is one of the arguments.
65 to 71 is a procedural safeguard or say a guideline, but not the Act in its entirety applies only in subsection 3 stage.
Including Section 9.
Including Section 9. Now, when a party chooses to apply for arbitration under Section 9, and that paragraph 47 of the Supreme Court judgment, the Act of 2006 gives a choice to the party.
But it's a penumbra region because Mr. Mujumdar, the moment we say that Section 9 also comes in only after subsection 3, one of the areas of operation of Section 9 goes, that is before arbitration.
Yes.
Because Section 3 comes in, the moment Section 3 comes in, simultaneously it comes in with the arbitration beginning. Now, therefore, the other region of Section 9, before arbitration, we can invoke that goes.
Because this has now been held to be a special statute. Now, there may be other benefits given to a buyer or a party to a dispute under this Act. Now, benefits given under a special statute, if are taken recourse to, then under a general provision, if something is available, I'm stopped from invoking or availing that.
Very good.
Now, as in that Section 9 application.
This is by Smith or this proposition of?
No, just.
Or Sengupta.
Yes, that's a better option. Privy Council. PC. Number two, when the Section 9 application petition is filed, he says that I am doing this in aid of my final relief. And at that stage, have I not chosen my relief? Or I could not have chosen my relief then also. Please see page 99 of the writ petition.
Yes.
Before approaching the council, he said that I have invoked this.
Yes.
In spite of our express intention conveyed to you on 10th October 2022 to resolve the dispute through conciliation or settlement as per section clause 34.3, you have neglected to hold conciliation. Hence, this invocation of clause 34.1 is bad in law. His intention.
When did you approach the MSME Council?
He approached in November.
November 22.
November 22.
I just give the relevant date. He filed the statement on 21st November 2022.
21st November 2022.
Yes.
And not that Rule 8, sub-rule 8 of the West Bengal rules, that specifically confers jurisdiction or power on the council to determine on his own jurisdiction, like Section 16 of the Arbitration Act, before he sends notices. And that is with reference to facts and circumstances of each case. Please read that sub-rule 8 of Rule 4 vis-a-vis that observation of the Honorable Supreme Court in paragraph 47 of the 2023 judgment. It's a choice.
Good.
These are my submission, but I don't think so.
Lord, I'm aware there can't be a reply to a reply. Only one provision I'll be failing otherwise, my lord, in my duty, my lord, to try and assist your lordship.
Only the West Bengal rules are cited for the first time by Mr. Mujumdar.
My lord,
You
I am
can answer
only,
on that.
I am only perhaps, my lord, the submissions made by my learned senior friend can be answered only by, my lord, referring to section 77 of the Arbitration and Conciliation Act. It's a, my lord, conciliation proceeding, resort to arbitral or judicial proceedings. It's section 77, my lord. The parties shall not initiate during the conciliation proceeding any arbitral or judicial proceeding in respect of a dispute that is the subject matter of the conciliation proceeding, except that a party may initiate arbitral or judicial proceedings where, in his opinion, such proceedings are necessary for preserving his rights.
So you say section 9 comes in
Section
here.
9 comes under this. That's the reason.
During the conciliation proceedings.
Yes, during.
During the conciliation proceedings.
And section 9, my lord, is before. So, my lord, in the course of section conciliation, my lord, we could not have approached other than this, but not conciliation was later. Section 9 was before. That's
the point.
That's the distinction, my lord, because here it says until and unless it is very urgent.
But during conciliation, you can go to
You can go in this situation.
This is
and
not
my lord,
during conciliation.
This
You
is
wait
not during
before
conciliation. This is before conciliation. So it's a better case, my lord, because section 9.
Better or not, that is.
That's my submission, my lord. And my lord, I apologize, my lord, because I've put in some flesh with the skeleton. My lord, I should not be doing that from the next time, my lord. Very deeply obliged for the patient here.
Thank you. Arguments are concluded. Judgment is reserved. Any interim order is there? So,
no.
Is there any scope of interim order there?
Lordship is finally hearing this now.
No. Yes. No, I was thinking of passing the order after puja. Some matters have to be retained during the puja.
Oh, then kindly maintain direct status quo to be maintained till.
You have challenged what? I forgot that.
The order by which my objection has been overruled. And
MSME Council is proceeding.
Yes.
The next date has not yet been given. That's my instruction.
No, I'll put in a line. Learned, in view of the judgment being reserved as above, comma, there shall be stay of all further proceedings in the proceedings before the MSME Council between the parties till disposal of the writ petition. Immediately after the vacation,
I'm very deeply obliged.
I'll work during the vacation on this.
But I'm sorry to trouble your lordship for that reason.
No.
Item number 5, OPT Solutions Marketing Private Limited.
You are for the petitioner?
Yes, my
right.
I beg to appear for the respondents. My lord, should I say private or statutory? I do not know, because my lord, there are only private respondents. So my lord, my preliminary point will be, my lord, the point of jurisdiction on the issue of maintainability, my lord.
Yes.
Yes.
Yes means yes bank. I mean,
Yes.
yes bank.
The petitioner number 2.
How does the 226 lie?
Yes. The petitioner number 2 applied for loan for petitioner number 1, my lord. And the bank sanction loan 85 lakhs against the 2 mortgage flat. And second wave of the COVID, my lord, the petitioner, some EMI was dues.
You are challenging willful defaulter.
No, I am not challenging willful defaulter.
That is your first prayer.
That's a prayer, my lord.
No, I am not challenging. I am challenging the bank forcefully try to take the 1 flat, my lord. According to the respondent bank, 1 flat 3I was sold by the petitioner.
This is under section 13(4).
No, 34 no. Sold without consent of the bank.
Not under the surface
which was mortgage by the petitioner. Lordship, thereafter, the bank sent a notice, recall notice, my lord. Recall notice. Kindly come.
What are you challenging? First, tell me that.
I am challenging the notice. Possession notice, my lord.
You have to go under section 17 before the tribunal.
No, bank has already filed the case before the tribunal.
You have to challenge before the tribunal, sir.
No, my lord.
What no?
My bank has already challenged. Bank has already filed a case. I will appear.
Not a question of. May I assist your lordship in a nutshell? Lord, we had
No,
filed.
Lordship, kindly come annexure P6, my lord. This
You
is
got a
the
copy of the SABYASACHI Act.
yes.
You got a copy. Please read out section 17 first. This is not maintainable. I reject it on the ground of maintainability itself.
I am not coming to the challenging the willful defaulter notice, and also I am not challenging the bank filed a case before the debt recovery tribunal. I am challenging the bank is every month taking the EMI every month, and thereafter, after filing the case, my lord, before the debt recovery tribunal, Lordship, kindly come annexure P7.
There are two reliefs here, sir. Please come to your reliefs first. You are giving a wrong impression to the court. Please come to the reliefs at page 12. You are saying you are not challenging two things. Let us see, those are the first challenges. Please come to your relief and read out the reliefs. Page 12.
No, my lord.
No, please come to the reliefs and read out those reliefs.
Page, my lord.
Page
Your
12,
reliefs,
page
you know, page 12. Please read out the reliefs in the microphone so that everybody can hear you.
Yes. Nature of amendments to do issue commanding the respondent, particularly the respondent number 3, to cancel the willful defaulter notice dated.
So you are saying you are not challenging that. So I'm scoring this. I'll record that you are not pressing this challenge. You say you are not challenging willful
Lordship,
defaulter.
kindly give me 2 minutes time to
first answer me, then I'll give you 10 minutes time if necessary. Plus, please answer my question first. This writ petition is maintainable or not? I'll have to assess.
Yes, I am challenging this one.
You are challenging willful defaulter notice.
Defaulter notice and also possession notice.
Please come to B now. Read it out. The possession notice is a relief, is a measure taken by the bank under section 13(4) of the SABYASACHI Act.
Yes.
If you
But
challenge
after,
that,
after filing the bank before the debt recovery tribunal,
what
then
is
he
the
has
difference
given
after
the
filing
notice.
the bank? What is the difference under the law? Even if the bank did not file it or filed it, you have an independent remedy to go before the tribunal under a separate section 17, not the bank's suit.
Yes.
If a bank files a suit against you, you cannot file a suit against the bank.
Yes.
Then you have got an equally efficacious alternative remedy. Why should the 226 court interfere in your writ petition?
My prayer is that, my lord, after filing the debt recovery tribunal, the bank cannot come to the petitioner's house and forcefully try to oust the petitioner.
Why not?
Forcefully. The bank will, my lord, the bank will.
Section 14 must have been.
Parallel proceeding bank will be started.
Yes. Why not?
I cannot start.
Show me the bar.
Parallel proceeding. Because.
Show me the bar.
Bar I did not bring today, my lord. Kindly give me time.
Next matter, call.
Lordship,
Learned counsel for the petitioner is not prepared with the statute on which he relies on. Accordingly, let the matter stand adjourned for the day. Next matter.
Item number 6.
Yes.
Please, Your Lordship. My Lord, I am appearing for the petitioner. My Lord, this is against, my Lord, the internal complaint committee. It's a sad case, my Lord. May I only indicate? Yes, I'll start. My Lord, the petitioner before Your Lordship had filed a complaint before the, my Lord, internal complaints committee. I'll, my Lord, use the abbreviation ICC. My Lord, my first point.
Which authority?
This is, my Lord, the Navy. My Lord, the Coast Guard region, Northeast region, my Lord, of the Coast Guard.
Yes.
Northeast, no. This is Haldia, no?
It's any.
So it's
Not, yes, I stand corrected.
Yes.
Northeast.
It's my Lord, the region is any. So, my Lord,
Because actually the case, the matter is pertaining to that Haldia port and that area.
it's
Northeast maybe.
under the Coast Guard region of any. My Lord.
Yes.
My Lord, a complaint was made. We took a point right from the very beginning that the ICC was not constituted properly. We made requests while the ICC proceedings were going on that the procedure was not being followed because there were several letters by which, my lord, the petitioner was required to immediately give replies to other proceedings which were initiated against the petitioner. The contention of the petitioner.
Will require the Sexual Harassment Act for this?
Yes, my lord.
একটা আনিয়ে রাখতে হবে। ওই sexual harassment at
But I'll
workplace.
try and, my lord, keep it very brief because, my lord, the first fact-finding authority, the ICC, my lord, held against me, the petitioner. We preferred an appeal. But the appellate order is before your lordship under
You are the
challenge.
complainant or the accused?
The complainant, my lord. The appellate order is, my lord, under challenge. I'll, my lord, refer to only the appellate order and I'll indicate the findings of fact which we say must be, my lord, much more findings of fact, but the findings of fact which have been rendered by the appellate authority, from there the conclusion drawn is absolutely erroneous. Finding that yes, he made a mistake, he did this, and the findings rendered, that's, my lord, the findings of fact.
So mistake and deliberate with motive are different things.
Where it is indicated that yes, he did this. My submission would be that it is covered under section 2N of the act itself. After that, my lord, remark, the finding is that remark was not repeated thereafter. And hence, my lord, nothing wrong happened.
My lord, but I'm to cut the story. I'm not interacting. My lord, there is no scope of interim order because such prayer, the interim order prayers which have
This is short matter, Mr. Trivedi.
my lord, affidavit needs to be used because there's an appellate, they are challenging appellate court's order.
Right.
Now, my lord, so a chance should be given, and the order was passed in 2022. And she has resigned from the post. She has on her own accord resigned from the post in 2021. So she is not also wanting reinstatement.
It's not reinstatement. I'll Lord, submit my prayers.
So why not direct affidavits? What is the?
Then let us come. We will take a very comprehensive.
No, because if there is no scope of interim order,
there's no scope for interim order. My lord, the only submission, my lord, since whether an affidavit would be required, is only this, my lord. My prayer before your lordship is for setting aside of the order in appeal and to remand back the matter, my lord, before a fresh ICC.
Mr. Trivedi, let us come back on Monday. We'll consider
lord, whatever falls from my lord, because I being my lord,
if it can be done ex facie, then we'll not require affidavits. I'll give my
lord, my lord, an affidavit is always required, my lord, because this is on appeal order. They are challenging, my lord.
Most of the cases not required, Mr.
That's why, my lord, I'll not go to the
facts. This is the case
the allegations and new allegations, Mr. Trivedi, definitely.
My lord, I'll never join issue, my lord. Whatever falls, my lord, will come.
Affidavit cannot be used as an excuse to stall the.
I'm the last person to do that. I just wanted to point out before my lord that there's no scope of any interim order.
We'll get the weekend, Mr. Trivedi. Prepare yourself. Come back on Monday. Let us see if we can decide. We will decide. Otherwise, I'll direct affidavits definitely.
My lord, before the pujas, going to burning the midnight oil, my lord, and then my lord,
midnight oil, weekend oil.
Very deeply obliged, my lord.
I'm grateful, my lord. My lord.